The Senate Committee on State Affairs will come to order, please. Clerk, call the roll.
Birdwell. Creighton. Fallon. Paul. Lucio. Nelson. Zaffarini. Hughes. Huffman.
Here. Quorum is present. Members, we have quite a bit of business to take care of today. I think the cars a lot. Okay, we're going to start. Senator Creighton, would you like to begin this morning? Are you good with that? All right. I'll recognize you on Senate Bill 13. Lucky number.
That's right. Thank you, Madam Chair and members. Senate Bill 13 is an omnibus ethics reform bill which proposes 3 ethics reforms designed to ensure that elected officials are representing their constituencies, not special interests or their own financial interests. The first of these reforms amends the election code such that in order to be eligible to be a candidate for or elected or appointed to a public office in this state, a person must not be required to register as a lobbyist under Chapter 305 of the Government Code. The logic for this reform is simple. The Texans expect their elected officials to represent their interests. If you're required to register as a lobbyist, that means that you're being paid to represent other interests, so anyone who decides to run for public office should be required to unregister. The second reform in this package requires that the Texas Ethics Commission make personal financial statements available to the public on its internet website not later than the second business day after the statement is filed. This will ensure that all Texans and all members of our free and independent press have the opportunity to look for financial conflicts of interest and hold their elected officials accountable. The third and final reform prohibits former members of the legislature from registering as a lobbyist until the end of the legislative cycle following their last session as a member of the legislature. The state of Texas is one of 9 states with no restrictions on the practice of legislators leaving public office and heading immediately into the lobby. The time has come for the state of Texas to enact these common sense ethics reforms so that Texans can be confident that their elected officials are representing their interests and not of those of anyone else. With that, Madam Chair, I appreciate the opportunity to present the legislation, and I know we have some witnesses available.
All right, do we have any questions of Senator Creighton? Okay, we'll open public testimony on SB 13. Call up Toto Key. I think that's it. Sorry, this is just registering a position for. And Crystal Maine, registering a position in support. Is it anybody else who wants to testify on for or against? All right, we'll close public testimony, leave that pending. Senator Creighton, you're recognized on Senate Bill 710. 710.
That's right. Thank you, Madam Chair. Members, I'd like to send up to the committee a substitute for consideration. Offering a committee substitute.
Senator Creighton sends up the committee sub to Senate Bill 710. Any objections? It's adopted. Go ahead.
Thank you, Madam Chair. On this today in Montgomery County, our flag flies at half-mast in honor of J.D. Lambright, our beloved county attorney. He's a great father and friend, and certainly someone that stood out among all elected officials in our area. One of my favorites. As the chief legal advisor for Montgomery County, Lambright led his office with unquestionable integrity, pride, and duty. It's in honor of J.D.'s integrity that I present before you today Senate Bill 710, or the J.D. Lambright Local Government Ethics Reform Act. Currently, only certain counties in Texas may authorize its ethics board to impose effective penalties against those who violate ethics standards. This leaves most counties unable to impose a civil penalty when an elected official, lobbyist, or vendor violates ethics standards. The J.D. Lambright Local Government Ethics Reform Act amends current law to remove restrictions on which counties may impose penalties and allows all counties in Texas to choose whether or not to create a county ethics commission which may adopt and enforce ethics standards. This bill is permissive, and it's an honor to be able to lay this bill out before you on the day of Mr. Lambright's funeral. It's my hope that this bill will serve as a testament to J.D. Lambright's commitment to justice and ethics at the county level and across the state. And thank you, Madam Chair and members.
Thank you. Senator Nelson, you have a question? No? You're very nice. You're very nice. Any other questions of Senator Creighton? No? All right, we'll open public testimony on Senate Bill 710, and we'll call up Eric Yalick.
Do I start? Okay.
Mr. Yalick, go ahead.
Madam Chair and Senators, my name is Eric Yalick. I'm from Montgomery County. Thank you, Senator Creighton. It's good to see you this morning. I'm just here as a private citizen. As Senator Creighton said, this morning we are celebrating the life of J.D. Lambright, our fallen hero, who was the county attorney in Montgomery County. And he really personified ethics in government. Senator Creighton has named this bill after him, and I want to thank Senator Creighton for doing that. J.D. Lambright drafted a code of ethics in early 2017, which our Commissioners Court adopted, but the problem with it was that it was completely unenforceable. There is no enforcement mechanism in any county in Texas other than El Paso County. There was nothing more that J.D. Lambright wanted than to have an enforceable Montgomery County Code of Ethics. SB 710 is critical legislation because it would give counties that precise tool. Currently, the only tool that counties have to enforce ethics is criminal laws, and that goes way too far. Public integrity prosecutions are rare, as they should be. Our experience in Montgomery County has been that there has never been an ethics complaint, even when people knew there were ethics violations, because everyone knows that it's a waste of time. We've had problems with nepotism, major issues with conflicts of interest, major issues with misuse of government property by county officials, secrecy problems. Of course, Montgomery County is known for killing the Texas Open Meetings Act, and problems with respect to gifts that went to public officials. For that reason, I ask that you give counties the tools that they are starving for and the quest that J.D. Lambright personified. Thank you, Madam Chair. Thank you, Senator Creighton, and thank you, committee members.
Thank you for being here. Any questions?
Madam Chair.
Senator Creighton?
Yes, Eric, I wanted to say thank you for, making it over to Austin. I know it's a really big deal to miss JD's service. That's, just in a few minutes it'll begin. But that just shows how important this legislation is to you, and it certainly is to me. And I know many of our constituents back home would be very pleased to not only have this named after JD in honor of all of his hard work, but to get this policy in place so that we can have sort of renewed spirit of confidence by the public on behalf of local government. So thank you very much for making the journey over and always for your advocacy.
That's the question.
Senator, thank you. And I received a text message this morning in my hotel in Austin from Belinda Lambright, who is JD's widow, and she wanted me to specifically thank you and also thank Senator Huffman for holding this committee and letting us go first.
Great. Thank you very much. Thank you, Madam Chair.
Thank you for being here, and thank you, Senator Creighton, for bringing such an important bill with such
Madam Chair. Thank you,
and bringing our attention to your hero. Thank you. Okay, we're going to close. Well, let me say there's a couple of cards registering positions. One's against Alex Tatum from Travis County Commissioners Court, and for Crystal Main representing themselves. Anyone else want to testify on, for, or against SB 710? Okay, we'll close public testimony and leave that pending. Okay, Senator Creighton, I understand you're laying out SB 30 for Senator Birdwell. Remember, Senator Birdwell had to attend a funeral today, so He will not be here for that, because of that reason. You're recognized on Senator Birdwell, Senate Bill 30.
Thank you, Madam Chair and members. Senate Bill 30's bond transparency seeks to ensure that bond elections are conducted in a manner that gives voters more choices in the authorization of bonds while giving them more information regarding the subsequent tax increases, if any. Statute currently requires bond proposals to describe the general purpose and allows for multiple distinct purposes to be consolidated into one proposition. For example, just last November, taxpayers in an area south of Houston were asked to vote on a single proposition ballot that was almost $1 billion in total. Even though the money from the bond was for at least 6 specific purposes, the taxpayers were only able to accept or deny the bond package in its entirety. This left voters with an all or nothing choice. In contrast, the City of Austin held a bond election in November that totaled $925 million, with 11 separate ballot items that gave voters the ability to decide individually which propositions they deemed worthy of authorizing debt. Senate Bill 30 amends Chapter 52 of the Elections Code by requiring taxing entities to list out each specific purpose for which bonds are being approved as separate propositions on the ballot. For example, in a bond proposition for a school district, construction of schools would be one specific purpose, so those items could be grouped together under the same proposition. The ballot must also list the rate of any tax that will either be increased or imposed should the proposition pass. The goal of Senate Bill 30 is to ensure that the voters have the greatest amount of choice when they're faced with authorizing debt. Political subdivisions that give an all or nothing proposition deny voters the ability to choose which specific investments to support and can also leave taxpayers with uncertainty regarding subsequent fiscal implications. Members, as Senator Birdwell is unfortunately not able to be here today due to a loss in his family, he'll still be continuing to work with stakeholders in the AG's office to ensure the applicability of this bill aligns with the intent. Thank you, Madam Chair and members.
Thank you, Senator Creighton. Any questions? Okay, we'll open public testimony on Senate Bill 30, and we'll call up Amanda Brownson, maybe, James Quintero, Michael Openshaw, Daron Robinson, and Rick Briscoe. And then next, you can wait in the back, will be Crystal Main and Alan Vera. Okay, Ms. Brownson.
My name is Amanda Brownson. I'm here representing the Texas Association of School Business Officials. We've reached out to the Senator's office. We're currently on the bill. Our concern was that the single specific purposes may be defined so narrowly that we would have overly long ballots. My understanding is this is not his intent, and so we're hopeful that we can work towards a compromise that would provide the information the Senator is seeking, but not create unintended problems.
All right, thank you very much. James Quintero.
Madam Chair, members, James Quintero, Texas Public Policy Foundation, here to testify in support of SB 30. From our vantage point, I think the current system does not serve taxpayers well. And as evidence, I would point to an old but poignant 2014 story from the Austin American-Statesman, where a reporter interviews a young lady by the name of Gretchen Gardner. And Gretchen is at a town hall tax protest talking to the reporter, and this is what she says about debt. She says, "I have voted for every park, every library, all the school improvements, for light rail, for anything that will make this city better. But now I cannot afford to live here anymore." I don't think Gretchen is unique. I think Gretchen, there are probably a few Gretchens out there that are underserved by the current system that does not afford voters enough information when they go to say yes or no on bond propositions. And so I think SB 30 would make the system better. Additionally, I want to point to Cypress Fairbanks ISD, my hometown high school, who is moving forward with a $1.76 billion bond proposition in May 2019. In your handouts, you have the language that will be in front of voters in May, and as you'll see, it's a single item bond proposition. Again, that's $1.76 billion that voters are going to have to say yes or no to in a take it or leave it approach. On the third sheet, you'll note that this is not the only time that Cy-Fair has done this. In May 2014, they moved ahead with a $1.2 billion bond referendum on a single item bond proposition. So again, I think SB 30 would go far to really improve the situation in terms of giving voters more information and more choice.
Hey, thank you. And yes, Senator Creighton, you're recognized.
I just wanted to clarify, what school district is that?
Cypress Fairbanks ISD.
Cypress Fairbanks ISD. And the previous bond proposal was for what amount?
Yes, so the May 2014 initiative was a $1.2 billion single item bond proposition. They're going to increase that amount this coming May to $1.76 billion.
So 1.2 billion in 14 and now in 19, 5 years later, is 1.7?
Yes, sir.
1.7 billion. And then what percentage, do you know offhand, by what percentage the May of 14 bond initiative passed by?
I don't have that information, but I will get it to you.
Yeah, I appreciate your testimony. Those are unbelievable numbers, that close together, and to be that large of bond packages respectively. 1.7 and 1.2 in 5 years.
And the unfortunate part, Senator, is that this is not an isolated incident. Instances like this are happening all across Texas. Perhaps not to that degree, but certainly at an alarming amount.
Thank you, Madam Chair.
Madam Chair?
Yes. Does anyone have questions? Senator Fallon, yes, sorry.
Thank you, Madam Chair. Where is this school district?
Cy-Fair ISD is just north of Houston.
Okay. In the suburbs?
Yes, sir.
Okay. And I don't know if you're aware, but in 2014, those bonds that were approved, have they all been sold? Or are there some?
I'm not familiar, but I will get that information to you.
Thank you, Madam Chair.
All right, thank you. Any other questions? Okay, Michael Openshaw.
My name is Michael Openshaw. I'm representing myself, and I am here for the bill. And I now know one school district I will never move into. Anyway, we do need better separation, as has been stated in bond proposals. I understand that they don't want to divide it up into like 105 different proposals, but logical units. It would be nice if something was based on a physical address. If you're going to build a building, that should be a separate bond issue from other locations, simply from a standpoint of that's probably the most reasonable division you can work on. Now, if you're doing like roofing on all the buildings, that can be a single item. But otherwise, we do need better separation than we've had for the voters. They pool these together so they can pass giant bonds like this, because there's a little pony in there for everybody, and if you can't vote against it, otherwise you'll lose your little piece. So we need to stop that, because we are indebting the taxpayers, the local taxpayers, to an extraordinary amount every time they put on things that people would vote against but can't vote against the rest. Our debt just has become unmanageable. I'm a taxpayer. I'm trying to survive in the home that I have through retirement. I'm not sure I'm going to be able to. Bonded indebtedness is a big piece of that. So certainly hope that this passes through and gets approval from both houses. Thank you.
All right, thank you, sir. Senator Fallon.
Thank you. Mr. Openshaw, you vote quite a bit, I'm guessing.
Oh, yeah.
Yeah. You don't probably miss an election.
I don't miss many elections.
All right. Do you recall like voting in city elections where there is a bond proposal? in the past?
Yes.
And do they specifically identify each category in which
They break it into large categories, something for like parks, something for,
like roads, for instance?
yeah, roads
police,
and all
fire,
this. They'll break it into units like that, yes, to some degree.
even an arts hall?
Yes, oh, even an arts hall, yes. Well, that was actually, the arts hall was actually done by the ISD and was part of a larger bond package.
So if a municipality can do this and thrive in
Yeah.
a growing state, you think that school?
Oh, yeah, most definitely. Again, a division by physical address, if you're going to build a school, if you're going to build a water park, okay, those need to be separate items.
Because a lot of voters may say, yeah, absolutely, I want this school. Hey, I want this technology upgrade. I want more school buses, but maybe not the water park.
Yeah. Also, it'd be good to address the fact that sometimes they put things on bond packages and they bond things out long past the life of the items. Technology upgrades is an example. You'll have people bond this out maybe for 20 years. We've actually had a case there in Collin County of people putting band uniforms were purchased based on bond money. Now, contemplate indebting people for band uniforms and how insane that is. So it's very important that bonding be done and respect the life of whatever you're bonding for. So if you're doing a technology upgrade of computers and stuff, these should not be 20-year bonds. These should be 5-8-year bonds at the most, because technology fades and then you're stuck with the bills.
Thank you, Madam Chair. Thanks, Mike.
Okay, thank you. Let's see. Who did I skip? Rick Briscoe.
Thank you, Madam Chair, members. I am Rick Briscoe. I'm testifying in my capacity as a private citizen. We need a lot more honesty in bond issues. This will, at least in part, provide more fully informed voters, somewhat more truth in advertising, and hopefully an impact statement on what these bond issues actually will cost the residents. Unfortunately, the practice is all too common where bond issues are passed promising the earth, moon, and the stars, and they never get built. Then they come back with another bond issue promising the same things, and the money's diverted. We need to tie these bonding agencies down to actually perform the specific purposes to which they submit to the voters and the taxpayers. Additionally, I'll simply say that the language needs to be intelligible to an average voter. The practice, at least where I live, is that no reasonable person can begin to understand what the real issue is. And as such, the vote is essentially for improving our city, and bonded indebtedness continues to climb. Bonded indebtedness in Texas is out of control. It's on a par with that of bankrupt cities such as Detroit. Fortunately, our economy is strong at the present time. Should we ever have a hiccup, there could be problems. Thank you.
Any questions? Okay, I think I can't see you, but Mr. Robinson, you're next. I thought I skipped you, but I just couldn't see you. Go ahead.
All right. That's all right. Good morning, Madam Chairman. Thank you for allowing me to speak today. My name is Darren Robinson. I'm General Counsel for Allen ISD. I represent Allen ISD, Texas Association of School Administrators, and the Texas Association of Community Schools. Testifying today on the bill. Want to say first that we are absolutely in favor of transparency. We spend a lot of time and effort trying to be transparent. I do appreciate the fact that Senator Birdwell is working with stakeholders to work towards some middle ground or some perhaps realistic ideas. So, for example, one of the issues with doing site-based bonds would be if you separated out building a new school for a fast-growing school versus the purchase of that property. You obviously have to have those two things go hand in hand. Conversely, if we separate school versus school, we have the issue of theoretically backing ourselves into a disparate impact of minority situation where, for example, in Allen ISD we have schools that have very high level of low socioeconomic students, and we have schools with a very low level of low socioeconomic students. And of course, the voter turnout for the schools with the high socioeconomics tend to be higher than those with the low socioeconomic. And we want to make sure that we're providing equity across the district to all of our students, regardless of what their socioeconomic level would be. So we would just ask that as we continue working through this, that we work towards a good compromise to make some realistic choices with moving forward to provide transparency to our constituents.
All right, any questions? Okay, thank you very much to this panel. And we'll call up the last two, Crystal Main and Alan Vera. Crystal, Ms. Main, you're recognized.
My name is Crystal Main, and I am here for the bill. I'm here in favor of the bill, and I'm representing only myself. And I'm going to echo a lot of what Mike Openshaw just said. As far as the line items, they need to be divided out. I need to be able to, there are things that I would support that are being tied in with things that I wouldn't support. Upgrading technology, paying for band uniforms, those types of things should be separate items. It should all be divided out so I can choose which things I would support instead of having everything all grouped together.
Okay, thank you. Any questions? All right, Mr. Vera.
Alan Vera, Chairman, Harris County Republican Party Ballot Security Committee, testifying in support of SB 30. I'm a Vietnam vet, but even worse, I'm a veteran of the Cy-Fair ISD 2014 bond election. The bond was pitched to the people as being for needed infrastructure, that is, school buildings to accommodate the growing population. But if you did what I did and did open records requests for the minutes of the bond steering committee, as well as their documents, you found a lot of interesting stuff in there. There was money for the pet project of nearly every single principal, the superintendent, the members of the board, and you also found money to reward the private sector vendors whose political action committee continually supported the re-election of the incumbent board members. There was more money on the nice-to-know propositions than there was for the actual infrastructure. If you dared to speak out against the bond, you were against the children. Voters did not have a right to selectively vote each of the major issues of the bond money. It was a take-it-or-leave-it proposition, just like many congressional bills. We believe taxpayers in Texas deserve the right and respect to be able to clearly understand the bond language and to execute a line-item vote on how their tax dollars will be spent. This bill takes us a good way in the right direction. We urge you to pass it out of committee.
All right, any questions, Mr. Vera? All right, thank you very much for being here, Alan. Appreciate it. All right, is there anyone else who wants to testify on, which bill is this? On for or against Senate Bill 30? Okay, we'll close public testimony and leave that bill pending. Okay. Senator Zaffarini, your witness is here, so let's recognize you on Senate Bill 346.
Thank you, Madam Chair. Madam Chair and members, Senate Bill 346 relates to the consolidation and allocation of state criminal court costs, increasing the amount of certain court costs and reducing the amount of certain other costs. This issue has been addressed by the legislature during the 2013, 2015, and 2017 sessions. During the last interim, this committee was charged with examining the structure of court costs and fees. The committee recommended in its interim report that the legislature take action to reduce the number of criminal court costs to simplify the system. Senator Huffman asked me to work with OCA to that end, and Senator Huffman, I appreciate the opportunity. Currently, state law includes 143 distinct criminal court costs in 17 different categories. Accordingly, the criminal court cost system in Texas is difficult for county and district clerks to administer and for the state to audit for compliance. The committee's interim report also recommended the legislature work to ensure that court costs are constitutional. In 2017, the Texas Court of Criminal Appeals ruled that criminal court costs used to fund a non-criminal justice purpose are unconstitutional. While the 2017 ruling affected only 2 criminal court costs, in its wake, appellate courts across the state have invalidated numerous others. The legislature not only has a duty to ensure the state's laws are constitutional, but also must address preemptively any cause that could be invalidated to prevent potential budgetary problems that could create for the state and local governments. Senate Bill 346 would consolidate numerous court costs to make the system more streamlined and efficient. It also would make changes to protect vital programs that are funded currently by court costs that could be found unconstitutional in the future. Generally then, Senate Bill 346 would first eliminate some criminal court costs and consolidate others. Members, because it was filed as a shell bill that was developed in the committee substitute, the committee substitute is very different. In fact, it grew from 21 pages in the Senate bill to 113 pages in the committee substitute. We requested the committee substitute in January and received it yesterday, and for that reason, I'm asking the committee chair to please leave it pending after our committee substitute and testimony. Madam Chair, I'd like to send up the committee substitute at this time.
Senator Zaffarini sends up the committee substitute.
Thank you, Madam Chair. Generally, the committee substitute differs from Senate Bill 41 as filed originally, and actually in Senate Bill 346 as filed originally, in that it would restructure the entire criminal court cost system in a manner that is constitutional, more efficient, and to the greatest extent possible, revenue neutral, by establishing state consolidated criminal court costs based on the level of offense in a given case, including $60 for a Class C misdemeanor, $147 for a Class A or Class B misdemeanor, and $185 for a felony. By creating local consolidated criminal court costs by level of offense, including $17 for a Class C misdemeanor, $140 for a Class A or Class B misdemeanor, and $122 for a felony. By converting court costs used to fund non-criminal justice purposes to mandatory fines. By charging reimbursement fees for particular services rendered in a given case, such as a DNA test, rather than funding the provision of these services by assessing court costs in all cases, and by repealing 16 court costs that are either archaic or do not serve a legitimate criminal justice purpose and cannot be reclassified as a fine or reimbursement. Madam Chair, we have an excellent resource witness, and I would appreciate your calling David Slayton at this time. And I'd like to thank him and the OCA staff for excellent work in developing not only the bill, but the committee substitute.
Thank you, Senator Zaffarini. Yes, we will call David Slayton up. And Senator Zaffarini, I'd like to publicly thank you and your staff for all the hard work that was put into this bill. Members, until you sat down and worked on something this large, and I knew Senator Zaffarini was up to the task when in the interim hearing we realized it was going to be quite a job. And I appreciate you taking the time and your staff, and I thank my staff too, who I know worked closely with you and with OCA.
And I was about to say thank you and your staff, the committee staff, for being involved every step of the way.
Right. And members, just kind of bear with us on this explanation. I know when we dive into something new like this, it can be frightening to folks, but I'm sure David's going to do a great job of explaining it. This was something that needed to have been tackled for a long time. We've heard it over the years since I've been here, and so this is an attempt. And as Senator Zaffarini said, we're going to leave it pending for a few days at least, to make sure everybody sinks in with everyone and the stakeholders have a chance to look at it carefully. But I'm confident we have a good structure in place here, and so. Mr. Slayton.
Thank you, Madam Chair, members.
Explain it.
My name is David Slayton, and I am the Administrative Director of the Office of Court Administration. In one of its first acts, the first Texas Congress adopted a criminal court cost structure, and since then, the court cost structure has become more and more complicated all these years later. 2 times in the past, in 1997 and 2003, the legislature attempted to consolidate the criminal court costs to try to simplify the structure. However, now there are 147 separate criminal court costs, which, if you look at the table, you would see are very complicated. I know those of you that were here for the interim, I got a copy of that. As your interim committee found, the criminal court cost structure is 1, difficult to administer due to its complexity, and 2, is being ruled unconstitutional 1 cost at a time, where the costs are not allocated for a criminal justice purpose. The interim committee asked OCA to work with Senator Zaffarini to develop a proposal to simplify the court cost structure, remedy the constitutional issues with the cost, and attempt to do so without negatively impacting revenue to the state or local governments. The committee substitute to Senate Bill 346 attempts to do just that as follows. We have segregated currently identified court costs into 3 categories. 1, court costs that are meant to recoup the cost of court. 2, fines which are meant to punish. And 3, reimbursement fees that are meant to recover costs that are outside of the typical court cost. Second, we have consolidated the true court costs, those that are identified as court costs, into a state consolidated court cost and a local consolidated court cost for each level of court. We've done so in a way that is meant to be revenue neutral where possible. The only exception to that is where current court costs that did not really fit into these categories, and for which the costs were not being directed to a legitimate criminal justice purpose. In those cases, we've recommended repeal of those costs. And some of the costs, rather than recommend repeal, we've recommended redirection, and the committee substitute does this, and dedication to a criminal justice purpose based upon the legislative intent of the cost. At Senator Zaffirini and Senator Huffman's request, we've attempted to visit with a wide group of stakeholders to get their feedback and have made adjustments to address their concerns along the way. I'm sure there will be additional concerns and things with the committee substitute, and I'm happy to work with Senator Zaffirini and those stakeholders to try to address those where possible. What results is a much simplified structure with 1 state criminal court cost dedicated to the various funds that support a legitimate criminal justice purpose, and 1 local criminal court cost dedicated to a similar purpose. Remember, we have 147 now. We're moving to 1 criminal court cost at the state level and 1 at the local court level. A set of mandatory fines would be created that the legislature has previously imposed as court cost. And lastly, a set of reimbursement fees that the legislature has previously imposed as court cost would be created. The materials that you have show the proposal in detail, showing you which ones meet each of those categories, and you also have a breakdown attached to the back of the anticipated impact of the changes on the revenue, which you will see is meant to be 0 impact on the revenue. Obviously, there's a lot of work to still be done on this, and I'm happy to answer any questions you may have about the bill or the substitute.
I have a question, David, about the fiscal note. So we're hoping that there will be no impact to at the end, because right now, the original bill, of course, the fiscal note was huge, but that was a shell bill, so.
Right.
But are we hoping that we even this out?
Yeah, the intent, so as you see in the filed version, the fiscal note shows a positive impact on revenue, but overall, a positive impact on revenue, but some of the funds show a decrease.
Right.
That would be caused by the percentage allocation being off. So adjustment of those would have corrected that. In the committee substitute, what we'll it's sort of like school finance. We'll do the runs to show what the impact would be to every fund that's coming in, and then work with Senator Zaffarini's office to make adjustments where necessary so that those funds are not negatively impacted.
Okay.
We're also going to work really closely with the comptroller's office on this, because obviously they're the ones who ultimately provided this fiscal note and showed the impact. Our numbers were a little bit different than theirs, didn't show quite the same impact, so we'll work with them to make sure those issues are addressed before the bill comes back to you.
And I'm going to repeat that one more time for stakeholders who are listening. It is not the intent to decrease the amount of money that, say, for example, Crime Stopper's getting or anybody. If your percentages look lower, that's because of the amount of revenue that we think is coming in. But we're going to double check all those numbers, do the runs, as you called it, and make sure that we're keeping everybody neutral.
Right.
Is that correct?
The intent, obviously, is to take, so for instance, there's a $2 court cost out there that's separate right now. If it's a legitimate court cost, the intent was just to bring it in and bring that revenue with it and dedicate it to that purpose. So there should not, at the end of the day, be a negative impact to these funds, and so we'll continue to work on that. Obviously, we haven't done that with the committee substitute yet, but we'll do that, work with the Comptroller's Office and LBB, and make sure all of them are addressed in an appropriate way.
And then 2 other questions. Are we creating any new fees with Senator Zaffarini's bill?
No, you are not.
Repeat that, please.
Yes,
we are not creating any new fees.
You are not. In fact, there are a few that you're getting rid of, but for the most part, you're just moving them from separate court cost into one, consolidating them down into one. But I'll repeat it one more time. This bill does not create any new court cost fines or reimbursement fees.
And does this bill address some of the constitutionality concerns that have been out there about some of the fees that were in existence?
We believe that we've looked pretty closely at each and every single court cost, what will be every court cost that will be in here, and we have remedied those. What we believe is we've remedied those constitutional issues to make sure that the court costs that are being collected for a legitimate criminal justice purpose. As you'll remember very clearly, Senator Huffman, last session, the Salinas case that struck down a portion of the consolidated court costs knocked a $17 million hole in the budget. And our goal here is to make sure that those things don't happen to where individuals and entities that are relying upon this funding are left without because of the fact that it's unconstitutional. If we do it in the way that the committee substitute does, we don't think that that would be an issue going forward.
All right, thank you. Senator Zaffarini.
Thank you, Madam Chair, and thank you and Senator Hossa for being co-authors of this bill. We certainly appreciate that. Mr. Slayton, I believe that people who are interested in this subject in this particular bill, in many cases will be interested about a particular court cost or a particular fine or fee. Is there a way that such a person could just go directly to that fine or fee or cost and see exactly what's happening to it?
So right now, obviously, with the filed version, there's a rundown in the fiscal note that has that. But what we will do is we'll be working in the next couple of days to try to do those runs for every single court cost and now fine and fee to show the impact. And so we're happy to work with any interested party who has an interest in any particular court cost, fine, or fee to make sure they understand what the impact would be. Like I said, we'll be working with the Comptroller and LBB to make sure our numbers sync up so that if someone is interested in knowing what's happening, they'll have what we believe is the best numbers on that issue.
Where do we expect additional pushback to the committee substitute?
I'm not aware of any particular place where there would be pushback. I mean, obviously, the biggest concern I think most people have is making sure that the funds that they're interested in aren't being negatively impacted. And as you know, the intent of the committee and your intent that you expressed to me and Senator Huffman's expressed intent was to not negatively impact revenue. So that's the one thing. I would point out that there are a few of these court costs that are listed in the repeal section of the proposal, and they'll be in the repealers, although it will be harder to tell which ones they are, so I'm happy to share this document with anyone who's interested, that some people may be interested in. One in particular that I think there's some interest in addressing is the time payment fee. This is a fee, a court cost that's currently assessed when someone doesn't pay their court costs in full within 30 days. Half that money stays, it's $25, half of it stays local, half of it goes to the state. It goes to general revenue in both instances. There's potentially problems with that. In fact, a court just a couple of weeks ago ruled that unconstitutional. And so we had recommended repeal of that originally. I know there's some interest from some groups in maintaining that and then dedicating it towards a purpose that's legitimate. So there may be some of those things that come up, and certainly, we're happy to work with them and work with your office and anybody else who's interested in trying to address those issues. At the end of the day, the goal is to make sure that these court costs and fees are actually constitutional.
Okay, thank you. Thank you, Madam Chair.
Thank you. All right. Thank you, David.
Thank you very much.
Appreciate it. All right, we're going to call up James McLaughlin or McLaugh something from the Texas Police Chiefs Association. Oh, he's a resource only. All right, that's okay. Emily Garrett, come on forward. Heather Hawthorne, Carlos Lopez, and John Barton. Emily Garrick, you can go on.
Thank you, Chair and members. My name is Emily Garrick. I'm a senior staff attorney at the Texas Fair Defense Project. I'm here to testify on this bill. Like everyone else, we just received the committee substitute last night and have been reviewing it. TFDP, we help low-income people who become caught in this cycle of debt that you're all familiar with, where they are unable to pay a fine or a cost and just become completely trapped with more and more fines and costs, lose their jobs, lose their housing, get arrest warrants, lose their driver's license, and we are working to help them get back on their feet and pay those fines and costs. I know that y'all are concerned about that as well, especially Senator Zaffarini, who has brought several bills to help those folks. We were concerned about the original bill as filed. I understand that the committee substitute changes a lot of things. We've been looking through it, and are very thankful to Senator Zaffarini's office for working with us on that and listening to us, and we look forward to working with you more. Thank you.
All right, any questions? Okay, thank you. Heather Hawthorne?
Good morning, Chairman
Morning.
and members. My name is Heather Hawthorne, and I'm the County Clerk of Chambers County. I represent today the County and District Clerks Association, and we are on Senate Bill 346. We look forward to reviewing the committee substitute and continue working with the committee, with Senator Zaffarini's office, and with David Slayton. They've been wonderful. We support consolidation of funds, but we want to make sure that no previously expressed concerns which might result in unintentional county revenue reductions have been addressed in the committee substitute. And thank you again, Senator Zaffarini, for taking on this huge project.
Thank you. Thank you, Ms. Hawthorne. Carlos Lopez?
Good morning. Yes, Carlos Lopez, representing the Justices of the Peace and Constables Association of the State of Texas on the bill. JPCA is the largest organization with the most elected officials in the state of Texas. And I tell you what, we have just a couple of concerns. We haven't even read the substitute as of this morning yet, but we have spoken to Senator Zaffarini's office, and we have been assured that the efforts have been made to ensure that the funding for training be untouched for law enforcement. We've spoken to other law enforcement groups around the state that expressed similar concerns, such as CLEAT, TMPA, TPCA, TSTA, and also JPCA. Specifically, we're concerned that the training funds for Law Enforcement Institute of Texas, which is also called LEMIT, and LEOSI funds allocated to all peace officers in the state will be reduced. We're concerned about that. Texas constables are mandated to attend training at LEMIT. Specifically at LEMIT. All our management training we hold there at LEMIT and nowhere else. There's a lack of clarification in how the funding will remain revenue neutral. We get the concept of a bigger pot and lower percentages, but we don't know what the size of that pot is. So that's the first concern. The second concern, we've testified the last at least 2 legislative sessions on the cost of bringing subjects in on arrest warrants. This hasn't changed since 1999. Studies have shown that the cost of this service has almost doubled for law enforcement. The cost now is being subsidized by the local taxpayers instead of the offenders. We've testified at the interim charges, and we haven't seen a solution to this yet. We need a method, some kind of method to recover the cost or maybe receive reimbursement for this subsidy. I can assure you that the cost of bringing in the subject is more than $50. This bill does not address that. Thank you so much for your time. We appreciate it.
Thank you very much, sir. John Barton?
Thank you, Madam Chair. I am Judge John Barton. I am Justice of the Peace in Midland County. I'm also the legislative chair for the Justice of the Peace and Constables Association, just like Constable Carlos said earlier, that we are the biggest organization of elected officials in the state of Texas. Again, we're glad that we're trying to streamline those fees. It is a complicated issue. We haven't had time to really look over the committee substitute, but we're willing to work with Senator Zaffarini's office. There's a few things there on some language that we'd like to address that may make it easier to understand. We are glad, we noticed in some of that the time payment fee, which we're glad that you're killing that part of it because we didn't think that was fair in any amount. But there's some few issues on it. We're here to testify on, but we're willing to work with your office, Senator Zaffarini, and make sure that none of this is going to affect the judicial training fund that we have, or security fund, or anything that's going to affect the operations of our office as far as training, security, and juveniles. Thank you.
Thank you. All right, thank you very much. Any questions? All right, thank you for this panel. Y'all are excused. Is there anyone else who wants to testify on, for, or against? There one? Oh, I'm sorry, did I skip you? What is your name?
Thank you. Thank you, Madam Chairman. My name is James McLaughlin. I'm a retired police chief, over 20 years. And I currently serve as General Counsel and Executive Director of the Texas Police Chiefs Association, representing approximately 1,300 members across the state. Serving as a chief, I was charged either directly or indirectly of 2 municipal courts. So I applaud the efforts to try to consolidate and make it much easier in those courts to figure out what they're supposed to be doing. Our 2 concerns, just as the constable has said, was over the perhaps loss of funding for what we call LEO's funds, or the training funds for all the local agencies in the state. It's in a lot of jurisdictions, that's the only money they get. Without that, they wouldn't be able to do the training that they really need to do. The other is, as the constable mentioned, is the Limit or Law Enforcement Management Institute of Texas. That was instituted some over 20 years ago and is the leader in the nation of management training for law enforcement. It also does something for the lower ranks as well. Without that, we would be surely hurt by the lack of quality training those places do, and we appreciate your efforts very much. And as everyone else has said, we look forward to working with you in any way we can to serve as that resource for y'all.
All right, thank you very much, sir. And Sheriff Hawthorne, I see you standing there. Did you fill out a card on this one? Yes, ma'am. Yeah, go ahead and have a seat and go ahead. We'll find it. We'll figure it out. Go ahead. Thank you.
Madam Chair, I'll be very brief. There is a card somewhere. I believe we have put ourselves against the bill as filed, but obviously there's a substitute. We're very interested in looking at it. In particular, a number of items that we're concerned with from the Sheriff's Association of Texas, who I'm testifying on behalf of. I'm a sheriff of Chambers County. But the Law Enforcement Institute Management Institute is something of very big concern, but particularly CMIT. It's the Correctional Management Institute of Texas, run by Sam Houston State University. It is who trains sheriffs and our jail administrators and our mid-level managers on how to manage and run a jail. It's extremely important to us. Sam Houston State University does a terrific job of trying to train our personnel, and as many of you know, that your jail personnel are not always trained at the same level as a law enforcement officer on the outside, working on the street, and it's very difficult for us to find the training, and the Corrections Management Institute of Texas does that for us, so please protect that funding that goes to Sam Houston State University. Also, the Crime Stoppers fund in the original bill takes a pretty big hit. As an ad hoc member of our Crime Stoppers board, I don't think there's any Crime Stopper in Texas committee that wants to lose any funding, and I don't see how any of those are unconstitutional in regards to the criminal justice program. Thank you.
Sheriff, I can't tell you on the Crime Stoppers, it looks like they got a cut, but they don't. It's like I said, there's more money in the pot, so though the percentages go down, the money flowing out is the same. But they're running the numbers to make sure, and all the stakeholders will have an opportunity to review those numbers.
Thank you, Chairman. Yes, thank you, Committee.
Yes, Senator Zaffarini.
Sheriff, if you would look at the committee substitute, and it only became available last night, although we requested it in January, which is why we're leaving the bill pending, because the bill that was filed was a shell bill. So I would hope that after you review the committee substitute, if you still have concerns, if you'll share those with us, and then perhaps you will change your position.
I feel like, Chairman, I feel like we will change our position on it once we review the substitute.
Great. You will
All right.
too. Thank you, Sheriff.
Thanks
for being here.
All right.
Thank you. All right. Is there anyone else who wants to testify on, for, or against the committee substitute to Senate Bill 346? We'll close public testimony and leave that pending. And Senator Hughes, I wonder if you might recognize me.
Thank you, Madam Chair.
Thank you, Senator Zaffarini, for your work on that.
As a matter of pending business, bring back up Committee Substitute Senate Bill 325 by Senator Huffman.
Thank you, Mr. Chairman, members. Mr. Chairman, if you recall from our hearing on March 4th, we heard the committee substitute to Senate Bill 325. The bill was left pending as it did have a small associated cost. I would now like to withdraw the previous committee substitute and set up a new committee substitute to address the fiscal implication.
Okay, so Senator Huffman withdraws the previous committee substitute, sends up a new committee substitute without objection.
All right. Members, the new committee substitute adds the Nelson Amendment to the bill. It specifies that the Office of Court Administration is not required to implement the provisions of Senate Bill 325 in the event that the legislature does not appropriate money specifically for the purposes of the bill. The new committee sub also makes clear that the clerk of the court is the individual responsible for entering orders into the registry. And this was the bill that had to do with protective order registries, so that they were computerized and maintained statewide. And that's all I have.
And since it's similar to the previously discussed committee sub, there's no need to reopen public testimony. Members, any questions for the author on the new committee substitute? I understand the author desires to leave the bill pending at this time.
Yes, we'll leave it all pending.
So the bill will be left pending at this time. That's 325, committee substitute to Senate Bill 325. 21?
1151.
Okay. At this time, the chair lays out Senate Bill 1151 by Senator Huffman, recognizes the author to explain the bill.
Thank you, members. Members, under the Timothy Cole Act, the comptroller is responsible for the annuity payments to those who receive wrongful imprisonment compensation. The comptroller currently pays approximately $440,000 to 82 claimants in monthly wrongful imprisonment payments. Under the Civil Practice and Remedies Code, a claimant's compensation payments are terminated if he or she is convicted of a new felony. Every month, the comptroller's office contacts TDCJ to confirm if any of the claimants have been convicted, and if it determines that they have been, then it terminates the payments to the claimant. Currently, the comptroller's office relies on TDCJ to confirm any of the claimants, but TDCJ doesn't have the information until it's entered into the system. Sometimes it's a period of time before that's done, and payments can be made erroneously. So this bill amends the Texas Government Code to grant the comptroller's office access to DPS's Criminal Justice Information Services system so that the agency could perform an administrative search on recipients of wrongful imprisonment compensation. By granting them authority to perform a search, the agency will have access to this information at an earlier point in the process so that it can track potential felony convictions. As the state pays more claimants under the Act, it is crucial that the comptroller's office has accurate and timely information. It was noted that in the fiscal note this could result in savings to the General Revenue Fund. It would reduce interagency delays, increase efficiencies. That's it. Any questions?
Members, any questions for the author of the bill? And Senator Huffman, there's a couple of resource witnesses here from the comptroller's office. Do you need them per se?
No, it's pretty straightforward.
Members, no questions for the resource witnesses? Okay, then we'll thank them for being here. And we do have one witness to offer public testimony, Ed Heimlich, testifying on the bill. Ed, I saw him earlier. There he is. Ed, come on up. Take a seat. Welcome. Oh, there you go. The lady there will take it from you. Mr. Heimlich, welcome. We know you, but introduce yourself and proceed with your testimony.
All right. I am Ed Heimlich, Executive Director of Citizens United for Accountable Government. Testifying on 1151, this bill must be amended to bring the statutory law of Texas into constitutional compliance. The amendment was to reform the definition or meaning of wrongfully imprisoned person. Codified in the Civil Practice and Remedies Code, claims for remedy for wrongful imprisonment must be recognized as a civil case. This particular chapter referencing this act is part of a scheme that converts a civil case into a criminal case, but with the executive division assuming the role of reserved for the judiciary. This code of Texas statutory law is for remedies, but this particular chapter's referenced by this act is a scheme designed for the opposite. Any and every human person has a right to remedies for a wrongful imprisonment. The identity of the person or entity that imprisoned them is immaterial and irrelevant to the question of whether or not that human right exists. The chapter referenced in this act creates a definition of wrongfully imprisoned person with the unquestionable intention of depriving wrongfully imprisoned persons of remedy. Committee members and staff, the people of Texas did not delegate to you the power to create or destroy rights. The people of Texas have a well-established, well-recognized right enumerated in our Bill of Rights This was done to protect our rights from you, assuming the position has granted them powers that nature has reserved for God. You are abusing your position of public trust when rather than preserve, protect, and defend our rights, you create statutory schemes to circumvent them.
Thanks for your testimony. Members, any questions for Mr. Heinley? Thank you very much. Anyone else wishing to testify on, for, or against Senate Bill 1151? Seeing none, public testimony is closed, and the bill will be left pending at this time. More folks here to vote. Okay. All right.
Yep.
The chair now lays out Senate Bill 21 by Senator Ruffman, recognizes its author to explain the bill.
Thank you, Mr. Chairman and members. Members, Senate Bill 21, also known as Tobacco 21, seeks to raise the minimum legal age of purchase for cigarettes, e-cigarettes, and tobacco products from ages 18 to 21. This common sense legislation is agreed to by the Tobacco 21 Coalition, which includes over 75 organizations who are eager to decrease tobacco and nicotine use by young Texans. While many of you are familiar with the harm caused by nicotine and tobacco consumption, I would like to share some statistics that will illustrate how important it is that we encourage meaningful public policy that gets these harmful products out of the hands of Texas children. According to the United States Department of Health and Human Services, nearly 500,000 people die each year from their tobacco use. Tobacco Free Kids, a nonprofit coalition of healthcare experts across the country, estimate that every day more than 300 children become regular daily smokers. National data shows that about 95% of adult smokers begin smoking before they turn 21. Even more astounding is that 3/4 of adult smokers try their first cigarette before the age of 18. A recent study from UT Health Northeast in your district, Vice Chair Hughes, indicated that smoking and tobacco use is disproportionately high in North Texas. Almost 1/4 of Northeast Texans are daily smokers compared to 15% in the rest of the state. Additionally, 13.6 of live births in Northeast Texas were to women who smoked during pregnancy. While these statistics on adult use are astounding, it's important to realize the effect that tobacco and nicotine use has on our Texas children. In particular, teenagers using electronic nicotine delivery systems known as vape pens or ends has become a widespread issue. And members, I hear this over and over again from folks. In fact, it has become so prevalent that both the United States Food and Drug Administration and the United States Surgeon General have declared teenage e-cigarette consumption an epidemic. Raising the MLA to 21 for this offense would help keep cigarettes, e-cigarettes, and tobacco products out of Texas public schools by creating more social distance between younger high school students and of-age purchasers, thereby reducing early addiction to nicotine and tobacco. Texas is not alone in making Tobacco 21 a priority for its children. 7 other states have increased the minimum legal age of tobacco purchase to 21, along with at least 380 municipalities. Finally, the Cancer Intervention and Surveillance Modeling Network Smoking Population Model has projected that if the MLA for tobacco consumption in Texas was raised to 21 in Texas, that there would be 32,027 fewer tobacco-related deaths by the year 2100, and 718,888 years of life would be added to current Texans. In just a moment, Dr. Ernest Hawk, the Vice President and Division Head of Cancer Prevention and Population Science at the University of Texas MD Anderson Cancer Center and holder of the T. Boone Pickens Distinguished Chair for Early Prevention of Cancer, will come forward to testify in support of Senate Bill 21. I encourage you to use Dr. Hawk as a resource and ask him any questions you may have about the real-world effects this legislation could have on cancer statistics in Texas. Members, SB 21 is a mechanically simple bill that changes the MLA for purchase, use, and possession of tobacco products from 18 to 21 and makes the necessary conforming changes in enforcement. Tobacco and nicotine use is truly detrimental to young Texans, and it is imperative that we make these changes now to ensure the healthy future of our state. I'm happy to answer any questions. And members, this is a very important bill. I know that there are some members who aren't 100% convinced. I'll be very honest on this. And I hope that you will open your minds and your heart, put aside any feelings that you have, and listen. Please listen. This is a very important bill that's important to the children of Texas. It's important to many, many organizations around this state who care about kids and who dedicate their lives and their career to protecting the health of our kids and the protection of our own health and our family's health. And you know, I wasn't convinced of this the first time they approached me a few years ago about this, but I paid attention to what they had to say. I listened to the statistics. You know, it's hard to think sometimes that we can pass legislation that could actually save lives. Sometimes you think about it and you think, oh, you know, does this really do that? When I became convinced that this legislation would save the lives of children who are alive today, it became important to me and to promote this to the Senate. It's a very important piece of legislation. It's supported by leadership. The Lieutenant Governor has given me Senate Bill 21. It's supported by the Governor. It's supported by many, many people across the state. In a minute, we'll get into some of the polls around the state that shows it's widely supported by the public. So open your hearts and your minds, members, and listen to the testimony, please.
Thank you, Senator Huffman. Senator Zaffarani has a question.
Thank you. Madam Chair, you just gave me the perfect segue into my question, which is, have Texans expressed any interest at all in raising the minimum legal age for using tobacco?
Yes, they have, and thank you for asking, Senator Zaffarani. A poll commissioned by the American Cancer Society Cancer Action Network in 2018 indicates that 2/3 of Texas voters favor raising the minimum legal age to 21, with 65% of GOP voters favoring to raise the age and 71% of Democratic voters favoring to raise the age.
Thank you. And I do hope that senators will respond to your request to listen and also to read. Some of the statistics are just abominable, and some of the actions of some of the tobacco industry representatives are even more abominable.
Right. And the e-cigarettes are very troubling as well. I urge you just to look around if you go to any events where there's young teenagers. You know, you may not notice at first that they're vaping until you start looking for it. You don't realize that they have a very clever way of sort of hiding it in their hands. And I would, to parents of teenagers out there, pay attention, because your kid could be vaping and you don't know it because you can't smell it unless they use some flavored product or something.
Thank you, Madam Chair.
Thank you.
Senators,
Thank you, Senator, Mr. Chairman.
Of course, Madam Chair. Senators, any other questions for the author? Yes, Senator, in addition to, of course, we have Dr. Hawk here. There's also, should we also call up Namisha Bhakta from Ditches as a resource? Do you want them? Okay. So, Dr. Hawk, I presume, welcome. Chair also calls Namisha Bhakta from the Department of State Health Services as a resource. We can just have you guys both there prepared to testify. And Doctor, welcome. Introduce yourself and proceed with your testimony.
Thank you very much. Madam Chair, members of the committee, my name is Ernest Hawk. I serve as the Vice President and Division Head for Cancer Prevention and Population Sciences at the University of Texas MD Anderson Cancer Center. Thank you for the opportunity to serve as a resource witness on Senate Bill 21. We come to share our perspective as an institution on the front lines of cancer prevention care and services for those impacted by tobacco-related diseases. At MD Anderson, we serve as daily frontline witnesses for chronic diseases, suffering, and death that tobacco inflicts on its users, our patients, the families, and loved ones. Those experiences create a deep and lasting motivation to try to help others from following a similar course. As you may be aware, nearly every smoker started using tobacco before they turned age of 21. Indeed, 18 to 21 age range is a time when many smokers transition from experimentation to regular daily use. The young adult brain is up to 25 years of age is very susceptible to the highly addictive nature of nicotine. It's also a critical time for brain growth and development. Nicotine disrupts brain synapses or connections. from forming properly, and those altered brain connections occur in critical areas of the brain responsible for controlling risk-seeking behaviors, as well as weighing the long-term consequences of choices and actions, which makes, again, the brain highly susceptible to nicotine and similar products. The benefits of raising the age of sale for tobacco to 21 are anticipated to be extremely significant. For every 3 young people who are prevented from smoking by increasing the legal age of sale, there would be 1 less smoking-related death in the future, 3 to 1. A March 2015 report by the Institute of Medicine, now termed the National Academy of Medicine, one of the most prestigious scientific authorities in the world, concluded that raising the age of sale would have a substantial positive impact on public health and save lives. Specifically, it would reduce the number of adolescents and young adults who start smoking, which would result in an immediate improvement in the health status of those individuals, including young mothers and their children. Second, it would reduce smoking rates by an estimated 12% and smoking-related deaths by 10%. Many of the same tobacco-related harms hold true, as we heard at the introduction of the bill, to nicotine delivered by electronic smoking devices, which carry a variety of different terminology. The nicotine dosing found in those products is often much higher than in traditional tobacco and of greater potency as well. Therefore, a policy restricting sales of those products to youth and young adults 21 and younger would prevent a lifetime of addiction to nicotine. It's important to note that these ENDS devices are not yet standardized, not established as safe, and not FDA approved for cessation therapy. Therefore, they shouldn't be used for that purpose. To assist smokers in quitting tobacco and overcoming their addiction to nicotine, the state's Tobacco Quit line offers a ready resource to both adults and youth as young as 14 years of age, offered by simple approach as the telephone. There are several also FDA safe and proven effective agents, both available over the counter as well as through prescriptions, which when used properly can facilitate successful quit attempts in combination with counseling most often. MD Anderson and other UT Health facility component institutions are willing, ready, and able to assist in providing effective, approved, safe tobacco cessation services. Indeed, we launched several initiatives over the last 5 years, including the development of a certified tobacco treatment specialist program that's serving across Texas with expertly trained individuals who are willing and able to help both adults as well as youth quit their addiction to nicotine. I will note that raising the age makes sense in our mind because there are other adult-like behaviors that are restricted to 21-year-olds, including the purchase of alcohol, entry into gaming facilities, adopting a child, renting a car, etc. So there's no more important responsibility than to try to protect children and our youth from harm, and the harms of tobacco use and nicotine addiction are both cumulative and substantial. Policies like this could significantly and profoundly reduce the burden of tobacco-related diseases and death in our population in the best way possible by preventing addiction and the opportunity for disease development before its inception. Happy to answer any questions you may have for me. Thank you very much.
Thank you, Doctor.
Thanks,
Excuse
Doctor.
me.
No, of course. No, of course. Thanks. Senators, any questions for the witness? Thanks so much, Dr. Senator. Help with the
I
questions.
have one question. Doctor, we talked about by raising the age, we create more of a social distance between younger high school students and of-age purchasers. Could you explain how that works for those who may not be familiar with that term or how we are thinking of that?
The fundamental idea is that access to these products for individuals younger than 18 is typically through a friend because of the social connections that folks have throughout high school and even into early college. So anything we can do to create more distance between 15 to 17-year-olds, which is the most common time to begin experimenting with tobacco products, lengthening that out from 18 to 21 puts more distance, less opportunity for social interaction, and therefore should decrease the adoption by those individuals.
Because very often you have 18-year-olds who are still in high school, and so they could be hanging out with the sophomores and so forth, and that's, or at the same parties and so forth. So that's the kind of situation we're referring to. Is
Yes,
that
ma'am.
correct? You mentioned in your presentation that you would expect through research that this would reduce the percentage of young people smoking. Did you say 12%?
Yes.
Yes.
The estimate is 12% reduction in use and 10% reduction in deaths, long-term, of course.
Long-term. And so, members, I think that's important because what I hear from some of the naysayers sometimes is, oh, kids are going to find cigarettes anyway. They're still going to smoke. You can't stop them, so forth. But we know that this bill isn't going to stop all tobacco use by teenagers, correct? The expectations, though, are, members, think about that. If we just reduce it by 12%, which I think is a very modest percentage and probably a very reasonable perception of what we can do, we're gonna stop deaths by 10% in the long term. Is that correct?
Yes, and the whole idea fundamentally is to establish more and more progressively a tobacco-free culture. Because again, we've seen the devastating impact of both tobacco as well as addiction to nicotine at a population level and in all of our individual lives, honestly.
So this is a long-term solution, is that correct?
Yes.
And in fact, members, it may not be completely clear from reading the bill, but the bill kind of grandfathers in this year by year. So over the term of like 4 years, we'll get to the point where all 18, everyone would have to be 21 years of age too. So that helps a little bit with the revenue, but it also, of course, kind of slowly adopts this into our culture. Is that correct?
Yes, ma'am.
Yes.
And also, I think it attempts to not only address the devastating health consequences of tobacco and nicotine addiction, but also the financial implications, which are terribly substantial for our state as well.
Exactly. Thank you. Thank you. Thank you, Mr. Chairman.
Thanks, Madam Chair. Any other questions, Senators, for Dr. Hogg? Or Dr. Bhakti is here also as a resource. Any questions for either of our witnesses? Thank you guys both for being here. Thank you very much. We'll cast the following witnesses to come and take a seat, and we'll proceed with the testimony. Chair calls Elizabeth Jones. Chair calls Jason Tamplin. Call Nathaniel Fomby. Robbie Klaus. Kathleen Russell. So Miss Elizabeth Jones, Jason Tamplin, Nathaniel Fomby, Robbie Klaus, Kathleen Russell. Please make your way to the table here. Make yourselves comfortable. Man. Welcome. Please introduce yourself and proceed with your testimony.
My name is Elizabeth Jones. I represent myself and I support Senate Bill 21. I live in San Antonio and I attend law school at St. Mary's University. There are 7.3 million children alive in Texas. 500,000 of them will die prematurely because of smoking. From 1999 to 2011, I was an adjunct professor at various colleges and universities. During that time, it was rare to see young people smoking on campus. When I entered law school in 2017, 6 years later, I was shocked by the number of students I saw gathered around the tiny smoking area on St. Mary's campus. Due to the rising popularity and youth-oriented marketing of e-cigarettes and Juuls, it is no longer unusual to see young people using tobacco products. Big Tobacco has found a way to reverse 25 years of state-funded prevention efforts. Their goal is to attract new consumers to replace the ones who die using their products. Many people argue that an 18-year-old who can join the military and go to war should be able to choose to smoke. Joining the military is a career choice. It's a decision that lasts 2 to 4 years, and it opens doors to careers and education for young adults. A decision to smoke, made before the brain is capable of weighing long-term consequences, opens the door to a life of addiction, chronic illness, and early, painful death. Nicotine rewires the teen brain to seek out stimulants and other addictive substances for life. This is not the equivalent of joining the Army. I work in the field of opioid misuse prevention. The United States is desperate to curb the opioid crisis, which kills more than 42,000 people every year. The tobacco crisis kills 480,000 Americans every year. That's more than opioids, guns, alcohol, and car crashes combined. Unlike the opioid crisis, we have a proven tool that greatly reduces the social and public health harms of tobacco. Please pass the Tobacco 21 law for the state of Texas. Thank you for your time.
Ms. Jones, thank you for your testimony. Senators, any questions for the witness? Senator Fallon.
Yeah, thank you for your testimony. You said the brain's not fully developed at 18, 19, 20?
Correct.
Is that correct? And you feel they'll be better informed to make a decision at 21 than 18?
Yes.
So would you also be in favor of raising the voting age from 18 to 21?
Again,
The brain's not fully developed, so maybe it would be better as a society if we did that.
the brain isn't fully developed until now we're seeing the late 20s, but voting is not putting people's lives in danger. It's not endangering the life of the person voting. It's
They
not
could if
taking,
you vote and elect the wrong leaders.
I suppose, yes.
Yeah. Okay. Thank you.
Senators, any other questions? Thanks for your testimony. Is it Mr. Tamplin or Mr. Formby? I wasn't paying attention when you... Welcome. Introduce yourself. I'm sorry.
Good morning. I would like to thank you for the opportunity to speak to you. Today it's Nathaniel Formby.
Thank you. Doggone it.
I'm here representing myself.
Thank you.
Thank you for the opportunity to speak to you today about raising the tobacco sale age to 21. I am in support of the Senate Bill 21. I am currently enrolled at Concordia University, Texas, here in Austin, majoring in global public health. And I'm also a Texas Teen Ambassador Consultant for the Say What movement, which stands for Students, Adults, and Youth Working Hard Against Tobacco, as well as the Texas Tobacco 21 Youth Ambassador with the Campaign for Tobacco-Free Kids. And although I have various roles, they all have something in common, and that's to create a healthier future. Tobacco use is a serious issue here in Texas, where according to the most recent Texas school survey, 30.5% of 7th to 12th grade students have used a tobacco product at least once in their lifetime. Additionally, 10,400 youth under 18 become new daily smokers every year. And this is definitely something that I've seen impact both my friends and peers. I've had the opportunity and the privilege of becoming involved in prevention efforts since I was 15 years old, and over these last few years, I have learned so much and gotten to work and volunteer at the local and statewide level. Since I've had such an awareness around tobacco-related issues, I've observed so many of my peers fall victim to the tobacco companies' targeted advertising and become addicted to nicotine, especially through the use of electronic cigarettes. And because of this, I would like to commend the author of the bill, Senator Joan Huffman, on including e-cigs into the legislation. And if we can take action and increase the sale age of tobacco to 21, we can prevent more youth from becoming addicted to nicotine. And that's a future that both I and the youth in Texas deserve. So it's time to get the job done and raise the tobacco age to 21. Thank you.
Ms. Formby, thank you for your testimony. Senators, any questions for the witness? Thank you very much. All right. Welcome. Please introduce yourself and proceed with your testimony.
Hello, my name's Kathleen Russell, and I'm here representing Smoke Free Alternative Trade Association, also abbreviated with SFATA. We're coming in neutral on this bill. A little bit of background about our organization. SFATA Texas chapter represents the interests of retail vape shops. We don't represent convenience stores, and we carry what's referred to as open vapor systems, so that's a little bit different than what a Juul or a pod system would be. Most SFATA members are actually ex-smokers, and we've used electronic cigarettes to put down traditional tobacco cigarettes. SFATA supported SB 97 in 2015, which raised or made sure the age to purchase electronic cigarettes was 18 years old. We've also participated in the comptroller's rulemaking to implement the new law, and we work to educate our members. So we want to make sure our members are educated and are compliant with the Texas state laws. We also participate in regulatory discussions on a federal level. We want to continue to be good partners, and we want to ensure that e-cigarette retailers in Texas are always complying with applicable laws. I would like to highlight for the committee a statement attributed by the Secretary of Health and Human Services. This was in the New York Times article last week. He stated that the Trump administration backs closing off children's access to e-cigarettes while making them available to adult smokers trying to quit. I don't want to ramble on and on. I've included in my written testimony our amendment, which we would like strongly to be considered. We are under a lot of regulations from all levels, and so we would just ask that you please consider our amendment that we've asked for, and I appreciate your time today.
Thank you, Ms. Russell. Senator, is there any questions for the witness? Senator Hall, please.
Could you describe your amendment, please?
Sure. The proposed amendment would add a new section, 161.0815, to Chapter 161 in the Health Safety Code to read, a limitation on local law. A political subdivision of this state may adopt public use restrictions regarding e-cigarettes, but may not adopt or enforce an ordinance or requirement that would establish standards on regulations for e-cigarettes. So basically, we want to allow municipal regulation, allow local governments to continue to impose public use restrictions so they can say when and or where you can or cannot use them. We would just like to have, we don't want to have too many more regulations where they can actually change it. So if it goes in as 21, we don't want a city or a particular municipality to be able to change that to 25 or change it in a future date. Does that answer your question? Yes. Okay.
Thanks, Senator Hall. Thank you, Ms. Russell.
Thank you.
And thank you each for your testimony. You're excused. Thank you for being here. Now, we had previously called Robbie Klaus and Jason Tamplin. Looking for them one more time. Okay, we'll register their positions, both shall not wishing to testify. Okay, for the next panel, we'll call Amy Hedke, Jessica Quick, Betty Hammett, Terry Harper, and Brian Hayden. So Amy Hedke, Jessica Quick, Betty Hammett, Terry Harper, and I think it's Brian Hayden. Oh, did Ms. Klaus make it? Welcome. Thank you. Have a seat right there. Thank you. Hold tight. I'm sorry we had more than... you'll be up right next. So just sit somewhere close by. I apologize. Okay. And we will start over there next to Senator Fallon. Didn't mean it's rude to point. I'm going to point. Introduce yourself and begin your testimony, please.
My name is Brian Hayden. I'm testifying on my own behalf. Aim high, the U.S. Air Force used to say to recruit young Americans, but it's hard to aim high or serve your country when your health is suffering from a culture of tobacco addiction. I should know, I'm a retired Air Force Master Sergeant, a participant in the CDC's Tips from Former Smokers campaign, and a survivor of a heart attack, a heart transplant, and lung cancer. Because of my experiences, I'm a passionate advocate for the proposed legislation to increase the sales age of tobacco to 21 years. Please understand, I am not speaking on behalf of the CDC today. These are my words, not theirs. Yes, Texans can join the military at age 18, but it's flawed logic to argue that you should be old enough to smoke if you're old enough to fight for your country. It offends me that the serving of our country is equated to smoking. Tobacco use is a lethal and addictive behavior, not some rite of passage or sign of adulthood. Tobacco companies target young people before they can fully appreciate the consequences of becoming addicted. Almost all smokers start before 21 years old. We should not exclude service members from the protection raising the age of 21 gives. Instead, our young service members deserve the same protection we offer our non-service members. They've pledged to protect our freedoms with their lives. The least we can do is pledge to protect them from the perils of smoking. Giving them a better chance for a healthier life is a better reward than preserving their ability to smoke. While I started smoking before joining the Air Force, my story might have turned out much differently had tobacco been off limits and instead of encouraging us to smoke. After nearly 2 decades in the Air Force, I had my first heart attack at the age of 35. I was in and out of hospitals for the next 15 years. As my heart failure worsened, I was unable to work by the time 2005 rolled in. But you know, I still smoked. As much as I wanted to live, I couldn't stop smoking. And in 2007, I lost my chance for a heart transplant. The surgeon had found nicotine in my system and removed me from the transplant list with no hope left. I entered hospice and waited to die. A year had passed and I was still alive. It was then I thought that if I'm not going to die, I should give myself a chance to live and quit smoking. We should do anything we can to help these kids from start smoking. I finally received a heart transplant in July of 2012. 4 years later, even though I had lived a smoke-free life for many years, I was diagnosed with lung cancer. Although it was caught early, part of my lung was removed just a couple years ago. Last week I had another CT scan to see if the new mass was big enough to biopsy. Luckily, the answer is not yet. But cigarettes still affect my health years after I stopped smoking. Some folks don't have much sympathy for a grown man who can't stop doing the things that are killing him, and that's fair. But the younger you start smoking, the harder it is to quit. Members of the military smoke at even higher rates than the general population. And I'm pleased that the military now recognizes the negative impact and is taking steps to curb its use. Texans can support our troops and fight for the health of those fighting us. I urge the Texas Legislature to prohibit selling tobacco to those under 21 years old.
Sergeant, thank you for your testimony, and glad to hear you're doing better health-wise, too. Thanks for your testimony. Senator, is there any questions?
Chairman,
Senator Truppman?
I might just take this opportunity, since this gentleman testified about the military and military preparedness. I have some written testimony that's going to be distributed. That's from retired Lieutenant General Lloyd Utterback from the U.S. Air Force, which I think he wasn't able to be here today, but he did submit written testimony that I think is really important to present orally. And if you would allow me just to hit the high points on this, because I think it's very important testimony. This individual, Lieutenant General, who is an Aggie, had 34 years with the military, and he oversaw a vast training enterprise leading all operational aspects of nearly 5,000 active training courses taught to approximately 250,000 military students annually. And the vast majority of his trainees were 17 to 24 years old. And he provides some startling information. Over 70% of all young Americans aged 17 to 24 do not qualify to join the military. 70%. A large portion of their inability to qualify to serve this country in uniform comes from poor physical fitness and the effects of an unhealthy diet. Tobacco use in virtually every credible study and analysis is linked to poor health and limited physical fitness. That simply is bad for military preparedness and puts a tremendous financial drain on the Department of Defense, the VA, and the rest of the American health system. When he was commander of the United States Air Force training, he put a stop to smoking with his airmen while they were in the training pipeline based on data showing a direct correlation between the availability of tobacco and initial use. He goes on to say, as this gentleman said, that 1 in 4 U.S. military service members smoke cigarettes compared with 1 in 5 individuals among the general public. According to the Department of Defense, the military spends more than $1.6 billion a year on medical care and lost work days due to smoking. Extrapolate those numbers to the American workforce, and the decision to delay the use of tobacco to enhance long-term health seems a logical choice. It's good for military preparedness and good for our entire nation. I would also point out that the Texas Education Agency, the TEA, is shifting some of their focus now to military preparedness as we look for ways to prepare our youth for the future. And they are starting to realize that we are not preparing our young people for the military. If only 30% qualify, certainly not allowing them and trying to help them at a very vulnerable age to not get addicted to nicotine is an important part of what we can do for our nation to prepare for a better military. So I wanted to make that point from this Lieutenant General who was kind enough to send this testimony. All right,
Thank you, Senator. Senator, any other questions for the witness? Thanks for being here. Welcome. Please introduce yourself and proceed with your testimony.
My name is Terry Harper. I am strongly opposed to this bill. I would like to shout out real quick to my Senator Zaffarini, who is a sponsor and a member of this committee. Texas is not a nanny state. Texas has a long-standing tradition of strong individual rights and responsibilities. Passing age-based laws to control individual behavior comes straight from Hillary Clinton's playbook, It Takes a Village. In our great state, the age of 18 brings about a timeline change that separates childhood and adulthood, a time in life where one can be called to sacrifice life for country, a time where responsibility for actions can be reconciled by harsh prison sentences, even the death penalty, yet a time that brings responsibility to select our elected officials, in fact, the very officials considering this bad legislation. Considering the change of direction in our great state and nation, I would suggest upping the voting age to near 40. I think we can all agree that generally tobacco products are not conducive to good health. Bad diets can bring about obesity, diabetes, heart and vascular issues. Overconsumption of alcohol can lead to serious health consequences, altered mental state, affecting good decisions and behavior, and diminished driving skills. My point being, how far must we carry legislation to correct bad decisions and behavior? Choosing an age of responsibility that is acceptable, an age of consent where we can live with both good and bad choices. I believe we all know family and friends, many who are way beyond their teen years, many in the 40s, 50s, and 60s, who still make bad choices. If 18 is that chosen time where childhood becomes adulthood, then we need to worry about cause and effect. The need to focus on penalties for bad choices and behavior, because no amount of legislation will ever prevent bad choices and behavior. I ask that you strongly consider that this bill is not the solution to the problem. Becoming a nanny state or the all-watching village is not the direction liberty-loving Texans want to go. Thank you for your time.
Mr. Harper, thanks for your testimony. Senators, any questions for Mr. Harper? Thanks for being here. Welcome. Please introduce yourself and proceed with your testimony, Ms. Hedke.
Hi, guys. Amy Hedke. I am also very much opposed to this bill. I'm going to kind of disagree with my friend Terry's testimony when he says that Texas is not a nanny state. It is, but it shouldn't be. And no, this is the equivalent of choosing to join the military. Seriously, you sign a kid up for only 2 to 4 years, more like 20 if you can keep them in that long. You give them a gun, teach them to shoot people in the head, send them to horrific, gory combat zones, and if they come home, they often do with a lifelong case of debilitating PTSD, but yet your argument is that you don't want to let them smoke as a bad life choice. 22 military folks a day are committing suicide. That's a little less reversible than your health problems from smoking. It's not flawed logic at all. You are blaming a young age as a time of making serious, life-altering, incredibly risky decisions. Doesn't hold water. Ditch the micromanaging. You referenced poor physical health and poor diet as reasons some folks aren't able to join the military. That's right out of your own K-12 education system. Congratulations. You want to let them make a career decision to kill other people and lay down their very life before the brain is fully formed, but not to smoke. Come on, guys. If y'all really wanted to save lives, you would have filed a Senate companion to House Bill 896 to abolish abortion. You don't care about saving lives. That's not what this is about.
Any questions, members? Thanks for your testimony. Welcome.
Thank you.
Introduce yourself and proceed with your testimony.
Yes, Madam Chair, sir. My name is Jason Tamplin, and I'm going to be speaking in opposition to SB 21, and I'm speaking on behalf of myself and my small business located in Fort Worth, Texas. I have 3 points I would like to make, and I will make them as brief as possible to respect your time. The first is, it's my opinion, if we're going to put a regulation and move it to a different age for when you can purchase these products, we should look at making that number 19 instead of 21. My reasoning behind that is our goal, I think, is to keep this out of high schools, keep this out of the hands of minors, and I believe that 19 succeeds in that. It takes it away from seniors that will still be in high school and have the ability to either gift it or sell it to their friends, and it accomplishes the goal without going past that and going all the way up to 21. The second point that I would like to make is the main cause for the youth epidemic and crisis, which is true, this is a real thing, and we agree with that, is due to not the open systems that we all came onto the market with, not the reason we exist. It's because of these new systems, these pod systems, these Juul, you've heard the name, you've heard all the different colloquialisms for it. If we really want it to affect change, if we were to remove in the state of Texas a nicotine level, say 29 and below, anything above cannot be sold here. If we took those types of products that kids are sneaking into schools, that schools are confiscating from their children, and got those out of the state of Texas, I really believe that that would move the needle, not so much simply changing something to 21. I'd also just point out that although we have 18 on the books today, we are having trouble enforcing that. Out of 39,813 inspections the FDA has made over the last 12 months, 2,401 warning letters were sent out to those who failed and sold to minors. And out of that 2,401 warning letters that were sold out, 9 were vape stores. Only 9. The majority are gas stations, your Dollar General type facilities, and convenience stores in general. So I would like to hopefully look forward to working with you guys as we move through this process, and thank you for your service. And thank you, sir, for your service.
Yeah. Thanks for your testimony. Senators, is there any questions for the witness? Thanks. All right. Welcome. Please introduce yourself and proceed with your testimony.
My name is Robbie Claus. Thank you, Madam Chair and committee, for allowing me to speak. A few years ago, my 18-year-old son had to have a procedure done that required anesthesia. He had fallen asleep earlier before the anesthesiologist could come in, and I tried to sign his consent form. And I couldn't do it, even as his mother, because he was an adult, I was not allowed to sign. If this is the case, comparing apples to apples, if my son is regarded as an adult, required to make major health decisions where risk of death is possible, why could we not trust him to make a basic health decision of whether to change or whether to vape or not? It just doesn't make any sense. I have heard time and again that the reason it is necessary to change the legal age for these products to 21 is because many 18-year-olds are still in school and have an impression on those younger around them. If this is the case, why not change the age to 19? A Penn State study says teen cigarette use increased in teens when the minimum age had changed. Is this our intent, to criminalize the proven less harmful product? And I think this is where the message is lost. The difference between Juul, and I don't mean to be repetitive, and open tank systems, the Juul pods contain 30 and 50 milligrams of nicotine. At a vape store, it usually starts around 24, and you can step down your nicotine level. So that's very important, I believe, as well. I'm sorry, I'm so nervous. Right. So really, in my opinion, there is no reason to sell a higher nicotine that has never been offered, even in a cigarette, but to make the option of vapor products away from other adults within these ages ties their hands to being able to use these products to wean themselves off cigarettes. Thank you so much for the opportunity to address this today, and I hope you will make the right decision and at least take vapor products out of this bill.
Thank you, Ms. Klassen. Senators, is there any questions for the witness? We thank you each for your testimony. You're excused, and we'll bring up the next panel. Thank you. And now the chair will call Betty Hammett, and Jessica Quick, Crystal Main, William Thomas, and Kellen Kruk, Kruk. And Thank you guys for coming and coming back. I'm sorry I miscounted seats earlier, but thank you very much for hanging around and for coming back. And please introduce yourself and begin your testimony.
Hi, and thank you, committee members and chairman, for allowing me to speak.
And get a little closer to the microphone, too.
A little closer?
Yes, ma'am.
All right, a little nervous.
That's all right.
Oh, you're going to do great. Oh, thank you so much. Okay, my name is Betty Hammett, and I am opposed to SB 21. Having operated a vape store for the past 4 years, I am also concerned in the spike in the teen vaping epidemic, as they call it. Main reason this spike has hit is because of the pod style systems. I don't really want to name any names, but their nicotine level is outrageous. The kids get them and they get the euphoric feeling from so much nicotine. We need to get those products out of their hands and away from them. It's just too much. There's twice the amount of nicotine in the pod systems. It concerns the entire industry. With that in mind, we need to know that we're throwing many adults under the bus because of one product should be regulated properly. And yes, we're talking adults. These kids that are 18 and above, they are adults. The federal government has said so. They can sign for their own medical procedures. They have to. Buy cars, houses, credit cards, serve the country, guns. Matter of fact, we trust them to vote. For many of you that sit on this committee today, the epidemic is in the pods, and that has been proven by the FDA as well as studies across the country. To impact the youth number and not sacrifice adults who need these products is a harm reduction alternative. The law needs to be different. Thank you.
Thank you, Ms. Hammett. Senators, is there any questions for the witness? Thanks for your testimony.
Thank you.
Yeah. Welcome back. Thanks for coming. And sorry I miscounted seats before. Please introduce yourself and begin your testimony.
Thank you. My name is Jessica Quick, and I am opposed to this bill. Thank you for allowing me to speak, committee. And this bill brings up many issues that I believe many of us don't think about or wish to think about, but having lived it, I definitely want to address them today. First, let me say that I completely agree that the youth definitely don't need to use these products, but we are not addressing the youth today. We are addressing adults within this bill. In a perfect world, we would have no drug users. We would have no children stealing cigarettes out of the ashtrays around the house, out of mom's packs of cigarettes. If you do a poll and you listen to your grandparent, your aunt, your uncle, mother who smoked for years, you will find this is a reality. The majority started smoking long before the age of 18. And it's because they saw their parents do it or because they were merely bored. This still happens today. Yes, teen smoking has declined, but it's not at all eradicated. You see, teens are also addicted to meth, heroin, cocaine, and opiates every day. You see it in the news, and you can ask addiction specialists if it is not true that a large majority of drug users also smoke. The National Institute of Health says cigarette smoking is ubiquitous to illicit drug users, and the National Institute on Drug Abuse says smoking increases the chance of relapse. Results from the National Institute survey on drug and health shows that illicit drug significantly spikes between the ages of 16 and 17. A BMA journal, Smoking Cessation on Users, 72% versus 45%, and a higher cessation rate, 42% versus 14% against traditional cessation.
Thanks for your testimony. Senators, is there any questions?
Yeah, thanks.
Thank you. Welcome. Please introduce yourself and go ahead.
Yes, my name is William Thomas. I'm here in opposition to SB 21. I actually had a fairly decent sized thing scaled out here, but I'm going to really shorten it down for you. My main reason for being here is my son is a Marine. He was discharged after an incident that left him with PTSD and spends half of his time in a wheelchair. I will tell you absolutely that the VA wanted to put him on a nicotine patch, Zoloft, or Paxil, which the doctors told us will wear out over time, or you can put him on a low-level nicotine therapy to help him. The problem that we're seeing today with kids and smoking is ages old. I know I was one of them. I stole cigarettes from my stepfather when I was 12. So it's nothing new. What we need to focus on today is products like Juul, pod systems, salt-based nicotines that are 1.5 to 2.5 times stronger than a cigarette. That's what's causing our issues today. And I ask you to reject SB 21.
Thanks, Ms. Thomas. Senators, any questions? Thank you. All right. Ma'am, welcome. Please introduce yourself and proceed with your testimony.
My name is Crystal Main. I am against this bill. I am representing only myself, and I am against this bill because, one, I really don't know how effective it's going to be. My daughter, well, I started smoking. I no longer smoke, but when I was smoking, you knew which stores would sell them to you, regardless of your age. My daughter started smoking. She knew which stores to go. She didn't rely on someone older than her to get her cigarettes. She knew which stores she could go to. And are you going to have a police officer or someone monitoring each one of these stores every day, 24 hours a day, to make sure that they are not selling them to minors? Because they're going to. And also, the other argument is, at 18, they are considered adults. So you're going to penalize adults in order to try to prevent younger people from smoking, which I really believe it's an admirable thing. I would love to see fewer children smoking, but this isn't going to solve the problem. If you're going to make 21 the age that they are allowed to buy cigarettes, then also make it the age for them to be allowed to smoke or to join the military. Joining the military is dangerous. They go into war zones. They're putting their lives at risk every day. They're able to make that decision. They should also be able to make the decision to smoke. You're asking them to make the decision to vote, which affects our government. It affects all of us, and yet you're saying they don't have the responsibility to be able to smoke. So the age should either be 18 or 21 for responsibility.
Thanks, Ms. Main. Senators, any questions? All right. Okay, please introduce yourself and begin your testimony.
Good morning. I am Kellen Crook. I am representing myself and youth from across Texas, and I am testifying in support of Senate Bill 21. Like I said, my name is Kellen Crook. I'm 18 years old, and I'm a senior at Piney Woods Community Academy at Lufkin, Texas. I'm currently serving as a Texas Teen Ambassador for the statewide tobacco program, prevention program, Stay Wet, and I'm also a National Youth Ambassador for the Campaign for Tobacco-Free Kids. I started in tobacco prevention before my 9th grade year when my mom invited me to the annual Say What conference. It looked like a lot of fun, so I decided to go. While I was there was a fact that was shared that tobacco was and still is the most preventable cause of death in the United States. That fact shocked me and sparked a fire of passion in my heart and made me motivated to make a change in my own community. When I first heard about Tobacco 21, I thought of how much of a big impact it would have across the state and especially in my small high school. As a senior who is 18 years old now, I look back at how it was when I was a freshman. The freshmen and sophomores look up to the seniors and they mirror and copy what they do. And that can be a good thing, but it can also be a really bad thing. And in the case of tobacco use, it's really bad. Because I am 18 years old, I can go out and legally buy tobacco and e-cigarettes. I can use the products and show them off on my Snapchat and Instagram, which influences the people who look up to me. Even worse, as an 18-year-old, I can buy those products and share them with my peers, even if it is illegal. Unfortunately, I see fellow classmates who are already addicted to nicotine. They think e-cigarettes and Juuls are the cool thing to do because they believe that these products are just water vapor. They have no idea that they contain nicotine and other harmful substances like formaldehyde. And the reason my fellow students believe this partly isn't their fault. Big tobacco companies avidly market to the youth. Philip Morris Industries even said, and I quote, "Today's teenagers are tomorrow's potential customer." They introduce flavors like cotton candy and Fruity Pebbles, which are appealing to youth, and the youth get addicted. Students plug in their e-cigarettes to the school-provided laptops and hide the e-cigarettes in their jacket sleeves and then blow out the smoke into their backpack to hide it from teachers. Some say that they are going into the bathroom when in all reality, they're just taking a smoke break in the next open stall. I'd like to end with just a simple question. When is Texas going to take a stand and protect youth of the state? I see too many students graduate with not only a high school degree, but also a degree in nicotine addiction. It's time for Texas to stand up to big tobacco. It's time for Tobacco 21. Thank you.
Thank you. Senators, any questions? Thank you. Each you're excused. We'll bring up the next panel now. Chair calls Steve Ross. Please take a seat. Also Stephen Belcher, Kevin Haney, Adam Kahn, and Susie Kennan. So Steve Ross, Stephen Belcher, Kevin Haney, Adam Kahn, and Susie Kenner. Introduce yourself and begin your testimony, please.
Good morning, Madam Chair, Senators. My name is Steve Ross. I'm the Tobacco Coalition Specialist for Texans Standing Tall. We are a statewide nonprofit committed to creating healthier and safer communities in which underage alcohol, tobacco, and other drugs have no place in the life of youth. My focus is providing technical assistance and trainings to the Tobacco Prevention and Cessation Coalitions that are funded through DSHS. And over the past 2 decades, grassroots organizations such as this and other environmental strategies have done a very good job of reducing tobacco use among high school students. However, as you've heard today, there's a new round of products that are not only stopping that trend, they are showing signs of reversing it and having an upward tick of high school youth. We are talking, of course, about ends and about electronic cigarettes. Juul has been mentioned here. Now, it has taken over become a monster in the industry. It has over 65% of the entire electronic cigarette ends system. And one of the things about it is it looks like a USB port, and it sells pods, and one pod has the equivalent nicotine of a pack of cigarettes. You buy 4 pods at a time. They're easily hidden by youth. They are charged on your computer through a USB port, and the 4 pods are cheaper than 4 packs of cigarettes. Now, according to the Youth Risk Survey, over 41% of Texas high school youth have tried end cigarettes, and 10% are using now. That also means that we have, according to the latest statistics from the Center for Disease Control, for the first time in over 2 decades, the reduction has been reversed, and there's now an increase of high school students using tobacco products, especially regular cigarettes. There is anecdotal evidence, obviously, that it also leads to dual use. And so history has shown that restricting access to tobacco products helps to make our youth safer from their consequences. It's not a silver bullet, but it is a help. This session, we have a chance to do something about it, and we support Tobacco 21. Thank you.
Thank you, Ms. Ross. Senators, any questions? Right. Welcome. Please introduce yourself and proceed.
Yes, my name is Steve Belcher, and I represent myself and a small business. And Madam Chair, I respectfully decline and do not like Tobacco 21. I'm sorry. My son is in the military. He is a Marine. As a matter of fact, my son is coming home tonight, and I get to drive home and see him. I haven't seen him in over a year. I'm really happy to see him. He gets deployed next week. He is part of a small, oh, by the way, the lady who said it's a 2 to 4 year job, no, a Marine, once a Marine, always a Marine, period. My son is part of a small specialized force of 45 Marines. He has been in many skirmishes, many things defending our allies. The reason I'm saying that is my son was 18. My son made that choice to do so at 18. Madam Chair, the nanny state that some of this stuff does, it really just is disturbing to me personally. Texas has always been known as a freedom-loving state. It is a freedom-loving state. Why can't it continue? My son can make the decision, and he has made the decision to see atrocities that 99.9% of these people would never see, and he did so at 18. Why not make the decision to not smoke or vape? And by the way, he does not smoke or vape. Thank you so very much.
Thanks for testimony. I'm glad you're going to get to see your son today, too.
Thank you very much. I'm looking forward to driving home.
I bet you are. Senator, is there any questions for Mr. Belcher? All right. Is it Mr. Haney? Introduce yourself and please proceed. Welcome.
Hello, and thank you, Madam Chair and Committee, for allowing me to speak on SB 21 today. My name is Kevin Haney, and I am opposed to this bill. In 2016, my friend became addicted to opioids. She was 18. How did she get them? How do we not know? Who knows? It happened, but we were supportive in getting her clean. When in rehab, she was smoking through detox. When she came out clean, the addiction specialist told her not to quit. Let that be the goal later on. It was her crutch then, they said. Her mom, hearing about the success rate of vapor products, 50+% compared to the patches, gum, and the like at 5%, took her to a vape shop and bought her a vape device. Wanted her to stay successful in her recovery, yet to use the less harmful alternative. It worked, and for the 3 years, she has not only remained sober, but she has weaned down her nicotine to 3 milligrams. This bill would have affected this outcome and gone against the very advice of her counselors. We are in an opioid crisis. We have addiction specialists in the heart of this crisis who are huge proponents of this product for addiction to not only the harder drugs, but cigarettes as well. We would propose that these not be readily available to adults of legal age. Granted, she did not use the dual or pod-based system, but one of the lower nicotine content, more like cigarettes. This only proves to me that we are throwing the baby out of the bathwater. With the recent hike in teen usage and highly addictive of nicotine pod systems, so much even that Commissioner Gottlieb of the FDA has called them out specifically to be the problem. It seems like producing a bill that focuses more on these types of systems stands to make more of an impact without making problems worse for others who need these products as harm reduction alternative. This bill also does not give the permission of the parent to consent for those under 21 to use these products. Although a parent giving consent to 20-year-olds to vape sounds ridiculous, we can't even do that.
Thank you. Senator, is there any questions for the witness? All right. Welcome. Please introduce yourself and proceed.
Good morning, Chair Huffman and members of the committee. My name is Susie Kennan, and I am the president-elect of Texas PTA, the largest grassroots child advocacy association in the state of Texas, with over 500,000 members who have a special interest in children, youth, families, and schools. We are here today in support of SB 21 and urge you to raise the age to 21 to purchase tobacco products, e-cigarettes, and cigarettes. You've heard very persuasive statistics about the dangers of these products, particularly for youth, so I won't repeat them. Raising the age to purchase to 21 would remove the pressure that was placed on my own daughter to purchase e-cigarettes for underage peers in her social circle. As a senior who turned 18 early in the school year, she was pressured to purchase Juul devices and then pressured repeatedly to purchase the pods for her friends as they would run out and need more. It put a strain on her friendships and definitely added pressure to an already stressful time. Texas PTA supports raising the age to purchase tobacco products and e-cigarettes for these additional reasons. 3 in 4 smokers aged 15 to 17 obtain cigarettes from social sources. This is not surprising given that currently their social networks are likely to include legal purchasers aged 18 and 19. 21-year-olds are not students in traditional high schools, making it much less likely that they would be in the same social circles as high school students and therefore less able to sell or give them tobacco products. Additionally, if the age to purchase is raised to 21, it will be harder for younger teens to pass themselves off as 21 to purchase cigarettes and other products. Lastly, while Texas PTA does not generally pursue policies that regulate adult behavior, we are convinced that raising the age to purchase these products to 21 will greatly limit youth access to them. And for that reason, we strongly urge you to pass Senate Bill 21. Thank you for your time and attention, and thank you for your service to Texas.
Thank you, Ms. Kennan. Senator, is there any questions? All right. Mr. Kahn, you're up.
Hi, Adam Kahn. I blog at the website Conman's Musings, and I am very avidly and strongly testifying against Senate Bill 21. Now, I had a number of things I wanted to say, but with the lady from Texas PTA who just went before me, I really have to ask, do you not think that the exact same thing will happen just with 21 instead of 18? You're simply, you're just punting, you're keeping the same basic dynamic while just punting the age a few years. The exact same social pressures will come on, it will just be at a different age bracket. That being said, I wanted to come in here, I wanted to mostly hit the military angle and the voting angle. I think those have been done pretty well by people who have other personal stories. I will add that one of the few things that really got me into political activism many, many years ago was when a buddy of mine who was a lieutenant in the Marine Corps at the time had to coordinate court appearances for some of his guys because they got minor in possession tickets while they were on leave from Iraq over alcohol. So this is actually a serious military issue. But beyond that, it really astonishes me to hear 18-year-olds, 19-year-olds, and 20-year-olds referred to as youths. You are not a youth at 18 years old. You are an adult at 18 years old. And you ought to be able to make adult decisions, and frankly, if we're not going to have that be legal for 18-year-olds, then maybe 18-year-olds shouldn't have to pay taxes or register for the draft either. Thank you.
Thanks, Ms. Constant. If there's any questions? Thank you each. You're excused, and we'll call up our final panel. Chair calls Sheila Franklin, Steve Kelder, Dr. John Carlo, Charlotte Owen, and Samantha Boy. So Sheila Franklin, Steve Kelder, Dr. John Carlo, Charlotte Owen, Samantha Boy, if I'm reading that correct. Lee. All right, welcome. We'll begin on this side of the table again. So, welcome, introduce yourself, and begin your testimony, please.
Hello, my name is Charlotte Owen. I own a vapor shop in Guadalupe County. I'm here opposed to SB 21. I've created a small 4-minute video that I hope everyone will watch, and it tells some issues that we deal with every day. I've passed those to the clerk. I'll go over this briefly here, but please take the time to watch the video. According to most research, 90% of all smokers start smoking before the age of 18, myself included. Texas has been 18 and over since 1997, so the law hasn't been working for over 20 years. Is there any reason to think it will somehow start working because we've changed the age to 21? In a Penn State study that someone has already referenced, it states that restricting vaping to 21 caused an increase not only in teen smoking, but also a much higher rise in smoking by pregnant teens, as much as 2.1%. That brings with it a much higher risk of birth defects. There is not a nicotine zero option for cigarettes. One thing we do face is the issue that we see and we face every day is the high nicotine pod use. They are small, concealable, and come in very high levels of nicotine. They are used as a device, honestly, to get high or get a head rush. They don't offer a step-down system like the nicotine pods to stop smoking. I truly feel this is big tobacco's way of addicting yet another generation. I think we're fighting the wrong battle. I truly feel like, in my opinion, we should lower the nicotine limit strengths to 24, 29 and under. I can promise if I'm going to give someone that nicotine level, they are not going to be able to be discreet when they use that open system device. In closing, knowing that 90% of smokers start prior to 18, what age is old enough to start quitting cigarettes? If you make them wait until they are 21, That is 3 more years of damage of increased risk.
Thank you, Ms. Owens. Is there any questions? All right. Ms. Franklin, welcome. Please introduce yourself and begin your testimony.
My name is Sheila Franklin. Today I'm representing myself speaking for SB 21. Madam Chair, committee members, thank you for allowing me the time to speak today. In an online article in the University of Rochester Medical Center Health Encyclopedia, copyright 2019, is the following entry: Understanding the Teen Brain. It doesn't matter how smart teens are or how well they scored on the SAT or the ACT, good judgment isn't something they can excel in, at least not yet. The rational part of the teen's brain isn't fully developed and won't be until age 25 or so. In fact, recent research has found that adult and teen brains work differently. Adults think with the prefrontal cortex, the brain's rational part. That is the part of the brain that responds to situations with good judgment and an awareness of long-term consequences. Teens process information with the amygdala, that is the emotional part. In teens' brains, the connection between the emotional part of the brain and the decision-making center are still developing and not always at the same rate. That is why the teens have an overwhelming emotional input. They can't explain later what they were thinking. They weren't thinking as much as they were feeling. That's the end of the article. If you're not a liberal by the age 20, you have no heart. If you're not a conservative by the time you're 30, you have no brain. With some stated textual and age variances, this statement is attributed to many great minds over the last 2 or 3 centuries, including Winston Churchill. I heard it said by a more contemporary great mind, Charles Krauthammer. I understand the thinking of some. If the age to serve in the military service of our country is 18, why is that person not also old enough to make decisions about voting, drinking, and using tobacco? There are complex issues to consider. One can be trained to follow orders, learn to make good decisions in an ongoing process in their personal growth and in their military education. With age, one has the development, experience, and skills to make better decisions, giving consideration to possible consequences. If I might just add, my dad began smoking when he was 15, and he smoked for 40 years. 20 years after he quit smoking, he was diagnosed with lung cancer, and after a few months of treatment, he declined any further treatment and died due to the smoking that he had practiced for 40 years of his life.
Thank you, Ms. Franklin. Senators, any questions? Welcome. Please introduce yourself and begin your testimony.
Madam Chair, members of the committee, my name is Dr. Steve Kelder, and I serve as professor in the Division of Epidemiology, Human Genetics, and Environmental Sciences at UT Health School of Public Health in Austin. I'm also a founding member of the Catch Global Foundation, an Austin-based nonprofit dedicated to disseminating health programs to underserved children in schools in this state and across the nation. Thank you for the opportunity to serve as a resource witness on Senate Bill 21. I share my perspectives as a researcher and a teacher on the front lines of tobacco prevention, and thank you, Chair Huffman and your co-authors for filing this important bill. I have a personal and professional interest in this topic, having met parents of addicted teens who are angry. And I serve because their children are addicted, and this is not being taken care of. I also served on the 2016 Surgeon General Report on youth e-cigarette rates as an expert in the health consequences of the use of e-cigarettes with children. Let me just say off script a little bit that I'm a little bit offended by people who are using the military as a reason to justify this being against this bill in favor of addicting teens at a young age. As a 5-year veteran of the Army and as a son of a father who served in World War II in Okinawa, the bloodiest battle of all times, who came back addicted to tobacco and absolutely could not quit and died because of lung cancer. Anyway, simply put, raising the age of tobacco sale to 21 will save lives. There's 7 states in the union who have passed this policy and 442 cities. Let me get to the addictiveness. Not only is nicotine addictive, the U.S. Surgeon General has declared a few months ago that e-cigarette rates are epidemic. The Juul brand deserves specific attention because it has a 70% market share amongst teens. And finally, Juuls also deliver an extremely high dose of nicotine at 59 milligrams per milliliter. That's 20 times the amount of nicotine that's considered a low dose in these systems of 3 milligrams. I'll stop there and say thank you very much. I'm very much in support of this bill.
Thanks, Professor Centers. Any questions?
Yeah, I have a question. Doctor, based on your experience, your expertise, and your research in this field, do you think if this bill passes that it will save lives?
It absolutely will. It'll stop children from becoming addicted to nicotine, and there is now strong evidence that children who do not smoke cigarettes, who become addicted to e-cigarettes, will eventually become tobacco users. That's one big problem, and let's not forget that e-cigarettes also have a harm beyond just nicotine addiction. There's new studies on respiratory problems. There's new studies showing levels of carcinogens that have mutagenic properties and DNA changing properties that we don't know fully yet what the impact is because we haven't studied them enough. I believe e-cigarettes need to have the pre-market safety considerations that the FDA has now first postponed and have now reduced the rate to a lower rate this week with Dr. Gottlieb at the FDA. But doing safety considerations is a paramount concern.
Thank you, sir.
Thanks, Professor. Dr. Carlo, I presume. Please introduce yourself and begin your testimony.
Good morning, Vice Chair Hughes, thank you, and Chairwoman Huffman, thank you for allowing me to be here. My name is John Carlo. I'm a physician from Dallas, Texas. My specialty is in public health and preventive medicine. I'm a member of the Texas Medical Association's Council on Legislation. I also have the pleasure of chairing the Texas Public Health Coalition, and I'm formerly a health authority for Dallas County. Speaking on behalf of TMA and the Texas Public Health Coalition, we are represented by 37 member organizations who all support T21, Tobacco 21. These are the groups that recommend raising the minimum legal purchasing age to 21. We've heard a lot of points today, but I want to give a couple of additional pieces of information. First, addiction starts early. We've heard this today. We're talking about under the age of 15, ages 15 to 17. And I'd make a point based on my experiences with patients and family members. Nobody wants to be addicted to tobacco. I've never met anybody that wants to have an addiction to a deadly disease. It certainly doesn't exist. So my question then becomes about choice and whether we really truly have those choices to make if nobody wants to have that addiction. It is about brain development, particularly at this early age, and what nicotine does at the brain level to the cells and the receptors, it's very profound, and this sets the lifelong course of this disease, which is very deadly. I think that we covered most of the earlier ages, but I would also say that the diseases that are caused, we're talking about lung cancer, cardiovascular disease, virtually every organ and part of the body is affected by tobacco and cigarette smoking. And ultimately this comes as a cost. It costs the individuals their lives, their family members, their loved ones, our employees, the employers, and also us as individuals who have to bear the costs of health care for all of the individuals that are suffering from these diseases and conditions. So the last thing I would mention is there was a question about why 19 versus 21, and the National Academy does indicate that if you make the tobacco age to 21, you actually double the rate of reduction. In other words, 5% under age 15 versus 15%, ages 15 to 17, 10% versus 25% reduction in savings versus for 19 to 21. I'll stop there. Thank you.
Thanks, Dr. Centers. Any questions?
Yeah, I have a question. Dr. Carlo, I'm looking at your written testimony, and I think it's significant in your last paragraph that maybe you ran out of time so you didn't get to say it, but I think it's significant that you make these points that we've known for almost 6 decades now how harmful these products are for our children. We've known for 4 decades how the tobacco industry considers today's teenagers tomorrow's potential regular customer. Do you believe that?
Absolutely. I think we should celebrate the fact that we have reduced the adult smoking age from the 60s, which was around 40 to 50% of adults, to now 15% in the state of Texas. But we've got to be really, really concerned about what e-cigarettes is doing and the earlier onset of use of them for the lifelong smoking risk. So absolutely, I think these are really true.
And I want to emphasize again what the previous witness says, the professor, about the fact that we don't really know much about e-cigarettes, about the potential long-term effect, because the FDA, and y'all correct me because I don't know the terminology, but the FDA has not, you tell us, what has the FDA not done very recently that's going to slow down our knowledge of what, and sir, you can answer.
Sure, the FDA has the ability, based on the 2009 Family Tobacco Protection Act, to require new entries into the tobacco product marketplace to go through a pre-market survey position, excuse me, and provide evidence of safety. And evidence of manufacturing processes. That has been delayed. It was first proposed, I believe, in 2017. It was delayed to 2022. Now it's been backed by the FDA chair to 2021. So there's a continuing sort of delay tactic of some sorts that happens with the FDA. So what was announced last week is clearly a step in the right direction, but it doesn't have any teeth in it just yet. So in the meantime, there's hundreds of researchers trying to figure this out, but we're doing it incrementally, one by one. Most studies that I'm looking at are not showing that they are safe. They're safer than tobacco, but they are not safe and they are unhealthy in their use. That's e-cigarettes.
E-cigarettes, all right. Thank you. That's all I have.
Thank you. Welcome. Oh, Senator Fallon.
Sorry. Thank you. So what was the percentage that you said that, people that were advocating raising it from 18 to 19, but you said there was a percentage that from 19 to 21 that had a beneficial?
Right. So this goes to the age groups that this would reduce the number of smoking. So if you're under 15, if it's 19, the age was raised to 19, it would increase the rate by 5%, versus if it's raised to 21, in the under 15 group, it's 15%.
Okay.
And then the key group is then that 15 to 17 year age group. At 19, it's just a 10% reduction. At 21 is a 25% reduction, which is what our esteemed colleague from MD Anderson started with, is the overall benefit of raising the age to 21.
If we raise the age to, say, 25, do you think that would also help?
Right, and so actually they looked at that exact question, and actually the benefits diminish after age 21 because of these social circles that we were talking about today with the high schoolers. If you go above 21, it doesn't show that dramatic impact and reduction in those age groups.
But it would have some impact.
Minimal, but
so
yes.
It would save lives.
It absolutely would, but I mean, I like the idea of going from 10 to 25%. I think that's a pretty profound decrease.
Would it be, do you think it would save lives if we just made smoking illegal?
Of course.
Okay. I mean, so it seems to me that 21 is somewhat arbitrary.
I think that is true, but again, it goes to the question of the social circles that people are initiating. When we look at the studies of how easy it is for kids in high school to have access to tobacco, that's what really this bill is about. And that's that critical age before addiction starts.
Thank you. Thanks.
Thank you. And Senator Hall?
Thank you very much. Just to follow up on what Senator Fallon had to say. So what you're saying, it's not the people making the decision that's the problem. It's the product itself that's the problem. And we're carving out just a small part of our population that we're trying to protect as opposed to the entire population in there. But it's just, our approach is trying to restrict people and tell them not to go do this. Don't do this. But what this is what's really the problem that we're allowing to exist, that apparently the federal government is not doing what it should be doing.
So I look at it as a little bit of both. I do think that when we know the substance is addictive as tobacco, and it does change the brain, it's an addictive disorder, that we do have to look at that as a dangerous substance and do what we can to protect the public health. I do think that there are individual choices and decisions that are made, but I think that there's a balance between the two, so I wouldn't say it's any one, I think it's both.
Right, but there are two ways to approach how we protect, whether we protect a small part of the population or the whole population.
Right, but when we're in
because the whole population can make bad decisions too.
Right.
Bad decisions do not end when you get to turn 21. I don't know if you've noticed that, but I noticed it.
Right, absolutely.
It doesn't end.
Right, but I think that what we see is that the younger you start on the addictive substance, the likelihood of becoming a lifelong smoker is there. And so even though decisions may not change in terms of age group, we know the earlier you start, the more risk there is.
No, that is absolutely true, but that's with any habit. Yeah. This is in the same way. Right. But thank you very much.
Senators, any other questions? Ma'am. Welcome. Please introduce yourself and begin your testimony.
Thank you. My name is Samantha Boy, and I'm here I strongly support the bill. I'm here today because of an organization called ParentsAgainstVaping.org. I have met a lot of parents that are in similar situations as mine. I have a daughter that is a severe drug addict. My daughter is in her 6th treatment facility for addiction. She just turned 16 last month. My daughter started vaping at the age of 13 the summer before 8th grade. CNN recently announced that there's, over the past year, an increase of 50% of middle schoolers that are using Juul and 75% increase of high schoolers using Juul. My daughter's drug of choice was the Juul. She was hooked immediately. When my daughter right now is 16. She's only about 5 foot. She weighs 100 pounds. If you could only imagine how little she was at 13 when she first tried the Juul. When she first tried the Juul, 1 pod equates to 1 full pack of cigarettes. Imagine an 85-pound child smoking 1 pack of cigarettes instantly. She got high off it immediately and was hooked. This became a severe addiction for my daughter. Millions of children are addicted to the Juul. Basically, when she started, she didn't even have a chance to build up a tolerance to it. It hit her right away, and believe it or not, children are getting high because of this. They get an instant rush from this. While she was vaping, she would constantly cough up and sneeze so much blood, you wouldn't believe it. It was nonstop. She lost so much blood, she had an iron deficiency. She also, when she couldn't vape, was irritable, depressed, isolated during withdrawing from the Juul. She would come into my room in the middle of the night and beg for a nicotine patch. Do you know a 15-year-old that comes into your room at night begging for a nicotine patch? It's unheard of, but it's happening. You see it everywhere. You see it in schools. They do it in bathrooms. They do it in classrooms. They do it in libraries. They do it in the halls. You go out to dinner, you see a kid with it in their sleeve. Their parents go to the bathroom. They're taking a hit off the vape. It's everywhere. You go to the pool, kids are vaping. Everywhere I go, I see it. Harvard recently came out with a study last month that linked 2 of the flavors to COPD and asthma. Well, guess who got diagnosed with asthma last month? My daughter. She has 2 inhalers and a prescription that she's going to be on for the rest of her life. I'm not sure if you're aware, but Juul has patented a nicotine salt technology. That's what hooked my daughter. The nicotine is highly addictive and it harms brain development. I believe this hardwired my daughter for addiction. It's not only a gateway to addiction, I call it an expressway to addiction. She is definitely on the ramp and I can't get her off. I guess that's all I have to say. Oh, and one more thing I do want to say. As a mother and as a parent, as you mentioned, angry is an understatement of what I've been through because of the Juul. Thank you.
Thank you, Ms. Boyd. Senator Hall.
Thank you, Mr. Chairman. And I almost hesitate to even ask you because I know what you're going through.
It's been a nightmare.
I had a brother. This was just like what your daughter is going through, and we experienced that with him. Actually, he started younger than your daughter smoking. But the question I really have for you, and I feel for you, it's tough. It really is tough. But you're talking about a daughter who's 13.
When she started.
When she started. This bill raises the age from 18 to 21. How would that have any impact on her?
I will explain to you. There are rarely any drug dealers in high school and middle school, and it's also happening in elementary school. There are Juul dealers. It is so easily accessible for kids to get their hands on this stuff. You have no idea how easy it is. It's a cakewalk.
Okay, but I still don't understand how raising it from 18 to 21.
Okay.
Because
But-
at
but I mean,
18
but because
Could you tell them it's okay?
drugs are illegal
Correct.
at any age. And I dare say there are very few high schools or junior highs in the state that do not have drug dealers in the schools. They're there.
Correct.
But it's illegal all the way up. So making the product illegal doesn't, that doesn't seem to be working, period. So my question is, how does raising it from 18 to 21, when for anything else there are dealers doing the same thing, is going to stop it?
18-year-olds are in high school right now, and they are the jewel dealers of the high school. And it trickles down to the middle school, and then it trickles down to the elementary school.
Okay, but is it legal? Is it legal for an 18-year-old to sell to a 13-year-old?
No.
Okay, so we're talking about a law to stop something that there's already a law against doing. And that's one of the things, I'm looking, believe me, I understand what we're talking about, and we need a solution. We need to have a solution, but we need to have the right solution that will do the job
Agreed.
in there. So that's just my question.
Yeah, just say, I'll recognize you, Professor.
that's good.
I think Professor
he's
may have
trying to answer my question.
he may have an
That's
answer to
good.
your question as well. Professor, you go ahead.
I agree with what you said, but put a different way, there's a supply chain coming in schools. Part of that supply chain is purchasing by 18, 19, 20, up to 21-year-olds who are still having friends, associates, siblings in in high school. And absolutely, there are dealers on campus. I've heard it over and over again. So someone is buying these jewel pods, and I believe that it's the 19 to 21-year-olds who know these kids and have easy access to these kids. So will this solve the problem 100%? No. But there's very little legislation we can pass that'll solve all problems all the time. It'll do what he said. It'll cut the rate. And that's what we're after.
I believe that the products were not available would have a far more significant impact on cutting the availability.
Well, that is on the table by the FDA. If these high nicotine companies are still, if we see a continued rise in their use, it was stated by Dr. Gottlieb, who, by the way, has somehow retired. It's on the table. He has the power to restrict their sale altogether. Do I wish he did that? Yeah, I think it's about time to do that. Or, as these vape owners say, let's lower that nicotine rate to a reasonable level.
Okay, thank you.
Thank each witness for your testimony. You are excused, and thank you for being here. Anyone else wishing to testify on, for, or against Senate Bill 21? Seeing none, public testimony is now closed. I believe it's the author's desire to leave the bill pending at this time. Okay, the bill will be left pending.
Thank you very much, Mr. Chairman, for chairing that. Appreciate that.
Madam Chair, I've got this stack in front of me, and I failed to mention.
Okay.
I'm so sorry. Let me bring the bill back up and say we have a stack of affirmation cards from folks who do not wish to offer oral testimony, but want to show their position on the bill, and those will all be entered into the record and shown to the members and to the public without objection. And now the bill will be left pending.
Senator Hughes, you are recognized on Senate Bill 9.
Thank you, Madam Chair. Over the interim, it was my pleasure to labor alongside you, Senator Huffman, Senator Zaffarini, Senator Hall, Senator Birdwell, and other members of this body on the Select Committee on Election Security. And the bill that we humbly place before you is in large part the fruit of that work. The report of the committee, which was supported unanimously by the members, endorsed the adoption of election systems with a paper ballot or paper backup. As of the end of last year, 36 states use systems only with a paper component, and 5 use electronic only, and then 9 states like us have a combination of the two. Senate Bill 9 would require counties to use election systems with a voter verifiable paper audit trail by the general election in 2024. The bill also requires the Secretary of State, as our Chief Elections Officer, to implement a pilot program to use what are called risk-limiting audits to make sure our electronic systems are counting votes as they're supposed to. This type of audit applies the laws of statistics to provide ongoing verification using the least amount of resources and cost to gain the highest confidence in the integrity of the system. Here to testify and also answer questions on voting systems with paper ballots and backups, we have Colonel Tony Schaefer, Senior Fellow at the London Center for Policy Research, and also to talk about risk-limiting audits around the country. Dylan Lynch is here from the National Conference of State Legislatures. The bill also makes several changes or responses to problems we heard about from elections administrators from my district, from around the state. Each of us have heard from folks back home, administrators, DAs, and the Attorney General. We have Honorable Omar Escobar Jr., who's the DA for Starr County. He testified at our interim hearing and really opened our eyes to a lot of what's going on, and he's here to discuss the need for those changes. There are other details in the bill we can go over as we come to them. We do have a committee substitute.
Hughes sends up the committee substitute to Senate Bill 9. You're recognized on the committee substitute.
Thank you, Madam Chair. The committee substitute deals with the issue of transportation assistance and curbside voting provisions that's addressed in the main bill, and the committee substitute changes it so that when someone is assisting 3 or more voters at a time who are not family members, then the provisions would apply. On assistance actually in the polling booth, it clarifies that a watcher or an officer cannot be present when the voter is voting, or if they're voting by themselves or with the assistance of a family member, but they can be present if anyone else is assisting that voter, again, to make sure that the voter's wishes are the ones being recorded. Also changes the collection process for a civil penalty, and also puts some technical changes in place requested by the Secretary of State to implement risk-limiting audits. I'd love to visit with you about more details. Those are the broad outlines of the bill, and we humbly offer it to the committee and hopefully to the full Senate, and I'll yield for your questions.
All right, do we have any questions at this time of Senator Hughes? Senator Hall.
Mr. Chair. Great bill, Senator.
Oh, thanks, Senator.
Covered many of the items that we need to address to clean up our election. Now, as you and I have talked, there are a couple of other areas that I'd like for you to consider, and I'm not the appropriate, I'm going to ask that chair the appropriate way. We had amendments for your bill. I am open to how we handle this, whether we do it here in the committee or we do it between now and the time we go to the floor. But I'd just like to address them, and then I'll leave it to you, because I know you're on the right direction and path on this thing, and all we want to do is get all of this passed. So as far as getting it incorporated, I'm good with how you'd want to do it.
No, thank you, Senator. And as we continue to have the discussion, I know there'll be amendments on the floor that we can work on. There's the committee sub we have deals with some of those technical changes I just described. Beyond that, doesn't make any substantive changes. And since it's a low number bill that we want to keep moving rather quickly, I'd love to keep talking to you and then visit on the floor about those amendments and whatever else comes up. But you're right about the issues need to be addressed.
Okay, if I could, let me go on what those are. It's this. Members, this amendment would simply require the presiding election judge to confirm that each voting machine has any public counter reset to 0 and print the tape from that machine that shows the counter was reset and sign the printing tape. It also required that a representative from each of the major parties would sign that tape. And then what that is voting machine in place, where the voting is going to take place. Not back in the warehouse, not back at central counting sometime the week before, but immediately before the polls open, we confirm that those machines have 0 votes in them. Okay. And then at immediately after closing for the polls, we would print what's called the tally tape. This is the tape that would now tell you what votes took place. So we had the machines at the facility just before it opened. We knew they were 0, and now immediately after the polls are closed, you print a tally tape, and the judge and a representative from each of the major parties sign that tally tape, so that you now have a record of what it was showing that was in that machine before it's moved. You know, we have a practice of some are taking it back, and somewhere between the time the machine leaves the facility and they actually get back, they run this tape. Sometimes there's only one person there, whatever. This would keep a bright light shining on all the activities that are taking place. And the other part of this one would be that we'd make sure to require that the counting station manager and the presiding judge of a station develop a protocol beginning on the location to ensure that no electronic devices capable of being connected to the internet is allowed in the central counting station. Okay?
Right.
All right. And then I believe we've got, just a second. Okay, and then we have one other that I come bringing money from another program that we're going to put an end to, hopefully,
Yes, sir.
to make available. You have a great part in there requiring paper ballots. And what we need to do is move to that as quickly as possible. Many counties have just bought some equipment that's not the right equipment. Many counties can't afford the equipment, and it was something to be purchased. And so what I've got proposed, and I have a rider in the budget for this, to make this money available for the counties to actually purchase the equipment that would meet the requirements that you have in your bill. And I'd like to see how we marry those up so that we can move out, so that they would have this before the 2020 election. That's the idea behind it.
Well, thank you. And I should say on that, in the bill as filed and in the committee substitute, for those counties who recently purchased machines that do not comply, there is already funding presumed in the bill to convert those machines. But yes, sir, you're right. The out date, how soon we want to require this, that's going to be a matter of how much money we can come up with to purchase more machines.
I think we'll find there will be enough money pulled up, immediately available, if we can get this done.
Good.
So that we can get those machines purchased.
Excellent.
And have them for the 2020 election. So I'd like to work with you between now
yes,
and then
sir.
to get this fixed at the appropriate place in time, if you agree with these concepts.
Thank you very much. It makes perfect sense, and we've discussed most of these matters over the last couple of days and over the internet. It makes sense. And as you know, there are 4 other election overhaul bills starting with 900 that are related concepts, and we're going to work on some of those as well. So
yes, and we have some others beside this, and we'll continue to talk about all of those, because I think the people of Texas deserve to know that when they cast a vote, we have done everything within our power to make sure that their vote is counted the way they intended for it to be counted. And I think you're on the right path here of achieving that. So thank you, Senator.
Oh, thank you, Senator.
Senator, I have a couple of questions about your perhaps, and I know we don't have anything in writing, but proposed amendments. When you talk about, a couple of times you talked about having a member of each party sign, or I don't know if you used the word member, a representative of each party to sign off on these the tally tapes. Who do you have in your amendment as the representative? Because I'm just imagining in some, jurisdictions and venues and so forth, when the polls are closed, there's not necessarily going to be a party representative in each and every place. So,
I think
how does that happen? And who's named?
Okay. If this will be such that only if they're present. If they're not present, they don't have to, but if they are, they will be allowed to sign the tape. And the idea is to just raise the level of confidence that that more than one person saw the tapes.
Okay. So would that be a representative?
So if you end up in a situation where, like may happen in some, there's only one person there, that's fine.
Would it be a representative designated by the party in advance?
It could be, yes.
Well, I would suggest you just sort of study that when you pick your words for your amendment, because I think that would be critical and crucial to have someone who had been set up in advance, not just some person who happened to be standing there, and just said, hey, I'm a Republican or I'm a Democrat, I'll sign off.
Right.
And are they going to be trained, of course, to look for the proper, just properly trained to perform that task?
Very good point.
Okay,
Madam
that's just
Chair.
some thoughts I had. Secondly, you talked about a county judge, I think you said county judge, and I was taking notes, I might have missed it, developing policies about not having a device present that could connect to the internet. Are those going to include cell phones, or, so you're talking about something that directly connects, or just something in the room?
something that could connect to the internet and be connected either directly or indirectly to the voting equipment,
Okay,
so that the equipment stays isolated.
okay. And will you be working with the vendors on this because that supply some of the machines? Because I know at some points there was some concern about some of the machines being able to keep up with the high capacity of high voting, and there's sometimes they use some devices to augment the ability for the machines to send back results and so forth. Or is that what you're talking about?
I think we find that those are the older machines that will no longer be around, that the newer machines will not have that issue. Matter of fact, I think what we're seeing is the newer machines aren't even capable of being connected.
Okay. All right. Again, we need to make sure that there aren't some venues or jurisdictions left with the old machines, because
Correct.
To make sure that we don't put anyone in a box where they can't, conduct the elections quickly, because everybody wants results real quickly, right? And when they don't get them, then they suspect something went, wrong, or there was, mischief, right? When the results don't come quickly. You also mentioned about taking money from one program to another. I've not seen your rider. Do you know which program?
The vehicle inspections program.
Okay. I haven't seen that rider. So
And I believe there may be more than one rider, and I know there's one in the House also to do the same thing.
Okay. Well, we haven't had Rider Day in Finance yet, so I'm sure that will pop up later. Okay, thank you. And I know we'll hear much more about those amendments later. I just had those initial questions.
I had one more.
Sure.
I'm sorry. And that is the moving to a voting week or a voting period to eliminate the gap that we have found, or gap that exists between early voting and election day. We found that provides an opportunity for people to do things with the machines. And so we think by coupling them and it'll be easier on the county to have a fine-out period of start voting on one day and you end on election day with voting available all the way through. And so that will be an amendment also.
All right. We're going to call up your invited witnesses, Senator Hughes. Is that good? Omar Escobar, Anthony Schaefer, and Dylan Lynch.
Morning.
Mr. Escobar?
Yes.
You may proceed, sir. Thank you.
Thank you. Good morning. My name is Omar Escobar. I'm the district attorney for the 229 Judicial District. Those counties include Starr County, Jim Hogg counties, and Duval counties. I'm going to just talk about some of our experiences as far as with the election code violations and sort of what our experience with election fraud in the most recent elections, and then I'll field any questions you might have. We began our effort sometime in January of 2018 to begin to enforce the laws that were passed in 2017 regarding election fraud. And some of the things that we began to see was that, for example, we have 30,000 registered voters in Starr County. And out of 30,000 registered voters, we might see, well, in the 2018 Democratic primary, we would have seen approximately 14,000 people vote. But for that election, we had 2,000 applications for ballot by mail. That's 2,000 applications for ballot by mail. When we began our enforcement efforts as far as the changes to mail-in voting laws, what we saw was sort of a decrease in the number of people that actually voted by application by mail. So what happened in the actual election was that only approximately 800, somewhere about 800 of the persons who applied for ballot by mail actually voted by mail. The rest began to cancel their ballots, and the reason they did that is because many people had been told by political workers that they could vote from the convenience of their own home if they just signed a form that they didn't understand. For many voters, they believed that the political workers were actually official election workers, so they were being shoved a application in their face and told, do you want to vote in the convenience of your own home? And well, who's going to say no to that? So You had people signing off on forms. What they didn't know was that the applications had disabled marked for them, and many of these people were not 65 years of age or older. They didn't know any better. And so the practice had been that these political workers who are being paid to harvest the votes would tell them, hey, by the way, these particular, the mail-in is going to come in at a particular time. As soon as you get that mail-in, you call me and I'm going to take care of it for you. By the way, this is all borne out through our investigation. One of our investigators is here also that will be available to testify. And so this would have been the practice. As soon as people found out that we were sort of investigating these matters, people started canceling their applications for ballot by mail and started instead going to vote in person. So that decreased the mail-in voting significantly, at least in the March 2018 Democratic primary. What we did see was that most of these people, I'm going to say 9 out of 10 voters that claimed a disability on a mail-in application for ballot by mail were not disabled under Texas law. There's no way. Some of them, you had a firefighter, you even had a jailer, some worked for the school district. They were all claiming disability and they didn't know any better. Some of these are professionals because of the practices that were common at that particular time. Also on the mail-in side, you had elderly people, many of whom receive food bank distributions, sort of approached by workers and being told, you know, hey, here's the application for ballot by mail, you need to sign this thing. And as soon as you get the ballot, we're going to come in and we're going to prepare it for you. So the practice, as we have seen it, was that they'd go in and, of course, as soon as that ballot came in, they'd swoop in and help them sort of vote the right way. And so that was really the practice. That has been the practice for years, but like I said, it began to decrease the moment we began to investigate some of this. And what I will tell you is that what has led to some of these practices is that the reason the political workers were so confident in allowing, sort of just putting disabled when they were not disabled, is because the Secretary of State has sort of given this opinion over the years that elections administrators could not ask whether somebody was disabled or not. So the law was on the books. In other words, you have to qualify to get an application or a ballot by mail, but there was really no enforcement of it. So it's akin to saying that possession of cocaine is illegal in Texas, but telling law enforcement officers you can't ask what the white powdery substance in the pocket is. That's exactly what's going on with the election code provisions. So people were not allowed to, the elections administrators were not allowed to inquire anything about disability. It's when we started asking ourselves that people started noticing that election workers started sort of coming back to that. So that was really our experience there. And part of the other experience that we saw was that we drafted policies that were basically property use policies in Starr County that kind of designated parking areas around the courthouse as parking areas, because before what would happen is that these parking areas would be commandeered by people who were sort of campaign workers, and they'd have tents and all kinds of things, and so it would effectively cut off most of the parking. And as soon as a voter would get down, you know, they'd be sort of congregated around, harassed to vote in a particular way. And so our experience, at least, is that most voters just want to be left alone. They want to get down, go vote in peace and leave in peace. And that wasn't happening. So that was also our experience there. One of the things that I will note is that in the November election for 2018, we started noticing a different practice. Now our enforcement efforts decreased mail-in voting. And even though, I will tell you that even though it decreased mail-in voting, it didn't seem to have any impact in overall numbers. There were still 14,000 people who voted, probably more than non-presidential primary elections. So it didn't affect, in my mind, it didn't affect voter turnout at all. In fact, it seemed to increase it in one way or another, but it didn't affect it. So as we go to November 2018, some of the local races, as far as the school district races and some of the general election, at least in one polling location, what we saw was, I'll preface it by saying there was much less mail-in that had been in previous years. So now we have a whole bunch of people that are cognizant that if they're not disabled, they can't vote. So that really, kind of weeded out a lot of the false applications, and there's a lot of election fraud there. But what we started noticing in the first day of early vote was at one polling location, all of a sudden you had people that campaign workers and even candidates approaching the voters and evidently asking them if they needed assistance. Now, so you can imagine a situation where a person is going to vote, wants to get off his car and go vote, being approached and asked, hey, do you need assistance? Well, maybe, maybe not. No, you need assistance. You need assistance. Well, and so, okay, well, yeah, let me get it. So we saw approximately 1 out of every 5 voters all of a sudden needed assistance. They couldn't read, write, or otherwise understand a ballot. We found that completely suspicious immediately. So it's my opinion, I think, that the strategy then changed from concentrating on mail-in voting to then concentrating on assisted voting. So what happens with assisted voting? Same thing that happens with disability. I'll reach into sort of curbside voting also, is that when somebody asks for assistance, most elections administrators are told you cannot ask. So once again, the exception is swallowing the rule. And so, or this practice is now making it largely unenforceable. So political workers know this. And so they can go to a particular voter and say, you need to vote, you need assistance. So somebody's going to go in and say, this person needs assistance, and they can't ask. So it was hard to believe that a lot of these people that could otherwise read and write were getting assistance. And so it seems to me like the fraud seemed to now shift over into assisted voting, which that has been the Starr County experience. I won't talk for Hidalgo County, but certainly Starr County, that has been our experience. So we've seen a reduction in mail-in. Now we got an expansion in the practice of assisted voting. So definitely, I think the provisions in SB 9 are something that will help address these situations as far as election integrity is concerned. I will just briefly comment on something that I think bears mention, that nowhere in any bill that I've seen, or any bills that I've seen, are there enforcement provisions. When we think about election fraud, we think of it as after it happens. So we've got before fraud happens, which is why we have election laws and provisions, and then we have what happens after election fraud occurs. So we're usually coming in, along with the AG's office, are coming in after it happens, and sometimes a year or years after the election fraud happens, to investigate, interview witnesses and come in and sort of prosecute. But we've already had several election cycles that have already gone past by the time there's action taken. So my concern is that, I think some of our conversations with the AG's office is that there is no enforcement provision that I can see in the election code that would give, let's say, the county attorney, a district attorney, or the AG's office enforcement provisions that would say, okay, elections administrator, you know what the laws are, but you're not enforcing them. And so the question would be, is there a way that, where we can have some kind of emergency enforcement authority from the local officials before fraud happens? By that I mean either an injunction, mandamus, TROs, anything that might, and maybe, some sort of punishment for somebody who knowingly engages or knowingly fails to enforce the election code. And that would apply basically to presiding judges and elections administrators. But right now it is unclear who enforces election code violations and who can sort of mandate that election code officials or election officials enforce the laws. So I would recommend that at some point in the future there be some provision in the laws that would give enforcement authority to the AG's office and either the county attorney or the district attorney, or even a private remedy that would allow somebody to go into district court and say, election official, you need to enforce this provision. Or even if you know and you can show that, let's say a politiquera, that is a political worker, is knowingly engaging in election fraud, to go in and get a TRO, or temporary restraining order, against this person if they can show it in court, and have an order restraining them from engaging in election code violations under some sort of order that a court can adopt. But right now it's just unclear, who can sort of. We did have one situation of an election official who refused to comply with part of the code, and there was like, well, there's no enforcement remedy, there's no remedy. So In either case, I think that a lot of the provisions that we have in SB 9 address a lot of the concerns that we have, and I think that they go a long way towards addressing election fraud. Thank you.
Thank you very much, members. Senator Hughes. Thank you, Mr. Chairman. Mr. Escobar, thanks for your testimony. What you offered during the hearing of the Select Committee some months ago was really something. Much of what you shared, we had heard maybe stories from back home, nothing that anyone would swear to, just rumors, this happens, that happens. And the investigation you conducted at great risk, we realize, did a lot to shine a light, not just for your county, but for the whole state. And so thank you again for that and for being here today and helping us do something about it. Let me ask you just a little bit to make sure we get the picture of what's happening about these folks who are offering, I'm putting that in quotes, assistance to folks either with curbside voting or meeting folks at the polling place. So when these folks are there to assist a voter under current law, under the practice, these political workers actually go in and see how the person voted. Is that correct?
That's right. So the assistant, by the way, so we're talking about, there's assisting in mail-in and then there's assisting in in-person voting.
Yes.
So I will just get this in here. So on the assisted voting on the applications for ballot by mail, I just want to reference this quickly. Our investigation showed that we had one person, just one person, assist 230 voters in an application for ballot by mail, just one. You had another one that assisted 100 people, another one that assisted 70 people, another one that assisted 50 people. Now, this is the application for ballot by mail. On this other side, on the in-person voting, you have people who are going to assist, and of course the assistant is watching this voter vote and sometimes marking the ballot for them. What's interesting about that is that under current law, as I understand it, poll watchers cannot watch when somebody is being assisted privately to vote a ballot. But if the elections worker, somebody's working under elections administration, if they assist the voter, the poll watchers can watch that ballot being prepared and being voted, okay? To make sure that they are not being told how to vote or forced. But when it's somebody asking for an assistant, their own personal, I'm going to call it a personal assistant, that cannot be viewed. And so it creates a situation where, see, assisted voting, just like mail-in voting, has become commercialized. It's a business. So a lot of this, what you're going to find on this side, on in-person voting, is that they know that poll watchers can't watch this. So it's just, now you're just left with the voter and the assistant that they choose. So a lot of times it's an election worker, and not an official election worker, but a politiquera or a political worker of some kind, campaign worker. It's just them two in the car, and you're praying, you're hoping that this person, this assistant, is not telling them how to vote. You're just sort of the honor system. And so that's a situation that currently exists. So I can find no reason for why poll watchers should not be allowed to see that. I can understand the privacy concerns, but in the end, I think the election integrity concerns are something we're going to have to balance out and address. And right now, it's sort of swinging the other way that allows an exception that is, I think, is swallowing the rule also. Yeah.
That makes sense, and that's why, and to your point you just made in Senate Bill 9, what we propose is if a voter is being assisted by a family member, then that wouldn't be observed. But otherwise, the watchers ought to be able to observe that process again to make sure the voter is being protected, right?
Right. I think you can have a situation where a family member, which is in the ordinary case, is somebody who's going to vote that needs help, is probably going to take a family member and to go to help them out. When you've got somebody who's being paid, or even though they might say that they are volunteers, so to speak, there's an incentive there for them to vote the right way. And I think that's where it makes sense to have poll watchers seeing this. When you got a family member who's taking their family member in to vote, we can see that. They need some kind of privacy. But when you've got somebody, a non-family member doing this, I mean, obviously there's a risk that they're being told, they're getting paid to bring these people in. They're being told or suggested, who to vote, and nobody's watching it. So I think, I think these provisions address that, and I think it does satisfy certain concerns as to family members, sort of the family member exception that is defined here. I think that it strikes the right balance. I think it strikes a good balance with trying to sort of stamp out voter fraud.
Thank you very much. Thank you, Mr. Chairman.
Thank you, members. Any other questions? Okay. Thank you very much. Okay. Lieutenant Colonel, correct?
Yes.
Go ahead. Appreciate you.
Good afternoon, Chairwoman Huffman, esteemed members of the committee. Thank you for the opportunity today to testify. My name is Lieutenant Colonel Anthony Schaefer. I'm here testifying for SB 9 on the behalf of the London Center for Policy Research. I support SB 9 efforts to end Texas' use of insecure and vulnerable voting systems. I want to thank Senator Hughes in particular for his excellent leadership on this important issue. I have 38 years of experience in national security and cyber operations, to include having worked with the FBI, CIA, and NSA. I created the first undercover offensive cyber unit in the Department of Defense back in the late 1990s. I continue to advise the Pentagon, the Army War College, U.S. Congress members and committees, members of President Trump's cabinet on cyber threat mitigation, technology vulnerabilities, and related threat intervention issues. I'm here to warn Texans that the paperless direct recording electronic voting machines, known as DREs, are open targets for foreign interference in our elections, whether it be China, Russia, Iran, North Korea, or any other nation seeking to undermine the integrity of our elections. Texas is one of only 13 states that still use DREs, and it is my understanding that they're using these DREs in over 140 counties. DREs use computers that record vote choices directly to a computer memory with no record of that choice. If DREs malfunction or are hacked, which has been proven possible, the election results cannot be audited, recounted, or most importantly, could be modified in such a way to completely undermine the integrity. Fortunately, SB 9 addresses this security threat by ensuring that counties replace paperless DREs with a voting system that provides a paper trail, a hard copy artifact. Cyber security experts like myself support the idea that systems that only incorporate paper ballots need to be the path going forward, whether marked by hand or device. The reason you want paper ballots is so that you can perform post-election risk-limiting audits, which use statistical methods to verify accounting and accuracy of the reports and results. I am encouraged to see that SB 9 also contains provisions to implement a robust auditing process. If these paper trails and audit provisions are enacted, Texas will be able to uncover any machine malfunctions or election interference so that Texans can be confident that their votes are cast as intended and counted as cast. I caution against grandfathering in the insecure DRE machines by equating the so-called voter verified paper audit trail, or VVPAT, with paper ballots. VVPATs are inferior to paper ballots. These printouts are difficult for voters to read and hard to actually audit. If you do allow counties that recently purchased DREs to retrofit them with VVPAT printers, I urge you to seek federal funding to eliminate these machines and set an earlier date by which the DREs must be replaced and truly verifiable auditing systems using paper are in place. Again, thank you, Chairwoman Huffman, Senator Hughes, and your leadership on this leadership on this critical issue. The threats to Texas' existing process are known and real. The solution to these threat issues, the vulnerabilities, are known and achievable. Paper trail audits. That's the key. This is an issue of national security that we must act to protect the sacred right of every citizen in Texas and their vote. Thank you for having me today.
Thank you very much for your testimony. Members' questions. Senator Hughes.
Thank you, Mr. Chairman. Colonel, thanks for your testimony. Chairman Huffman and I and other folks who were involved in the process traveled during the interim and heard a lot of testimony about these machines, about how they work, about what can go wrong, and about the possibilities. And of course, there are many folks who believe strongly that DREs are safe and they're safer than paper, and good folks who can differ over this. And when you talk like me and you're kind of slow like me, sometimes when it comes to technology, people think we're Luddites or we should just get with the program. But tell us a little bit more about your background, to the extent you can share with us.
Yes, sir.
Your work in cybersecurity technology and the reason you would know about the threats. Tell us a little bit more about that.
Yeah, let me try to give some background and additional illustrations of why this is important. There's a perception out there, Senator, that simply because something is either air-gapped or secure, it cannot be penetrated by bad guys. So let me give a couple of points on that.
So air gap means there's no cords going to the machine.
There was a comment earlier regarding some of the legislative add-ons to this where and by the way, I appreciate the fact that certain members want to move this forward to 2020. I applaud that, obviously, so anything I can do to be helpful in it, let me know. But there was a mention of air gap, essentially, where the systems that are used to vote are not physically connected to the internet, but some of the older ones do have that capability. Let me be very clear. Anything that's digital, whether it's connected to the internet or not, can be hacked and modified. The old 0 and 1 thing. I can't go into a great deal of detail of how we've done it, but during the early days of the internet, there was a false sense of security by foreign nations thinking that somehow if they didn't connect their internal system, digital systems to the internet, somehow we wouldn't be able to get to it. That's just not true. There's number of ways to compromise, primarily through supply chains and updates. Anytime you have a system of zeros and ones, you have programs which go with the systems. And you have what we call hardware or software embeds, so that someone like me, and I always talk about this in Congress, I'm the guy your mother told you to stay away from when you were growing up. It was my job to think as hard as I could how to penetrate bad guy systems. So all I'm saying is what we can do to others, they now can do to us. And the systems we're talking about, the DREs in particular, were not designed, they were not hardened to prevent foreign threats from getting into it, either whenever they're connected to the internet or when they're going through updates. Let me give you an example of what we need to consider, with a metaphor, if you will. During the late 1990s, we did an exercise in DoD where I was part of the Red Team, and the Red Team's task was to penetrate a closed system off the internet that controlled DoD's blood supply. The idea was, during this exercise, during a fictional war, our task was to make sure that the blood supply was compromised. Now, physically, the blood supply was located all over the world. There's no way we could physically contaminate the blood. So what's the best thing you can do, next best thing you can do to deny someone a supply is by contaminating the data that managed it. We're able to get into a closed system to modify the data regarding blood supply location, types, and availability, and once that was contaminated, leadership running the exercise no longer had it available. It was not available because you had no assurance. So this is what I'm talking about here. It's not necessarily about penetrating every single DRE or every single system. It's all about the perception that something was contaminated, something is not assurance, and therefore you undermine the very confidence in the process, even if you don't touch the process into every detail.
Colonel, thanks for that. Based on your experience with the technology and with what can be done, is it possible, given how these machines work, to go in and make changes and then cover your tracks?
Oh, absolutely. One of the things that's been noted within the last 3 years of the so-called Russia hack, I've had to testify to this and other issues. You have hackers now who will use either third country or third-party tools to hide their signature to make you look somewhere else, or more importantly, they're so skilled they can get in through an administrative back door and never even let you know you were there. So in essence, anything that's digital can be in some form modified, sometimes with a trace, sometimes not. But we do know this: the machines that are in question were designed at such a time that we were not as a priority taking on cybersecurity or supplying the technology going into them. Therefore, it is my professional judgment that there's no way to fix these things. Therefore, the current path you guys are on to replace these is the only viable option, to replace, not update. And I think even in the instance where some of the counties were permitted to buy some of these DREs late, again, I would urge a rapid removal, if at all possible, by 2020. And let me be very clear on why I think this is important. I don't believe for a minute that these foreign countries are going to pick a winner. They are more concerned about simply disrupting and undermining the confidence we have in our process. And this is a clear opportunity. And let's not fool ourselves that a nation state the size of China, Russia, or Iran would not take that as an opportunity, because if they can undermine our elections, there's secondary and downrange effects on economics and national security. So often it's just the seeking of the perception of undermining the elections is what they're seeking, and that would be a win by them.
Thanks, Colonel. Thank you, Mr. Chairman.
Thank you very much. Appreciate it, Lieutenant Colonel. Yes, Senator Hall.
Yes. Appreciate your testimony very much.
Thank you, sir.
From work I've done before, I understand you are very accurate in what you're talking about, but also the technology and the ability of what you're talking about doing isn't something that's unique to a foreign country.
No.
This is something that somebody that maybe doesn't want to disrupt it, but would like to change the outcomes of it.
Yes.
Could do exactly what you're talking about from within the states.
There's no doubt, Senator, that someone with sufficient skills and understanding of a system could map it out and then establish access and then establish the programs necessary to use that access. Absolutely. So we, in many ways, are more in danger by domestic threats regarding hackers. I mean, foreign threats will be disruptive. Domestic threats will be focused on achieving a specific outcome, and that is something we indeed have to be concerned about.
Absolutely. And in terms of level of security, we know that there are different levels of security as we go up into the whole overall system. And where we sit with our systems that were designed and built with security not being a really high priority compared to some of the systems that we have with our agencies like CIA, NSA, and others.
Yeah.
We know, without going into specifics, that those levels those pieces of equipment at much higher levels of very sophisticated security, real-time security, have been hacked.
Right.
And so the possibility of hacking things at such a low end of security as our voting equipment is almost like child's play compared to what they have done at the higher level. So this is not like got to take a special person that has spent years doing something or whatever it is. This is something that probably a teenager could do.
Yes. If I may give a complete answer on that. This is public knowledge. It's going to be, I think, head spinning, but it's public. Former Director of CIA Jim Woolsey and I were advising CIA Director Mike Pompeo during the time that CIA had its hacking tools hacked. To your point, the vendor who was retaining the CIA's hacking tools had what they believed to be a high level of security on keeping these tools from being hacked, but they were stored on the internet. Well, because of a third-party vendor controlling them, you had other smarter hackers who were able to penetrate into it. So this is, to your point, that there's certain things that can be made vulnerable simply because of being on the internet or having access, being in that. So what I'm saying, and I think, Senator, I think you've said the same thing in your own way, the paper ballots provide an artifact with a process of review and auditing, which allows for a building of confidence. It's not a single component, it's a series of components that work together using a central piece of paper, an artifact, if you will. And I think that's the key. If you have things only recorded digitally, or you make them available on the internet, you leave them vulnerable to any number of hacks or access to third parties.
Right, and you were talking about it's just raising the confidence, because as long as we have humans involved in this, there will always be a way for the evil heart of man to figure out a way to beat whatever system it is.
Correct.
Our job is to make that hole they can get through as small as possible.
Yes, sir.
And right now, we've got a hole that you could drive several trucks through at one time, and we need to get it down to something as close to a thimble is what we can size.
Yes, sir.
And paper done the right way. Now, quite often people confuse when we talk about paper ballots going back to the old pencil and a piece of paper kind. That's not what we're talking about.
No, sir.
We're talking about a much more sophisticated control where you have opportunity to confirm and reconfirm as opposed to just the DRE where when you touch that point on the screen with your intent to go to Abbott or Patrick or whoever it is, you have no idea where that electron ended up in the memory box. I mean, we do know that the machines by calibration have quite often shown punch Abbott and you get the other guy.
Yes, sir.
If there's no reason to think that if that machine will send you over to what you visually see, because it's just electrons doing it, that when it gets it right, that it's actually going down and putting it in the right bucket in the memory for the person that you intended for it.
Right.
Matter of fact, would you agree that where we have used DREs here in Texas, that you could not prove in a court of law today that the intent of the voters was carried out by the results of those elections?
Based on my knowledge of threat and technology, and I'm not a lawyer, but I work with lawyers every day, the fact that there is no physical artifact, no way to go back and recreate or audit the results, the results as noted from the DRE cannot be verified. There's absolutely no way to verify it. So therefore,
my point.
So therefore, the validity of the outcome could either be questioned by those who have intent to undermine the security and confidence, or, to your original point, Senator, someone could have gotten in and hacked and changed the results, and there's absolutely no way to go back and examine either by snapshot or by a full recount of what the intent of the voters were, because it's simply a 0 or 1 that was captured theoretically on the moment of the vote.
And that alone, to your point that you were making, that what we're trying to do is maintain the confidence of the people that their vote counts, the confidence that the outcomes of our election is what is the intent of the people, and that alone is enough to say we should be going to paper. Now that we know and have talked about it, that we have zero confidence that our history of voting, you and DREs, has resulted in the will of the people, that it'd be incumbent upon us to absolutely make sure that we have hard copy paper in the process to do that.
Absolutely, Senator.
Thank you, sir.
Yes, sir. Thank you.
Appreciate your testimony very much. Go ahead.
Great. Thank you. Thank you to the committee for the opportunity to be here. My name is Dylan Lynch, and I'm an elections policy associate with the National Conference of State Legislatures. NCSL is a nonpartisan organization that provides policy research and analysis for all 50 state legislatures as well as the U.S. territories. And NCSL does not take any position or stances on policy. I was asked to provide a little bit of background information here on risk limiting audits. It's been addressed a couple times already, but actually the state of Washington, their statute defines a risk limiting audit as an audit protocol that makes the use of statistical principles and methods and is designed to limit the risk of certifying an incorrect election outcome. So again, you're limiting the risk of certifying an incorrect election outcome. As of this time, there are currently only 3 states that have risk limiting audits in their state statute. So that is Colorado, Virginia, and Rhode Island. I will note that Colorado is the only state to have actually implemented a risk limiting audit, and I have provided, I should go back and mention I provided a handout here as well. It includes a map of the current state of post-election audits on across the country, as well as some more background information on risk limiting audits as well. So the states in purple on the map are those that currently have risk limiting audits in statute. Colorado originally passed their legislation in 2009 with a deadline of 2014. However, once they reached that deadline, they realized they weren't quite there yet and again pushed it back further. In 2017, Colorado was able to conduct a county-wide risk limiting audit. And in 2018, they were finally able to conduct a statewide audit as well. I would note, again, on the map, there are 3 states in green, and those are states that we're kind of labeling as risk limiting audit optional. And so those are Washington, Ohio, and make sure I get it right, and California. So in California, in March 2020, election officials can choose to conduct a risk limiting audit in lieu of their traditional audit. And then in Washington, local election officials can choose one of 3 audit methods, with a risk limiting audit being one of those again. And then in Ohio, a 2017 Secretary of State directive recommended risk limiting audits but did not mandate them for their counties. So those states currently have some risk limiting audits in the works or in the process. I would also note in the document included there are 6 other states that do have risk limiting audit specific legislation this year, and including Texas, that would be 7. And then as well, again, there are numerous other pilot programs that are going and being undertaken across the country. However, you might note that all those other pilot programs are in fact at local or that's either county or municipal jurisdiction level, and not so much at the state level at this time. And I'm happy to answer any other questions on risk limiting audits. That's a general overview of the state of risk limiting audits and statute.
Thank you. Yes, if you can, on your exhibit, can you distinguish between the categories of other and no requirement and give some examples that may be interesting for the committee in the category of other?
Absolutely. So the no requirement is there's no statutory requirement for any sort of post-election audit, whether that's a risk limiting audit, a traditional audit that I can define here as well, or any other requirements. The other, so the yellow category there, I believe is Idaho. As an example, Idaho they will only do an audit if a recount is triggered. So it's sometimes more often conditional. Another example is prior to Michigan passing legislation in 2018, Michigan actually did what we define more of a procedural audit, and would have actually looked at the processes and procedures being used in the election and audited those instead of auditing the ballots themselves. So those are 2 examples there.
Can you give us any indication of recent trends across the country that are consistent with what we're considering here in Texas?
Absolutely. So post-election audits as an election policy trend are picking up generally. I think since 2011 they've been pretty consistent, and in 2016 legislatively they became more popular. Risk limiting audits again are an upward trend, I would say. I believe they're the 7 bills I mentioned there, including Texas here, and I think we're about the same number last year as well, particularly after Colorado implemented its first statewide risk limiting audit in 2018. It did kind of pick up a lot of extra traction in the media, in public, as well as in legislatures as well.
So all the states under the traditional category are consistent in their policies, or?
In terms of?
Well, you have traditional labeled, and Texas is one of them.
Sure. So it's a pretty broad category, and so when we call it traditional, it usually means it sticks to there's a fixed percentage that is looked at. That fixed percentage could be a number of precincts, it could be a percentage of ballots, it could be a percentage of machines. So what is being counted can change, but it always sticks to a fixed percent. So I think in Texas it's a 1%. You're looking at other states might have 5%, or you might look at 3 precincts in a county, or some variation of that. So
those are some of the variables. Okay, thank you very much. Members, any questions? Senator Hughes?
Thank you, Mr. Chairman. Thanks for your testimony, for walking us through what's happening around the country. The concept of risk limiting audit, obviously we understand what the words mean, but I didn't really know what that was until the last year or so. Mm-hmm. And so tell me if I get this right. So under a traditional post-election audit system, if we see there's a problem, we take a look. The risk limiting audit, would you say it allows us to apply statistical principles and good technology and good paper ballots to let us know there's a problem that we didn't know about before? Is that fair to say?
Yes, and so
help us along those lines. What's a risk limiting audit? I think we get that, but just to make sure we know what that means.
Sure. So perhaps one of the difficulties with a traditional audit method of, let's say, 1% of ballots, is if you're only looking at 1%, you might find all the good ballots, theoretically. and you might miss other problems. With the risk limiting audit, one of the possible benefits there is because you are looking at the whole broader scheme of things, is that you will have the statistical methods that will, again, help you in understanding and knowing that you are not certifying an incorrect result.
Good,
So-
good. Very good. Thank you. Thank you, Mr. Chairman.
Members, any other questions? Okay. Thank you very much to this panel. Appreciate that. Okay, at this time, the chair calls Chase Bearden, Heather Hawthorne, Chris Davis, Alan Vera, and Jeff Miller. Witnesses that will be called after this panel include Lynn Foster, Crystal Main, Tom Glass, Cindy Weatherby, and Mary Smith. If you could be ready.
And Mr. Chairman, may I
Senator Hughes.
Thank you. May I request that with the next panel we bring up the AG witness as a resource for some threshold stuff I should have mentioned?
Yes.
Thank you. At your convenience.
Absolutely. Thank you, Senator Hughes.
Thank you.
Okay, if Mr. Bearden could begin.
Sir, Chair. Committee, thank you all for your time. Senator Hughes, appreciate what you're trying to do here. We didn't get a chance to come by, so we wanted to testify on the bill. We had a few questions about it, especially around the transportation portion of it, and if that was requiring anybody dropping someone off and then helping them up to the door, because we run into people that are using STS where they get dropped off by the bus, they're taken all the way in. Others who may use Uber to get there and then have assistance up to the front door. The way it read to us is that it actually meant that person needed to come in and fill that out. Right. Go ahead.
I don't want to cut into your time, but I will. So without using your time, I'll say, and thank you. We've obviously worked together for a long time. We appreciate you. And the idea is actually assisting with the voting process, or not just getting us there and back. So thank you for clarifying
only using the curbside vote. If they brought out the curbside voting and there was a person there, that's when the person would have to fill out the forms.
That's what the bill's driving at. Yes, sir. Go ahead, please.
Perfect. And the other issue that we see for us, assisted voting, we like to make sure that everyone understands all of the adaptive equipment that has been developed into the machines we have currently. We would love to see and make sure that everyone that's working in the polling place understands the adaptive equipment and how to use it, so that when someone comes in and asks for assistance, they're at least told that this equipment is available. That way they may not need to use anybody for assistance. I know we got to work with one of the local voting machine companies over the summer, working on one of the pieces of equipment for that auditable trail. That allowed someone to use the electronic device so they could have all the adaptive equipment that we've grown very used to having, so that we don't have to have assistance. It then printed out the ballot and allowed someone else to check it, even someone visually impaired, that once it was printed out, they put it into another machine that read that back to them. For us, what we want is to make sure everyone has the ability to use the assistive technology that's out there, make sure the polling places actually have all of the knowledge on how to train people. That way we don't have to worry about someone needing an assistant if needed. We also see that with some of our people that are visually impaired that may want to vote from home, that currently they cannot, when that mail-in piece comes in, they can't fill it out themselves. So looking at ways that we can do that so that when they vote from home, they aren't actually having to use someone. So I'll end on that, and we'll come by your office and work with you as we move forward.
Mr. Chairman, may I?
Yes, Senator Hughes.
Thank you so much for that. And obviously we always enjoy working with you. We want to get these things right. We sure don't want to make it where folks need assistance who didn't need assistance before. That is sure not our intent. Some of the most compelling testimony I've ever heard, I was brand new here, and electronic, this was back 2005, electronic voting was new, and there was a question as to whether that should be required for every election. And it was actually Sparky that testified, and he talked about how for the first time he was able to vote privately without anybody helping him. And what I will never forget what an impression he made on everybody there. So we sure don't want to mess with that. We'll definitely work with you on that.
Because sometimes you don't even want your family in there when you're voting.
You bet.
You may not even with your spouse want to
You
be
bet.
because it could make it for a long day, but we want that private ballot and
Amen.
as independent as possible. Thank y'all for your time.
Thank you.
Thank you. Members, any other questions?
Thank you.
Okay. Appreciate that. Ms. Hawthorne.
Well, I was going to say good morning, but now it's afternoon. So my name is Heather Hawthorne, and I'm the Chambers County Clerk. Chambers County is between Houston and Beaumont. I am representing the County and District Clerks Association of Texas and myself, and I am testifying on Senate Bill 9. This bill has great legislation and gives us great tools to help stop fraud in the electoral process. I tabbed my election code, Senator, and I went through every single change, and there are a lot of great things that are going to help us. Appreciate it.
Thank you.
But, there's a but, I have a little bit of concern with two issues in the bill. And the first one is the converting of the DREs in the state of Texas. The cost to the Texas taxpayer right now looks like it's in the upwards of $200 million. The taxpayer is in DRE counties have already paid for this once. This equipment was federally and state certified, and unless the state can fund this change in the law, it'll be difficult for many counties to use taxpayer dollars to be able to comply. For example, Galveston County, just in the last 30 days, purchased DRE certified equipment and to the tune of $3.5 million. So that recoup is going to be quite substantial to Galveston County. When I purchased the equipment that Chambers County uses in December of 2016, at that time there was not a paper trail system available that had been certified. I asked Commissioner's Court to purchase this $1 million worth of equipment in full trust and faith that had been certified by the feds and the state, obviously, and thought that equipment would be good for at least the next 10 to 12 years. So again, show me the money, and we will comply with the law.
And just to be clear, Ms. Hawthorne, you're testifying on the bill.
On the bill.
Got it, got it. Members, any questions?
No,
Thank you very much. Okay, Mr. Davis. Yes, Senator Hall, question for Ms. Hawthorne.
To also correct something I said a little bit earlier about the money, because if you heard the other week, we have a rider in the bill to do this. We have one in the House. This rider, I've got two of them, I got them too confused. This one would be to use money from the ESF to actually purchase the machines, a one-time purchase to buy the machines. Because we understand the burden on the counties and some of those that bought them, but it is so important that we get paper system in there to protect the integrity of our election that feel that this is a proper use of the money. So if that rider makes it through there with this, then we'd be able to do that.
Fantastic.
All right. Thank you. Thank you very much. Mr. Davis.
Thank you, Senators. Chris Davis, testifying on behalf of Texas Association of Elections Administrators on Senate Bill 9. In the interest of time, we echo County Clerk Hawthorne's comments on the issues faced when purchasing a system, and we also are in favor of risk-limiting audits as a concept. This bill's grown quite a bit, perhaps almost fourfold since we visited your office, Senator, and in its infancy, it covered those two issues. What I'd like to talk about today in my limited time is some of the other issues that have been introduced in this filed bill is filed. One, Section 104, dealing with impeding access to the polling place. Our members are really interested in how something like this can be enforced. We got a little information from Starr County on where this may be happening, but one of the implications is that it essentially increases the area responsible for a poll worker or presiding judge by tenfold. Currently, it's 100 feet outside the polling place, and it goes to over 3 football fields, 1,000 feet. And we can't see this but taking time away from the principal purpose of our judges is conducting the elections in that area. So how would that be enforced? In Section 2.03, as far as allowing poll watchers to examine a voter's ballot, This expands the cases where they can examine a ballot based on relationship. And again, how would this be researched and or enforced on the spot at the polling place? Will our judges be required to be supplied a genealogical tree, 23andMe, for every voter that walks in to determine whether a ballot can be examined based on relationship or not? It's a question that we have. And lastly, Section 403, the wording was a little confusing to our membership in regards to the 3-mile radius of vote centers. Was the intent of the author to limit voters from ever voting in a vote center beyond 3 miles of their residence, or was it the intent to ensure that at least one vote center is available within 3 miles of any voter's residence? We hope it's the latter.
Of course. Thank you very much. Members, questions? Senator Hall.
One quick question on the issue of the 1,000 feet in there. Do you think that leaves an awful lot of latitude for the election judge to determine what constitutes obstruction of people coming in, whether it's one person standing there handing out literature or 10 people that have to be walked through in order to get in?
I see it can definitely introduce senator latitude both in concept and in territory. 1,000 feet could be across a street in a neighboring lot, well out of what we consider the purview of a presiding judge at a polling place today.
Yeah, there are very few polling places that you've moved into businesses a couple of blocks away when you do that. And I'm not sure. Okay, thank you.
Thank you.
Thank you, members. Any other questions? Okay. Appreciate your testimony. Mr. Vera.
Chairman, Harris County Republican Party Ballot Security Committee, testifying in opposition to SB 9 with the unanimous support of the Executive Committee. We appreciate all the concern that's been raised about the DRE systems and the hacking and the new technologies, and we were eagerly looking forward to a solution coming from this committee. We can't understand why the solution you've brought us is Broward County, Florida. Not exactly a high point of election integrity and credibility, because the DS-200 verifiable paper trail voting system in Broward County is exactly what you've described in Section 5.02 of the bill. What you're going to have to go back and come to grips with is, how do you work around that? How do you prevent the kind of ballot duplication and counterfeiting that's been a part of paper ballots forever? If people can counterfeit our currency, they can counterfeit our ballots, and they have, and continue to do so. Ballots can be altered after the fact as well as before the fact. We have to deal with that. And finally, we have to deal with the issue of the voter credibility. Senator Hall, you said it perfectly. One of the key issues here is restoring to the voters credibility in their systems. I don't think Broward County inspires voters with confidence that their vote counted and was properly handled. And that's what we have in Section 5.02. Need to go back and take a look at that and tighten the parameters so we don't end up just like Broward County. That's it.
Thank you. Members' questions? Senator Hall.
I agree with you. We've got to make sure it's tight, but to compare the equipment and the paper ballots that were used in Broward County many, many years ago to the equipment we're talking about and the technology today is a little disingenuous, because there's very little comparison between the two. There are no Chads involved, there are no pencils involved. Okay. We're talking about something, and granted, it doesn't matter which way we go. I guarantee you that someone will find a way to beat the system. We will never kid ourselves into thinking we have the perfect system. We've got to make, as I described earlier, right now we've got a hole that those that would mess with our election system is big enough to drive a couple of trucks through, and we need to narrow it. And I would say that with technology and with the Colonel's testimony that he talked about earlier, the ability to mess with the electronic voting in today's world is far easier to do than to mess with a paper trail system. Both can be hacked, both can be changed, but relatively speaking, it is moved. And the needle is moved in both directions, and our job is to make it as difficult as possible to do that. And I'd welcome, I think Senator Hughes would also welcome any ideas you have when you say tighten it up. What's your ideas of what needs to be put in there so we get confidence that the paper system is one that will do the job?
Yes. Thank you, Senator. First of all, let me tell you that Broward County DS-200 we're talking about now. We're talking about the last 4 election cycles. They've been using the DS-200, which is what's in SB 9. And so all the fiasco with Broward County in the November 18 election was with the DS-200 system. So it's not going back to before that with the hanging chads. We're talking about current modern day problems with that system. Okay? So yeah.
I would suggest there that that is more of a problem of the people that live in Broward County and what's being done than the equipment itself. I mean, they've proven themselves over and over again of how they're going to handle elections, and that's an example of what I'm talking about. When you have a system that doesn't have, the machines themselves will not do this job. That's why we have several other modifications that are coming, not just in this bill, but other bills that will change the way we're doing. Processes and procedures are going to have to go with this. We cannot rely on the basic honesty of everyone to do the right thing. We have to make it as difficult as possible for there to be mistakes and fraud. And believe me, I mean, changing the outcome of an election due to mistakes is just as serious as changing it as a result of fraud. And that's what we need to tighten up on. So it's not just adding equipment with no other changes. There are other changes that need to go along with it so that we make it as difficult as possible to do it.
We just came to be on the record that the solution you brought us in section 5.02 of SB 9 is Broward County and not acceptable to us.
Okay, understand. I think Senator Hughes or any of us who are working on this, working on it, would welcome your suggestions on what to do, how to tighten that up.
Thank you, members. Any other questions? All right, Mr. Miller.
Good afternoon, Jeff Miller, Disability Rights Texas, and we are testifying in opposition to the bill right now. And a lot of the reasons have to do with some of the things that Chase talked about earlier. We really believe in what you're trying to do here and think that integrity of the process and security is really important, but so is accessibility for voters with disabilities. And we think that there's some tension in some of the sections because it's not really clear that the rights that people have under the Voting Rights Act, Section 248, which gives people that with disabilities that need assistance, the right to choose the person that assists them. That and the Americans with Disabilities Act, some of the provisions around access to the polls there, we believe that there needs to be some language in some of the sections that specifically reference those rights so that people don't lose that ability to vote independently because it's so important for the people that we represent. One of the other things I'll just mention real quickly is that in the provision that talks about a poll watcher being able to observe someone that's assisting a voter, I understand the intention there, but unless we really focus on making sure that poll watchers and poll workers have the training that they need to understand what assistance looks like. Because assisting a voter with a visual impairment or with deafness is much different than assisting a voter with an intellectual disability or autism. And so the kinds of questions that are asked or the ways that interaction will look different, and a poll watcher that hasn't been exposed to that may draw some conclusions that aren't necessarily true. And just finally, I will end by saying, as far as the DRE system goes, we think it's really important to ensure that whatever systems were used, even with a paper trail, that we continue to have accessibility by people that have visual impairments or need the other electronic parts of the machines that we now have. And we look forward to working with your office to look at the language.
Members, any questions?
Chairman.
Senator Hughes.
No, thank you. Of course we'll work with you on it, and you're right, you get it. The bill is aimed at those who would abuse the rights of the disabled to cheat. And so you get it. And so we sure don't want to do anything that's going to harm the rights of disabled folks to have full access to a private ballot when that's possible. If not, to get all the assistance they need and are entitled to. Of course, we'll work with you on that. Thank you. And Mr. Vera, thank you. The thought of being opposed to you on anything makes me real nervous, and I hate it, but I'm sure we'll get this figured out. Thank you, Mr. Chairman.
Members, any other questions? Okay, thank you. Appreciate this panel. Okay. Okay, Senator Hughes, would you still like Mr. White, Jonathan White, with the election fraud section of the Office of the Attorney General to come up as a resource witness?
Subject to the pleasure of the chair, I'd sure like that.
That'd be great. We'll ask Mr. White to come forward. So we may get through this panel and then just ask Mr. White if he would be available.
Thank you, Mr. Chairman.
Does that sound good?
Very good.
Yeah. Okay. So at this time, the chair calls Mary Smith, Cindy Weatherby, Tom Glass, and Crystal Main, along with Lynn Foster. And we will start with Ms. Smith.
Good afternoon. My name is Mary Virginia Smith. I am here representing Concerned Women for America, and I am the North Texas Director of Concerned Women for America. And I'm here speaking in support of Senate Bill 9, the election integrity. As a representative of CWA, we are very concerned about the integrity of our elections. As you know, for the last 4 years, Texans have been made very aware that the integrity of our elections has been jeopardized. There have been cases of prosecution for illegal voting, mail-in ballot problems, and election irregularities and total votes exceeding registered voters. And we are very concerned about this, as you are, and we appreciate the work that Senator Hughes' office has done and the research that he has done. We support a voter verifiable paper audit trail, as has been mentioned several times this afternoon, to ensure votes is counted as expected by the voter. We think that's very important. We support statewide audits done randomly to confirm that electronic systems are recording votes as voted. We support prohibiting pre-checking boxes simply affirming eligibility to register without official documentation and official identification. We support information about the voter relationship between a voter who requires curbside assistance and the person assisting the voter and the reason needed, as has already been discussed during this period of time. We support disabled voters being able to vote an absentee ballot by mail, but just checking a box does not make them eligible through the legal code. So, to be fair and honorable to each and every voter, every means must be taken for the protection of the voter and the protection of the vote in our state. Thank you.
Thank you. Members' questions? Okay. Appreciate that. Go ahead, sir.
My name is Lynn Foster, and I'm here to support SB 9, especially the addition of recording capability for watchers. I have been a central count watcher in the past 3 years, and that experience has shown me we need a recording capability to document potential crimes when proper procedures are not followed. The only current recording device is a pen and paper, and then it becomes our word against theirs. Our being the watchers and theirs being the party in power. Having a recording capability would also give us the ability to zoom in on computer screens, which I have found in my experience is difficult to see when you're 5 to 10 feet back from the screen behind the operator. And that's all I have to say right now.
Thank you. Members, any questions? Mr. Glass.
My name is Tom Glass. I am in favor of SB 9. I'm testifying on behalf of myself. I have a number of experiences that inform my testimony. I've been a poll watcher both at the precinct and central count level. I have trained people on poll watching. I have an IT career focused on security controls. I'm an attorney. I had a group called Texas Election Integrity that watches these issues, and I filed an amicus letter for Laura Presley's election integrity case with the Texas Supreme Court. This bill solves many of the issues raised in that case. I would say that the number one benefit of this bill is the auditable voting system phase-in that is described, which I think is the key to many of the lack of integrity and trust that we have in this system. I also support the poll watchers being able to record proceedings. I've just handed you a handout which talks about, gives a visual description of all the different ways that electronic systems can be compromised and how cast vote records do not do the trick to do a count. It's more detailed than I have time to talk about, but I wanted to make sure you had it. One thing I will say is that election integrity, like health, is an absence concept. Election integrity is the absence of successful corruption. Health is the absence of disease. Just like there's many diseases, there are many ways to corrupt. In my answer to a man who I respect, Alan Vera, on the corruption of the paper system, is that all systems can be corrupted. The beauty of the auditable voting system is you have two independent pathways that have to be both corrupted to be able to be successful. And that's the beauty of this system. And of course, we do have in place the traditional systems for poll watching to take care of the paper ballot systems. I'd like to take questions on the risk limiting audit procedure if anybody wants to ask that question.
Members,
Yes.
any questions?
Mr. Chairman?
Senator Hughes.
Yes.
Thanks for sharing your experience here. Tell us about risk limiting audits that we need to know.
I greatly support the idea of comparing at the precinct level, which is what I understand this does. Precinct level, the electronic results versus the paper results right there on site. That's a beautiful concept. One thing that I worry a little bit about is doing it on a statistical basis. I understand in the large early voting locations or maybe countywide voting locations that might be necessary because the volume to count is so high. But I trust actual counts much more than I do statistical. I would say there's a problem when you do statistical is you've got to have some smaller units by which you compare to do a statistical analysis. That means that the voting number that we have in the Constitution in Texas that has to be applied to every deal probably is going to be very important because that number will have to have information about how it's tied to a particular part of the system, like a JBC, a job booth controller, or an individual thing. You've got to do that in a way that doesn't compromise voter secrecy, but you've got to have some sort of link on that or the statistics won't do. And I would, to the degree that you can actually do a count in the precinct levels, the real count as opposed to doing statistics, I would trust that a lot more than statistics. And if you're going to do statistics, it's going to be a tricky thing to get done. I haven't seen the committee substitute and how you've addressed it, but it's difficult. But the concept is fantastic, and if you can do it without the statistics and just do actual count, that's the best.
Good.
Yes.
Makes sense.
Yeah.
Thank you. Thank you, Madam Chair.
Thank you. Crystal Main, have you testified? Because I'm a little confused with the cards.
My name is Crystal Main, and I am testifying in favor of SB 9. And I am strongly in support of getting this in place just as soon as we can. It needs to be by 2020. We can't wait because election integrity is everything. When I cast my vote, if I don't know that my vote is being counted properly, then I may as well not vote. And where I lived in Dallas County, I was always able to go on election day in order to be able to cast a paper ballot. And I made sure I did that. I never voted in early voting because of that. Where I am now, I don't believe that's available, and that's quite disturbing to me. Of course, that doesn't mean that other people's votes can't be manipulated other than mine. But with the paper ballot, with the combination, the way you're doing it, it allows for it to be counted. The ballots can be counted electronically, but if there is a concern with how the system is counting, because that system can be compromised, then you can always have a paper ballot that you can go back and check, and you can count them manually if that is needed. So you have another check against the system that's being programmed to do this. When I cast a ballot on the machines like what they have in Dallas County at the moment, I can select it, but I don't know once I confirm and submit it that there's not a program in the background that is doing something else differently with my vote. And so with the paper ballot, I have assurance that there is a way to verify that it's voted the way I want it, my vote counted.
All right, thank you. Any questions? All right, Cindy Weatherby.
Thank you, Madam Chair and members. I'm Cindy Weatherby, testifying as a member and on behalf of the League of Women Voters of Texas. In opposition to Senate Bill 9, I'd wish to come here before you today and support all the good things in the bill, but there were more bad things that we were on record in our positions as being able to support. I do look forward to seeing this committee substitute, and my comments here today are based on the bill as it was originally introduced. Chairman Hughes and members, Senator Hall, Senator Zaffarini, who served on the interim select committee, we really appreciate your work, and we can tell you've done an awful lot of that. We agree our election systems must be renewed, and it was very encouraging to hear your opening remarks about the improvements that you're making in the bill on the election equipment and security processes, and the additional requirements for paper trail election equipment and risk limiting audits are at the top of our list. Due to the limited time that I've got here today, I've given you a written testimony. The one thing I want to use my time for is to call attention to your intent in section 4.02 for cross-checking our voter registration rolls with other states. And we don't believe that that we must provide the social security numbers and dates of birth of our voters, and could be better done by participating in the Electronic Registration Information Center, otherwise known as ERIC. And as I understand it, ERIC uses encrypted voter registration information from partnering states along with Social Security death records, duplicate voter registration, voters who move, and eligible voters not yet registered.
Thank you. Let's see, Lynn Fosher, you testified? No? Okay. Has everybody testified there? Okay, great. Thank you. All right, let's call up. Yes, which one do you want? Jonathan White? And we can go ahead and call up, oh, they already did? Okay. All right, Terry Harper. You can just be waiting to come to the table. Glenn Maxey, Don Dixon, Rick Briscoe, and Michael Openshaw. And Mr. White, I believe Senator Hughes, do you have a
Yes, thank
question?
you, Madam Chair.
Yes.
Mr. White, thanks for being here. The bill increases penalties because these are pretty serious offenses. We had an inquiry about the level of the offense, whether these penalties seem appropriate. Give us some idea about the penalties in this bill and how they compare to like crimes that already exist, please.
Yes, sir. Jonathan White with the Attorney General's office testifying on the bill. And the penalty increases in this bill are state jail felony level. For the registration fraud offense, that is a federal offense, that is a federal felony. That's a felony where you serve actual day-for-day time in federal prison. State jail felony in Texas is kind of a hybrid offense between a misdemeanor and a felony. It is punishable by time in state jail, but if you don't have previous felony convictions, probation is an option. So for the offenses in this bill, it's in line not only with other election code offenses, which are similar for false statements, false information given in order to, perpetuate some type of fraud on the system, whether it would be for mail-in ballot application fraud or the fraud involved with a false statement on a reasonable impediment affidavit. State jail felony level matches on all of those offenses, as well as penal code offenses for similar types of crimes involving false material statements.
Thank you for that. Let me also ask, with regard to the offenses that are addressed in Senate Bill 9, would you agree with me that they each have an intent requirement? This is not about negligently checking the wrong box. They have an intent requirement before one can be held accountable. Is that your understanding?
That's correct. The fraud or the fraudulent statements must be made with the intent that with the knowledge of the falsity of those statements and with the intent that they be, used to produce a ballot fraudulently or whatever the case may be.
Thank you. Thank you, Madam Chair.
Thank you. Okay. Are those all the questions of the resource witness? All right, Mr. White, you can leave if you'd like to. Terry Harper? Terry Harper, that's you? Okay, sorry, take your time. Okay, Mr. Harper, go ahead.
My name is Terry Harper, and I will speak briefly for the Republican Party of Texas, followed up as an individual. I would like to make note that in the platform of the Republican Party of Texas, planks 188 through 202 address various election issues. That is 15 planks. 5% of the Republican Party platform address election issues, particularly election integrity. Speaking as myself, I would like to encourage each of you to support this bill. Election integrity is of the utmost importance to our American way of life and must be preserved. Without fair, law-abiding elections, our future is in grave danger. Our country is based on the rule of law and the fear of punishment. This bill performs both law and punishment. Thank you for your time.
All right, thank you. All right, Glenn Maxey?
Thank you, Madam Chairman and members. I'm Glenn Maxey with the Texas Democratic Party. We've registered in opposition to the bill at this time, Mr. Hughes. I would much prefer that this bill had a number of issues such as online voter registration, where the vast majority of new people registering in Texas would be vetted through the Texas driver's license, that we would know that they're citizens, or proposals like House Bill 704 by Synfronia Thompson that would bring the renewal of vote-by-mail applications into a county function. The abuse in vote-by-mail is happening when people go door to door and are creating relationships. If we had every 2 years the county renewing these applications, probably 90% of people who vote by mail are the same people from election to election, and that would cause a lot of solve a lot of these problems. We are very much for the ending of the DREs without a paper trail, the audits, many good things in this bill. There are a few places where I'm concerned about just some sort of vagueness, things like where it says any election official responsible for the integrity of the voting rolls. I'd like to see that spelled out, who those people are. In the place where we have the things about immunity for law enforcement to do these things like the sting operation kind of things, I would like to see that those people are spelled out who can do that, so we don't have entrapment of voters. I'll be glad to work with your staff on these kinds of cleanup things or things making things more clearly. And clearly in Section 403 about the voting centers within 3 miles, have no clue what that means. And I think there are better ways. If we're looking for even distribution, we can fix that in a much more efficient way.
All right, thank you. Don Dixon?
Thank you, Madam Chair. My name is Don Dixon. I'm speaking for myself, and I'm speaking for SB 9. The very basic of good government in Texas is the trust of the public. And the trust of the public is centered on how the integrity of the vote. So it is absolutely imperative that the state of Texas make sure that every vote is counted correctly and that every vote is a legal vote. And I believe this bill addresses a lot of that. There's been things in the paper like, well, if this passes, it's going to affect one party maybe more than the other, one direction or the other. Everybody's vote should be protected regardless of the party. So look at it this way. You're a conscientious voter. You studied the issues. You voted. And somebody that wasn't supposed to vote possibly could have voted and canceled your vote. This must be corrected. This bill is a good way to get this done. Thank you. Be happy to answer any questions.
All right, thank you, sir. Rick Briscoe?
Madam Chair, members, thank you. I am Rick Briscoe, a resident of San Antonio, Bexar County, Texas. I wish to associate myself with the earlier remarks regarding the necessity for the availability of timely remedies. A right without a remedy is no right at all. I had an extended conversation with the Harris County Elections Administrator last summer regarding the machines they're using over there, and simply put, without machines similar to those specified in the bill, you have no assurance whatsoever of the accuracy of a vote. Why? You can't recount it. The electronic vote's going to be the same every last time. If you have a failure of a machine, I observed one as a poll watcher, that a machine somehow or other lost a handful of votes. The election official properly documented them, and fortunately it was a small enough error that it did not affect the outcome of any election. But if you've got paper ballots, you've got a backup. It also helps prevent fraud because, as was pointed out earlier, you have to have the systems match. We ran a total of voters who signed in against votes cast on the machines. Not surprisingly, there were a couple of errors. There are humans involved, but nevertheless, they were small. We must do something either like this or what this bill specifies as a building block for election integrity. Thank you.
Thank you, sir. Michael Openshaw?
Yes, my name is Michael Openshaw. I'm testifying for myself, and I'm in support of this bill. No system, whether electronic or paper, is without flaws. I date back to being an election judge in the punch card days. You could take a stack and shake them like this and get the numbers to change. Yeah, and you won't have a situation with electronics where all the punch ballots and the blank ballots are in unlocked boxes in the back of a county chairman who was just defeated at the polls either. So having two checks ongoing is good because neither one is perfectly without issue. I would say the 1,000-foot attribute here to this bill is maybe a little bit excessive. If you're going to do a committee substitute, I'd suggest something about 300 feet. We wouldn't want to get in a situation where you're having a lemonade stand interfere with a voter, and the election judge say that it's interfering with voter access. Okay, the lemonade stand 2 blocks away. Get conflict of bills going here, but this is a good first attempt. You're not going to be able to fix everything. The use of the machinery by Broward County, defibrillator can be used to save somebody's life or can be used to electrocute somebody. Broward County chooses to electrocute their voters with their machinery. The machinery is not at fault, the people are. So people are always the issue. And this bill, while it helps, will not solve the people issue. Are there any questions?
Thank you, sir. Okay, thank you very much to this panel. We'll call up the next panel. James Slattery, Joaquin Gonzalez, James Keller, Robert Caples, and Dr. Laura Presley. All right, Mr. Slattery?
Yes.
You can go ahead.
Thank you for having me. My name is James Slattery, and I'm a senior staff attorney in the Voting Rights Program at the Texas Civil Rights Project. SB 9 contains a number of alarming changes that would impose substantial and unnecessary new barriers to voting. My testimony will focus on just one particular provision, which would bolster an ongoing campaign of selective criminal prosecutions like that of Crystal Mason in Fort Worth. Section 1.05 effectively eliminates the intent requirement in certain election-related offenses. If enacted, voters could be thrown in jail for making an honest mistake in the voting process. such as trying to vote at what they incorrectly think is their polling place. We know this is a real concern because of people like our fellow Texan, Crystal Mason, who went to vote in 2016 as part of her civic duty. She believed in good faith that she was eligible to vote, but could not in fact vote because of a prior conviction. For that honest mistake, she is now serving a sentence of 5 years in prison. She's far from alone. 9,608 Texans in the 5 most populous counties cast provisional ballots in November 2018 that were rejected because, like her, they mistakenly thought that they were registered to vote. Section 1.05 would expose Texans like these and more to prosecution by eliminating any need to prove intent when prosecuting election-related offenses and by eliminating provisional ballots as the safe harbor they were intended to be. We should be empowering our fellow Texans and making it easier to vote, not frightening them into staying home on Election Day with the fear that a politically motivated prosecutor may send them to jail for an honest mistake. Thank you.
Thank you. Any questions? Okay. Joaquin Gonzalez.
Hello, my name is Joaquin Gonzalez, also with Texas Civil Rights Project, testifying in opposition to 2 other provisions of SB 9 that would loosen safeguards protecting voters' private information. Section 4.01 would expand direct, instantaneous electronic access to the statewide voter registration database to any official responsible for ensuring the integrity of the voter rolls or compliance with the election laws. This is a broad category that could include any number of individuals with only a tangential role in elections. All relevant government officials already have sufficient access to voter information from the Secretary of State's office without having to broadly expand direct access to the highly sensitive electronic database itself. As infiltrations of state and county voter databases in recent years have demonstrated, these are vulnerable systems. Colonel Schaefer testified about how any digital program is vulnerable, but these risks are exponentially magnified when you allow broad access to a networked system. The bill in Section 4.02 would also allow for disclosure of voters' social security numbers and dates of birth to other states and jurisdictions. This appears to be an attempt to participate in the discredited and largely defunct interstate cross-check program. This program was halted because it failed to maintain the security of sensitive voter data, and there are more reliable systems such as the ERIC system, but these changes to the bill would not facilitate participation in that program.
All right, thank you. Any questions? No. James Keller.
Yes, I'm here in support of this bill. I have observed central count in 3 Hays County elections. I watched close up and personal while Hays County election workers connected incoming electronic voting equipment to a laptop prior to removing the memory card and loading the votes onto the central tabulation computer. So I asked them, has that laptop been through a logic and accuracy test like the big computer? And they said, no, it doesn't count votes. And I responded, yeah, but it could have a virus on it. It could have malware on it. Why are you connecting it to this machine that has the incoming votes? And they said, well, we're not going to change anything. So this is a problem where electronic voting systems basically have, we must have paper ballots to have any kind of credibility restored to the system. I've consulted with some senior engineer from IBM and a systems engineer from IBM. And by the way, as far as having access to that computer, it's not just wireless communication we have to worry about. It's also data over power line. I asked one, he said, well, you know, all they have to do is put a modem in there that connects to the plug-in, you know, your power plug of the main computer. So we need to To be clear, that laptop could have been altered without the knowledge of anybody in that room. We don't have to worry about just Russians. We need to worry about people in our own counties. It's worth millions and billions of dollars. How much is a city or a county or a state election worth in dollars? Think about all the contracts, and all the contractors have a huge stake in the outcomes of these. Surely there are bad actors who would love to have somebody in place or even next door operating through the power cord to change the elections. Thank you.
All right, thank you. Next, we have Robert Caples.
Good afternoon. My name is Robert Caples. I'm the commander for the Stark County Special Crimes Unit. The district attorney covered most of the things that we've experienced since January of 2018, but my team and I are the ones that were actually on the ground investigating a lot of these cases. A lot of the things that we found were that, and this goes back to the assistance issue, we found that people were being told misinformation. They were being manipulated by campaign workers. Every single person that I spoke to had no idea that their mail-in ballot application had been marked with a disability. One of them was a rodeo cowboy, and he had 0 disabilities. Another one was a firefighter, a jailer, a nurse, providers. And we also found that they were being told to let the campaign workers know to come back when the mail-in ballots were in, the actual ballots. And they were coming back and picking them up. And they were taken off with them. And when I asked these people, do you know what they did with them? They said, well, they were supposed to go put it in the mail, I guess. Which is another violation of the law because they had not actually marked anywhere that they had done so. So all we've seen in our investigations are manipulations, misinformation, and I know people have said that it's up to the voters at the end of the day, but I think that that's a really bad idea because the people who are doing the manipulation are the campaign workers.
Senator.
Commander, thanks for your testimony. Thank you for doing this. We know that in law enforcement, from your standpoint, and also with prosecutors, have so many crimes to be concerned about, violent crimes, property crimes, often election law violations. As important as they are, there's just not the resources. There's not the decision to commit the resources. So thank you for doing it. And what you've done is really opened the eyes of a lot of us to what's going on in all of our communities. Let me ask you this. These election workers, and we're talking about, by that I mean campaign workers, right? Paid campaign workers who come to these folks' homes, especially the elderly. Did you ever find cases where the voters who were being visited by these political workers, where the voters thought these folks were official election workers from the county or from the government, had some official role?
That is?
We had some cases where they believed that they were official workers. But even the ones that didn't, because they were working with the elections, they expect these folks to be knowledgeable about the laws. So if they were come to their house and say, hey, how would you like to vote by mail? That way you don't have to take the time off work or do anything else. You don't even have to drive over there. The answer is always, yeah. What do I need to do? Just sign the form and I'll take care of the rest. So in every single case that I saw, none of the voters actually filled out the mail-in applications. The only thing they were required to do was to sign their name to it. And, I ended up with there's a stack about that big on my desk. And I could randomly pick any application out of there, which is how we worked it. And we did that to avoid the implication that there's, targeting, a particular site or whatever. So we randomly selected applications, and every single one of them was illegitimate that I've encountered. 100%.
Man, thank you for the investigation. Thank you for testifying. Thank you, Madam Chair.
Thank you. Okay, Dr. Laura Presley.
Yes, hello. Senator Huffman, thank you for this meeting and bringing this bill forward to the committee. And thank you, Senator Hughes and Senator Hall and other senators on this and moving this forward. I'm the founder of True Texas Elections. I have a PhD in chemistry and physics and spent 17 years in the semiconductor industry where I was a manager and an engineer, and I have 4 patents on computer technology. I'm also a member of the Grassroots America Coalition that supports Senate Bill 9. This Senate bill, and Mr. Tom Glass said it very well, this Senate bill really addresses all of the issues in our Texas Supreme Court case that was pending for about 4 years across the state, and I've given about 275 presentations around the state of Texas on these issues. And I really support, the audible paper trail. One thing that Mr. Vera brought up that I'd like to address is we are very different than Florida. Florida does not number ballots. They don't have the state constitution that we do. And so you can bring in a whole bunch of paper ballots in Florida and bring a whole bunch out, and no one knows where they went. Here in Texas, they have to be uniquely numbered according to the Constitution, and that is really the power of a paper backup and the power that Texas Constitution secures for the voters here in Texas. I'd like to also support the watchers that are allowed to start recording and taking pictures and audio. One thing I'd like to add, Senator Hughes, is that you add not just the polling location, but ballot board, central counting, and for recounts. I've trained about 30 different counties around the state on central counting watchers, and we've seen some very concerning things all over the state. The other thing I want to support is Senator Hall's request for zero and tally tapes. The zero tapes have to be there, not just to say that the counter has 0 ballots, but that every candidate has a 0 ballot value, because you can have a plus 50 for one race and a negative 50 in another, and you get a 0 sum. You have to have the complete 0 tape. And I'm here if there's any questions.
Senator Hughes?
Thanks, Madam Chair. Dr. Presley, thanks for this, for your work on this and on all these matters. Let me ask you in particular about watchers.
Yes, sir.
And have you yourself been served as an election watcher?
I have. I was a central county, I've trained probably 50 watchers around the state in the last 3 years. I was a watcher in Travis County, and what's been reported to me and I've observed where watchers are obstructed, they're not allowed to see and monitor any activity going on. And I've personally in Travis County seen the elections supervisor, the tabulation supervisor, delete election data on the computer. I observed it myself. Multiple watchers observed it. We asked, why did you delete the data? He said, because it's confusing. My understanding is a state jail felony to delete data for elections. So we've observed very concerning things all over the state. Dallas County, San Antonio will not let watchers in. They will not let them observe. Dallas County has escorted watchers out when stuff is going on, according to the audit logs. This is a big issue. Watchers are there to document a crime.
Yes.
They're not there to prevent one. They're there to document it, and I applaud you for allowing them to be able to document it so it's not a he said, she said.
That's right.
Thank you.
Thank you. Thank you, Madam Chair.
Thank you. All right. I think, yes, Senator Hall, I'm sorry, go ahead.
Madam Chair, just real quick, what you talked about with what Senator Hughes was talking about, and you said about that we know that things have been happening that are illegal.
Yes, sir.
Throughout the system.
Yes.
But we have a system in which it's incredibly difficult to document or gather data
Yes.
on these things that are happening like this in order to be able to follow through and prosecute. It's not quite like what you have found with the mail-in ballots, where you can go through and you find, or someone shows up that there were assistants for 120 people by one person. That's a little bit different. But the things you're talking about that I've seen described to me from poll watchers, where the judge would say, okay, watchers, you can be in the room, but they put up a screen between them and the people who are actually doing the counting. And they said, we've met the legal requirement to be in the room. You can't do anything about it.
That's right.
And that's just one example, but there are others of what you're talking about, that people that do stuff when nobody's watching, and so you can't record anything, you can't take a video, you can't take a photograph, you can't take any paper out. So one of the challenges we have is getting a system so that when things are done improperly or illegally, that there is evidence that can then be used to prosecute. And that's probably going to be one of the biggest challenges we have, is in order to do that. Because we can have all the laws in the world, but if it has a void where you can't get your hands on the data or information that would verify that it was happening, is going to be very difficult.
That's right. And, you know, central counting is one of the most important places, ballot board, all of it. Here, you know, people are not casting their ballot in those locations, so there should be the disinfectant of light that says, you know, we're going to be able to record, and hopefully that will prevent crimes, Senator Hall. You know, it takes a lot of effort to prosecute a crime, but if you can prevent it by observing and being able to video and take sound, audio recordings, I think it's going to prevent a lot of fraud that potentially is going on.
Now you're distinguishing. You're talking about in Central County, not at the polls,
not at the
where
polls.
people are, which I think everybody agree we don't. That's very private, and we keep it that way. But when you get to Central County, everybody in there is in a service role. They're in there in a trusted role that they have taken to work for the people, to do what needs to be done as a part of having a secure election system. They have a job. They're there performing a job. So there is nothing that should be performed.
They've taken an oath to honor the rule of law, yes.
So it has nothing to do with how anybody votes in any way at all. Are now they doing their job correctly in assembling the data that will give us the results of what the people had wanted when they stepped into the polling booths. So there would be no reason not to have a comprehensive recording of what's taking place. That should be done in the bright lights shining and recorded, so that when people know they're really being watched, they tend to behave differently when they think they're operating in the dark. So would you agree with that, that one way to clean up and reduce the opportunities for mistakes or fraud in Central County would be able to have video recording of what's going on?
Absolutely. I think it's absolutely crucial.
Is there any other way that we could actually document fraud in there that you could think of without the recordings?
I think that's your strongest bit of evidence. And, you know, what we've observed, I have trained 30 to 50 counties around the state, and we have seen watchers. I was personally escorted out of Central County when the early vote was being tabulated, and the law says it's a criminal offense to obstruct a watcher. I experienced that myself. If I could have taken a video of us being escorted out, we were not allowed to come in. Votes were being tabulated and logic and accuracy testing was being done when we were not allowed to be in there. The audit logs showed it. We have evidence of counties that have internet connectivity going on when votes are being tabulated. This is not acceptable. We're violating law left and right at central counting. So we cast our votes at the polls. But guys, what the bottom line is when we count the votes. When we're counting the votes, we need to have the best security and the best processes and following law.
I think it was Stalin that said, I don't care who votes or how many times they vote. I just care who counts the votes.
That's right, Senator. Senator Fallon.
Well, you got to step up your game,
Look
man.
at this.
Step up your game.
Excuse me. Y'all need to
Okay,
wait
sorry
to be
about that.
recognized. All right.
Distraction.
Senator Fallon, did you want to enter? You may. Recognized. Just don't talk.
No, thank you. Sorry. I talked out of line.
Anyone else? Questions? Senator Hughes? All right. Did I skip you, sir? Or did you everybody's testified?
Yeah, God bless you, every single one of you. You're doing God's work. Thank you.
Thank you for being here, Ms. Presley, Dr. Presley. Appreciate it. Thank you to the panel. All right, we'll call up the next group. Todd Key, Bill Sargent, Fatima Menendez, Adam Kahn. Oops, skip someone, hold on. And Ed Johnson. Mr. Key? Go ahead. Thank you, sir.
Is this on? Okay, there we go. My name is Todd Key. I'm here representing myself, and I'm testifying in favor of SB 9. There's a lot of evidence of voter fraud, many types, and it's disheartening to know that when I go cast my vote for candidate A, that it might actually tally for candidate B or candidate C. I fully support going to an offline computer-generated voting system that creates a paper ballot so that we do have a paper trail so that a count and a recount can be established without having to worry about cyber attacks. This bill also, we need to increase civil and criminal penalties, and this bill does that. And I appreciate this committee and Senator Hughes for bringing this bill forward. If we don't act on this now and get this in place for 2020, some of you people on this committee and others in the Senate and House can very well be ousted by stolen elections, and that is troublesome to me. It's just something we've got to get this fixed. I mean, there's some things that this bill doesn't address, but there are other bills out there that are going to clean up these elections if we can get them passed. Finally, what y'all just said about the quote from Joseph Stalin that says the people that cast the votes decide nothing, the people that count the votes decide everything. And that's what this bill does, is corrects that problem. So I appreciate you guys.
Thank you. Okay, next, Bill Sargent.
Before I start my testimony, before you push that button, I'd like to say that I've submitted a written testimony. I would ask that be included in the record.
Yes, sir, it will be.
Okay.
Yes.
I'm Bill Sargent. I was a former election administrator for the Republican Party of Galveston County, also the chief deputy clerk for elections for Galveston County as well. Senator, there are a lot of good things in this bill, and I've mentioned them in my written testimony, so I'd ask you to read those. And there's some good things that can be really improved as well. But I oppose this legislation for one reason. It's the subchapter C, which has to do with DREs. My experience is this: we're seeing the hype and the hysteria up here when the reality is down here. You're dealing with machines that are DREs that are not, and the equipment that's actually programming the ballot that is not connected to the internet. It's not connected to any network at all. It's standalone. It has no wireless capability. There's no modem in the room where it is. In our case, we required 2 people to be in the room when anybody was in that room to program the ballots or tally or anything. So you had complete security for it. The equipment has the ability to differentiate the data cards, the MBBs, between one election and another. So if somebody were somehow to change a card in the machine, that machine would know immediately that card was not legitimate, and would also say that you could not, it wouldn't count it. Like, for example, when you have a ballot that's from a different election, like a local election versus a primary election, and somebody sends in the wrong ballot for a ballot by mail, it'll kick it out. All right. The equipment also has the redundancy in it, so that if there's an issue about how many votes were cast and what it was, you can go back and check it. So you have that capability. And the HEART system, Madam Chair, people who testified earlier in support of this bill were given up to 5 minutes. Can I ask for a little extra time?
Well, I'll tell you what the difference was, Mr. Sargent, with all due respect. Those were invited witnesses that had been invited by the author of the bill. And also, I wasn't chairing, and so I wouldn't have let them go on as long as
I've got about 30 seconds. Can I finish?
But if you have 30 seconds, you can finish that up. Yes,
the equipment has been verified, been tested and shown to be secure by the federal government. My recommendation is you might want to have someone like Keith Ingram from the Secretary of State's office, who's here, to come and talk about what his experience has been with problems with the machinery. No disrespect intended, Senator, but I can't see why anyone would want to put subchapter C in this bill and mess up a really good bill. If you take that out of there, I'm 100% behind you. But until that happens, I cannot support this legislation. Thank you for your time.
Thank you, and thanks for offering your expertise, Mr. Sargent. Senator Lucio.
In your county, what would you say the conditions of your...
I'm sorry, having a little hard time
in
hearing.
your county, where you, Galveston County?
Yes, sir.
In your county, what would you say, how would you rate the equipment that is used for elections? Are they up to date? Are they up to date equipment? Is it antiquated? How old is it?
They just finished purchasing new equipment from Hart Intercivic, but when I was there, the equipment they were using was completely safe. I mean, you had, when it was programmed, the MBBs were put into the equipment was sealed, and if anybody broke that seal, there was all hell to pay. So we knew that no one was going to deal with that. No one was going to went out to the field. It was verified to make sure that the seal was the right seal and the right piece of equipment. When it came back, that was also verified. When it came back upstairs, we verified it when we were ready to tally to make sure that was the case. That was the same equipment. We always had 2 people with that equipment when it was there. When it was programmed, it could not be. We didn't have. We were not connected to any network. Now, there was a statement here earlier about running. The tally tapes and the zero tapes at the polling location. You're looking at the poster child. I made national news, November 2012, excuse me. Our polling places, every single one of them, opened up 2 to 3 hours late because we ran, in a countywide vote center election, we ran the zero tape. We had to run over 16,000 zeros to verify that the machine had nobody to vote on. No one had voted on it. 16,000 tallying. If you did that with a tally tape, you're talking another 3 to 4 hours before the vote can be returned to the polling central county to be counted. We invited, since then, we've been doing it in the warehouse. And we've invited the Republican and Democratic Party to come. We've invited the public to come and witness it. Not one person showed up, and every time we've done that. And when we ran the same tapes for the tally tapes afterwards, same thing. Nobody showed up. We asked them, we invited them, we encouraged them to come. Not one showed up.
Why do you think no one showed up? Why do you think no one showed up?
Because either they were not interested, or, I don't know why they didn't show up. But
they trust the election were fair?
They trusted that what we were doing was right. And I built my reputation on integrity and integrity of the voting process. And I can tell you that we have never, ever, and when I was there, done anything that was, not correct.
I think regardless of party affiliation, the people that I've dealt with over my 40-something years in politics want fair elections, no matter who you are. They want fair elections.
Absolutely.
And I guess where I'm going with this is we also want to make sure that if the state or the federal government tells us at the local level we need to do it this way, but you have to pay for it, we need some help down there. And that's where this comes in. Besides some of the other testimony that's been turned in by people with special needs. But how do you feel about that? If the state passes a bill that creates a mandate for the cities and counties and local units of government to have to pay to get an upgrade on how they handle their elections, would you support that?
Well, Galveston County paid $3.5 million to get new equipment within the last 6 months. Okay? If they have to retrofit it, it's going to be a whole lot more expensive on top of that. If you require what's under this bill to take place, you're looking at somewhere in excess of $150 million. That's going to be a mandate to be done. My question to you is, will the Senate and the House and the governor sign a bill with all this issue about taxpayer relief from property taxes, will they actually be appropriated? If not, you have an unfunded mandate. The counties can't do this.
And that's what I personally think, that any upgrade in how we handle our elections for the good, for people feeling good, for elections to be sound and fair, we should pass. But we also should give you the tools, the money to be able to, pay for it. I would hate to put this burden on the local units of government. That's a big problem with me, because many of them can't afford it.
You're my kind of guy.
Thank you.
Senator Hughes, did you have a follow-up question?
Thanks, Madam Chair.
Yeah.
And I think you guys talked about this before, and thanks for your testimony. And we know you know what you're talking about, and your input's obviously really important. On the money, and I would say this for Senator Lucio's question as well, under the bill, for those counties that have bought new machines since September 1st, 2014. So if you bought a new machine September 1st, 2014 forward, the intention of this bill is for the state to provide money to pay for the upgrade, to pay for the conversion. So for those folks who have recently bought new machines that don't comply with this, the state would take care of the retrofit.
So any counties that have machines prior to 2014 would have to pay their own way.
And under this bill, they're given a little bit longer to get new machines. The thinking is they get these around every 10 years or so. That's what folks tell me. So the thinking was they get new ones around every 10 years or so. So if folks have already bought new ones recently, we want to take care of that.
So how many out of 254 counties fall into that category?
So if we go back to 2014 and we go from there forward and pay for that retrofit, we are taking care of about 60 to 70% of the voters in the state. Those are the big counties and the medium-sized counties. And so we have a little longer to pick up the smaller counties. And Senator Hall has a budget rider that would buy new machines for everyone. So if that happens, it'll take care of even the small counties. But under this bill, all the large and medium-sized counties would be paid for by the state. Now, many counties have already bought new machines, and they've bought, as you know, they've bought these voter-verified systems. But those that haven't, we would pay for the retrofit.
Senator, I'd feel a whole lot more comfortable if you put in this bill that says we are appropriating in excess of $150 million to the counties.
The number
doesn't do that. It says,
actually, you're a little low. It's going to be about $200 million, and this is not the appropriations bill, but we have it taken care of. Thank you, though.
Yes, sir.
All right, thank you. Yes, sir.
Thank you, Madam Chair. Just a couple quick questions. I think many of us have seen, I remember seeing it on Facebook and reading reports about folks saying that they chose someone on the screen, and when they looked, that wasn't what the screen indicated. So how could that happen? If I press, candidate A and candidate B shows up.
Well, what happened in the 2016 election, people would come in and they would vote straight party. Then they would go and they would pick a candidate from that party and vote for that candidate. And what happened was that means that the actual selection was then deselected. So the person they wanted to vote for was then deselected. And they complained that the issue was that their vote was not going to, the summary screen showed that they weren't going to get the person, the vote for the person they wanted to vote for. So we tried to duplicate the issue over and over again. We couldn't do it. We determined that the problem was the problem with the voter. Now, that problem goes away because in 2020, there is no straight party voting. So that's.
So you're saying that was more pilot error?
Excuse me?
That was more like pilot error?
Yes, sir.
Okay. And then in your experience, can an electronic ballot be manipulated once it's been cast? And how can you contrast this against the possibility of voting, manipulating or changing the paper ballot?
Well, there's no way you can, once the ballot is cast electronically, that you can adjust how that vote comes out. I mean, it is what it is. However the person voted, whatever they push that cast ballot button, that's how their vote's going to be recorded. Unlike paper, with paper, it can be changed. I mean, we don't want to have, for example, a voter walking out of the polling location with a copy of their ballot, how they voted, because that's setting up intimidation. Just like you don't have a person from the union representative they're helping them vote, or the person from their company helping them vote, assisting them, you don't want to have that information to be able to be used against you. In a paper ballot, when you have a paper ballot, it can be changed. It has been. I mean, look at at Florida. I mean, we don't want to have this reputation that Florida has. We want to make sure that every vote that was cast counts. Now, Senator, I think you misspoke a minute ago. You said that you wanted somebody to vote often. I assume you didn't mean vote early, vote often. You meant one vote per person. I'm joking.
No, I think you misheard me.
Well, I could have been. I have a hearing impediment.
I think the statement that I was quoting was what Stalin had said when he says, I don't care who votes and I don't care how often they vote, but I do care who counts the votes. And he was very accurate in what he said.
I certainly...
So that was a quote from him. But it's also the basis of our concern of where
right.
our problem.
Does anyone else have questions?
No, but anyway, the bottom line to your question is
okay,
a paper ballot can be
Mr.
manipulated.
Sargent, I think
electronically.
you've answered everyone's questions. No one has any further questions. Thank you for your input today. Ms. Menendez, Fatima Menendez?
Yes, thank you. I also have written testimony that I would like to provide, and I did mark it on my
Okay, you
chart.
can hand that to the clerk. Thank you.
Chairwoman Huffman, Vice Chair Hughes, and members of the committee, my name is Fatima Menendez, and I am a legislative attorney for MALDEF, the Mexican American Legal Defense and Educational Fund, testifying against Senate Bill 9. Since its founding in 1968, MALDEF has litigated and advocated for Latino voting rights. My testimony today will focus on specific provisions of SB 9, but we oppose the bill in its entirety. Sections 1.04 and Section 1.07 are unconstitutionally vague. The First Amendment permits certain electioneering activities like standing outside of a polling place, holding up a sign, handing out campaign cards, and asking voters to support a candidate. Because these constitutionally protected activities may cause voters to have to walk around an individual who is electioneering, SB 9's reliance on broad terms, such as impede and hinder, render these provisions unconstitutional. MALDEF is currently litigating a challenge to similarly flawed policies in Starr County and has already won preliminary relief in federal court. Again, this is not because of state law, but this is because these limitations on electioneering are unconstitutional. Section 1.07 also contains vague language authorizing certain individuals to commit voter fraud, specifically the term weakness. This language authorizes a person employed by a law enforcement agency to engage in freewheeling voter fraud outside the investigation of a specific violation of the election code. This element of Section 1.07 is unnecessary, and it will undermine both the integrity of elections as well as public confidence in the election system. MALDEF opposes Sections 2.07 and 2.08 because they are inconsistent with federal law, interfere with the sanctity of the ballot, and open the door to voter intimidation. Both of these provisions conflict with federal law on voter assistance, will slow down the voting process, and prevent voters from bringing the assister of his or her choice to the poll. MALDEF urges the committee to take into consideration the many flaws in Senate Bill 9, and we reject this bill. Thank you for your time.
Thank you. Mr. Johnson.
Yes, Ed Johnson. I'm here representing myself, and I'm against Senate Bill 9. Start with, I've had 18 years working in Harris County in the elections department, and I have never seen anybody that's been able to hack our current electronic system. This system that was used actually started before Help America Vote back in 2000 with Beverly Kaufman. She was the one that helped design the HART system, a little fallacy that was talked about earlier. It was actually designed by the company that became Semantics. So there have been hackers that have tested and proved this thing, and they set out to set a system that you could not hack, and they did a very good job of it. This was then, due to Beverly Kaufman's relationship to the president at the time, all of these rules are put forward into the national policies that have to verify how electronic voting machines work. So they are very secure, probably the securest way. Opening it up to paper ballots, you do away with the secrecy of the vote. In 2016, I saw many newspaper article reports where Hillary Clinton doubled her exit polling, got twice as many votes as she should have. In each one of those locations, they had the verifiable paper trail system. And what they did is they had someone that was a union worker standing at the scanning machine assisting the voter when they scanned the ballot. And when it wasn't correct, they went back in and had to change it. And this is in newspaper articles. You have Florida this last time in November 2018 where ballots keep showing up. If I can change an electronic vote, it's really easy to go make a copy of a piece of paper or to print more serial numbers on them. If you have an inside person that's doing this kind of stuff with the paper ballots, you know, it's a lot easier to change a piece of paper than it is to change an electronic vote.
Thank you, Mr. Johnson. Any questions? Okay, Adam Kahn, excuse me.
Hi, Adam Kahn, blog of the website Men's Musings, testifying in favor of Senate Bill 9. Honestly, every point that I wanted to make has already been made, so I'll just say this bill is awesome. It would be more awesome if Senator Hall's amendments were included in it, and I yield the rest of my time.
Thank you, Mr. Kahn. Any questions? All right, thank you very much to this panel. We appreciate your participation. Call up the next group: Karen Marshall, Sharon Armkey, Terry Harper, Lynn Foster, I'm not sure, and Mary Virginia Smith. No, as it gets later in the day, people tend to drift off, so you can have a seat. What is your name?
Karen Marshall.
You can go ahead, Miss Marshall, while we wait for the others to come up.
I'm about to lower the bar on the testimony here.
Well, we're happy to hear from you.
I've been a voter registrar since 2011, a volunteer, and I've also been a poll clerk every election up until November when I served on my county's early voting mail-in ballot board. I've registered voters at all the colleges in San Antonio, and churches and retirement homes, and every one of my neighbors as soon as they turned 18. Students are now naturally computer savvy, and senior folks are naturally leery. Both are aware digital data can be compromised. They would appreciate seeing a printed receipt, per se, created as they vote. I've personally witnessed a wide variety of registering and voting situations. Registering people who are blind and carrying the voting machine to a car at the curb of a poll are great experiences I've had. I love registering voters and enabling people to vote, but I've also witnessed demoralizing and discouraging voting situations. In Bexar County, we're blessed to have an above-par administrator and system, but I've seen people registering people as they stumbled out of a bar. I've encountered voters who are distrustful of what we, the election workers, are doing at poll computers. I've known a poll judge who got lost delivering poll equipment to the elections office after the poll closed. I've seen sweet old ladies serving as poll clerks say, "Oops," when shutting down a voting machine. So through my experiences, I've come to the definite conclusion that any assurance that an election is honest and the outcome can be trusted by everyone is a great thing. Increasing the public's trust will increase participation, and so I urge you to pass SB 9 on from the committee. Thank you.
Right, thank you very much. Let's see, now we have Sharon Armkey. Go ahead.
Yes, my name is Sharon Armkey, and I support Senate Bill 9. I'm from Dripping Springs, Texas. I'm just going to report something you probably already know. In 2016, Hays County Election Division lost 1,800 electronic ballots on a mobile ballot box, small flash memory card. We need to have paper ballots, as this young lady just mentioned, as a receipt that can be kept as a backup in case of some problem like this. We do not have small paper ballots now as a backup. It is easy to lose a small memory card, but it is very hard, I'm thinking, to lose 1,800 paper ballots. I support a paper ballot backup. I do not support paper ballot fraud by any stretch of the imagination. Let's see. We've had paper ballots in Texas in over 50 counties, and no issues on ballot secrecy have been raised, because I had been told that this was all a plot to destroy your privacy while you're voting, and Apparently, that is misinformation. This would build trust that our vote would be counted, especially in close races. And for example, in Dripping Springs, another story, we had a bond election that was very controversial recently. And out of thousands of people that voted, the result was 31 votes, or was it 37? You know, or maybe, again, there were some irregularities in how those were counted. There was a court case about it. We need to maintain the confidence of our people. My father at age 18 fought for our nation's enemies in World War II to preserve this wonderful nation. Excuse me. We should do everything possible to retain an honest voting system. This is our task, just as his task was the same. Thank you.
Thank you, Ms. Armkey. Thanks for participating today. So we have Terry Harper. Terry Harper, no answer. Lynn Foster or Fosher, I'm not sure, from Austin. Lynn. Mary Virginia Smith from Arlington. All right, then we will show they were not present. Is there anyone else who wants to testify on, for, or against Senate Bill 9? All right, we'll close public testimony and leave that pending. Okay. Members, we have two more long bills. We're going to, with lots of witnesses, so we're going to start with Senate Bill 29. We'll do what we can, and then we'll have to stop at about 20 till for session, and then we'll resume after session back in the Betty King room later. Okay, Senator Hall. What? I'm sorry. What? Senator Hughes, yes?
Bill 9, may I make one important comment? I apologize.
Senator Hall, you're recognized. Senator Hughes, you're recognized on Senate Bill 9 for a closing comment.
Thank you, Madam Chair. Just as a matter of housekeeping, there is a repealer section at the end of the bill, and there is a rare typo. I say rare not because I don't make them, but because Legislative Council rarely does. But of course, in the heat of the battle and committee subs going back and forth, so our intent is to clean this up on the floor. But so everyone's aware of it, on page 21 of the bill, line 15, it's the repealer and effective date. It repeals section 33.05C. That should be section 33.051C. And so just want to make that aware. We'll assume it should the committee see fit to pass the bill and get it to the floor, we'll fix it on the floor. Thank you, Madam Chair.
Thank you, Senator Hughes. All right, Senator Hall, you're recognized on Senate Bill 29.
Thank you, Madam Chair, and appreciate you very much allowing me to hear this bill. And thanks for the opportunity to bring this important citizens requested bill before all of us here today. This is one of the Lieutenant Governor's priorities. Taxpayer-funded lobbying is compensation to an association or an individual by political subdivision in exchange for directly or indirectly influencing the legislature or legislators. It also includes political subdivisions paying fees or dues to organizations that engage in lobbying activities against bills that are intended to protect or benefit the citizens. Taxpayer-funded lobbyists consistently oppose legislation that would shed more light on exactly how much money is spent by political subdivisions on lobbying, such as SB 445 from last session. Up to $41 million is spent annually by Texas governments on lobbying. The city of Houston spends roughly $1 million a month lobbying. The city of Austin hires lobbyists even though the city completely encompasses the state capital. And according to TEC, in my district, the city of Fate has one lobbyist for roughly every 3,000 people living in Fate. And just a few miles down 290, the city of Dripping Springs has one lobbyist for about every 1,300 citizens. And the town of Pecos City has one lobbyist for approximately every 800 people living there. And Madam Chair, I do have a committee substitute.
Senator Hall sends up the committee substitute, Senate Bill 29. You recognized?
Thank you, Madam Chair. The committee substitute for SB 29 would modify and replace the language in SB 29 as filed. By doing so, the intent for which SB 29 was originally filed would be better spelled out in the statute as follows. The committee substitute would prohibit political subdivisions from spending money or compensating in any manner to directly or indirectly influence or attempt to influence the outcome of legislation before the legislature. There is specific language to ensure that invited testimony, the ability of elected officials to influence legislation, and the ability of public employees to testify is in no way impaired. This bill would also prohibit the expenditure or compensation to an association or organization for membership fees and dues for any purpose unless specific criteria is met. One of those is that neither the organization nor the employee of the organization may directly or indirectly influence or attempt to influence the outcome of legislation pending before the legislature. Again, language is included to ensure that invited testimony and the testimony of elected officials and public employees is not impaired. The committee substitute for SB 29 would not infringe on any free speech rights. Both individuals and organizations would still have complete freedom to lobby and voice their opinions. The committee substitute for SB 29 would simply prohibit their ability to receive political subdivision funds if they are engaged in these activities. Finally, the bill will allow that a taxpayer or resident who prevails in an action against a political subdivision that violates the statutes entitled to recovery attorney's fees. And the committee said it would level the playing field between urban and rural citizens and government. The purpose of taxation is not to line the pockets of lobbyists, but rather to support the core functions of government like funding police, firemen, paying teachers, building roads, and protecting the rights of citizens. Taxpayers should not have to foot the bill for lobbying that advocates against their interests, such as cities lobbying against bills that could lead to lower taxes. This bill would also encourage more communication between elected officials, communities, and the legislature. Taxpayer-funded lobbyists often overwhelm the voices of citizens and elected officials, the very people we legislators are elected to represent. With that, Madam Chair, I'd be happy to take any questions.
All right, do we have any questions of Senator Hall from members? Okay, then we will open public testimony on Senate Bill 29, and we'll call up our first panel, Michael Openshaw, Ed Heimlich, Rick Briscoe, Don Dixon, and Terry Harper. All right, Mr. Openshaw, recognize.
Yes, my name is Mike Openshaw. I'm testifying for myself. I'm testifying in support of the bill, if my shirt tells you where I stand on this. Let's make it clear, we are not preventing cities, counties, and school districts from being able to advocate for their positions. But if they do so, they have to use the actual resources of the city, county, or school directly, and those expenses can be more closely monitored. They also have to specifically direct how that advocacy occurs, which is not happening now through third-party lobbying efforts. I'd like to compliment Senator Hall for getting that perfect piece of videotape done of literally a lobbyist admitting he's down here on, being paid by Houston taxpayers to lobby against taxpayers' interests. This just has to stop, okay? I'm down here full-time as a volunteer advocate, and I understand that cities and counties and school districts have serious interest down here, but they can be handled by their directors of government relations. That's how it should be handled, and that's how it must be handled. I don't need to be enriching, having my money indirectly making 7-digit salaries for a bunch of lobbyists.
Thank you, sir.
Any questions?
Ed Heimlich? Ed Heimlich, okay, he's not here. Rick Briscoe?
Thank you, Madam Chair, members. I am Rick Briscoe, testifying on my own behalf. I want to thank Senator Hall for bringing this bill. There may be a misconception that taxpayer-funded lobbying against the interest of taxpayers is a rare occurrence. I respectfully submit it's more common than you realize. If it's not the MPOs or the RMAs or TxDOT or the city government or school districts, they're just everywhere. And quite frankly, they can get in their car and drive here or fly from El Paso just like a citizen can. And as much as they get paid, if a $300,000 to $600,000 school district superintendent can't walk and chew gum, maybe you ought to hire another one. It's a very simple proposition. It's just not right to make the taxpayers pay for lobbyists lobbying against their interests. Thank you very much.
Thank you, sir. Don Dixon?
Thank you, Madam Chair. My name is Don Dixon. I'm representing myself, and I'm for SB 29. I come up here on my own dime, my own dollar, my own time. I'm very blessed to be able to do this and work in what I believe is better government for the people of Texas. And yet, lobbyists paid with taxpayer money, money that I paid to these entities, government entities, come and sometimes work against the interests that I come up here and testify for. I'm not a fan of the lobby class hardly at all, but I'm really not a fan of taxpayer lobbying. This has to be changed. The playing field is very uneven right now in favor of the people who have had connections, have relationships that the ordinary citizen will never be able to have. So we need this bill. We need to get rid of taxpayer funding lobbying, and I think this bill will do it.
All right, thank you. Terry Harper?
My name is Terry Harper, and I am speaking in support of this bill, first for the Republican Party of Texas. I was asked by our chairman, James Dickey, to remind y'all that the Republican Party of Texas Platform Plank 217 says, we urge the Texas Legislature to enact legislation that prohibits tax-funded contract lobbying. Speaking for myself, as an individual, little or nothing could be more wrong than taxpayer-funded lobbying. At almost every level of government, some taxing agency uses paid lobbyists to influence legislation, usually not to the benefit of the taxpayer. The average taxpayer has no idea that their money is being used this way, and municipalities and other authorities certainly don't advertise this practice, along with refusing to divulge the amount spent on lobbying. I feel confident that those who died fighting for Texas independence never considered the notion that they would be taxed to pay for the very things they were resisting against. I consider taxpayer-funded lobbying to be totally contrary to both the Texan and American way of thinking. Last week, I wrote an op-ed for a local newspaper on taxpayer-funded lobbying. I ended the piece with my feeling that taxpayer-funded lobbying is nothing more than me buying the bullets that are used to shoot me in the back. I thank you very much for your time. I encourage you to ignore the paid lobbyists and those municipal employees, police chiefs, fire chiefs, city managers, and department heads who are here to testify while on the taxpayer's payroll and expense account. I also encourage you to do what is right and push this legislation forward so that both the taxpayer and the municipalities are on the same level playing field. Lastly, I would like to add that I am here on my own dime, paying for my transportation, meals, and accommodations, along with using my time and energy that could be well spent earning an income. Thank you.
Thank you very much, sir. All right, thanks to this panel. We'll call up the next panel. Tom Glass, Crystal Main, Alan Vera, Todd Key, and Chuck DeVore. Mr. Glass, you can go ahead since you're sitting there.
Thank you. My name is Tom Glass. I'm representing myself. I'm in favor of SB 29. I think today we're talking about the disestablishment of lobbyists. Thomas Jefferson, when he was governor, fought for another type of disestablishment, the disestablishment of the Anglican Church. And in that debate, he said, To compel a man to furnish funds for the propagation of ideas he disbelieves and abhors is sinful and tyrannical. Exactly. That's exactly why we need to disestablish lobbyists, because taxpayer lobbyists often are propagating ideas we disbelieve in. Another example of the moral case word here is a quote from a Roman tyrant. I'm not sure who it was. He said, "I raise taxes to raise armies, and I raise armies to raise taxes." And then there's my favorite cartoon from Wizard of Ed, with the short king and the towering soldiers and the peasants in the sackcloths. It starts off with the soldiers coming through clubbing the peasants. Club, 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 club. You get to the last frame, they turn to the audience and say, "Another example of your taxes at work." So that's the moral case. What about the practical? I've worked in one of the best managed companies in the world for most of my career, and every year they told us in our budgets that we had to do something. We had to do more with less. They said, despite escalating cost, we need to do to have a lower budget. If we just spent $40 million that was spent by the cities and municipalities and subdivisions today, instead of spending it on lobbying, we spent it on improving productivity in our local governments. Think about how we could get more for less at our local governments. That's the kind of discipline it takes to lower taxes. Thank you.
Senator Hall, recognized.
Thank you very much. Thank you, Madam Chair. Mr. Glass.
Yes.
Do you have any idea how many lobbyists the city of Austin employs?
I do not.
10.
10 lobbyists. Okay.
The ISD?
I have no idea.
School district?
No.
While teacher pay goes lacking in Austin like others, they have 8 lobbyists.
8 lobbyists for Austin ISD.
Georgetown has 5.
Okay. Georgetown 5. Thank you.
Thank you.
All right. Crystal Maine.
My name is Crystal Maine. I am speaking on behalf of myself as well as Northeast Tarrant Tea Party, and I am very much in favor of this bill. I have been here to testify a number of different times, and it's very frustrating to sit until 3 in the morning listening to all of the lobbyists speaking against me, including ones from my town who list themselves as being from my town. And I know I have paid their salary, or a portion of their salary and their expenses to get there and testify. I don't get paid to be here, and I don't have anybody paying my salary, and it is extremely upsetting to watch my money, my taxpayer dollars at work. I think they would be much better spent paying for things that our city needs or our school districts needs, rather than to pay to lobby against us. There are many others who would be here if they could afford to take off work or had someone paying their expenses or their salary to be here. And they're not here. So I am not only representing myself, I am representing all of my neighbors who would love to be here and are not able to be here. So please remember that for each of these lobbyists who are here, myself, I am representing a whole lot of taxpayers who disagree very much with those lobbyists that are here. So thank you very much.
Thank you. Alan Vera.
Alan Vera, representing myself, testifying on SB 29. We need this. It's a great direction to take. The substitute already has 3 big holes that they're going to drive trucks through. Let's talk them real quick. The bill says will not attempt to influence the outcome of any legislation pending before the legislature. Well, months before this legislature even convened, TASA was already putting together their talking points, manufacturing their kits, sending the kits to their administrators, who could then give them to teachers to come and testify as unregistered lobbyists. They're way ahead of this. So think about how you cut that off as well, because it's our money paying for those kits. The bill says an officer or employee of the subdivision may address legislation as long as that person would not be required to register as a lobbyist. Well, who's paying the salary and travel of those people? We are. Make them come on their own time using their vacation money like we do, and not be paid by us for the time being here testifying against us. And this is the killer. The bill says a taxpayer can seek injunctive relief to the courts if the subdivision violates this law. So if the taxpayer has to shell out their own money, put it at risk to go to court, then he has to fight the lawyers paid by his tax money to oppose him, And if he succeeds in recovering his expenses, he gets his own tax money back. And what? Let's put some teeth into this. The bill should say that violations are reported to the OAG Public Integrity Unit. Personal fines, criminal or civil, are levied against the individuals in the subdivision who have violated these prohibitions. Make them pay out of their own pockets, and then you'll see this stuff stop. Thanks.
Thank you, Mr. Vera. Todd Key.
My name's Todd Key. I'm here representing myself and Northeast Tarrant Tea Party, and I'm for this bill. I would like to say thank you to Senator Hall for bringing this bill forward and to this committee for allowing us a testimony. I fully agree that no tax dollars should ever be spent to hire lobbyists to influence legislation one way or another. Normally, it's against, more often than not, it's against what I'm believing in. And I'm not going to waste a whole bunch of time, but the current situation we're in now makes about as much sense as me being a business owner and hiring somebody to sabotage my business or to promote my competitor. That's all I got to say.
Thank you, sir. And Chuck DeVore.
Madam Chairman and members of the committee, my name is Chuck DeVore with the Texas Public Policy Foundation. I'm here to testify in support of Senate Bill 29, the committee substitute for it. And let me say, as an intel officer, I'm always happy to have the Airborne Rangers lead the way on tough issues. The $41 million figure from the last legislative session, that was my original research. It took me 3 days of going into the Texas Ethics Commission filings, looking through thousands of line items to come up with an estimate of the amount of money that taxpayers spent last legislative session. It's important to note that this money does not include things like public relations, it doesn't include bill analysis, it doesn't include coalition building. So in fact, the amount of money spent on full service lobbying firms for the array of services they provide, including consulting, was probably substantially larger than the $41 million. Secondly, I think there's no better illustration of the testimony 2 weeks ago on SB 2, where, as I recall, 29 people testified against SB 2, not one of whom was an individual citizen. Every single one of those individuals who testified against it were either elected officials, staff from local governments, or lobbyists. Number three, you've heard that there's a right to free speech. I've heard that argument made in the past. Let me be very clear. The right to free speech is an individual right that attracts to individual people, to American citizens. Governments don't have rights, they have powers. Lastly, Thomas Jefferson was mentioned earlier. If you look at recent U.S. Supreme Court decisions as well, such as Janus, there's a significant issue with compelled speech that this bill addresses. And then finally, I think that you'll all be interested to know that the Texas Public Policy Foundation hired WPA to do a statewide poll of 800 registered Texas voters. We found 91% were in disagreement with taxpayer-funded lobbying.
Thank you, sir. All right. Any questions? All right. Thank you very much to this panel. Members, we're going to try to squeeze in. Senator Hall, I didn't see you. Go ahead, sir.
Just real quick, in your poll, that was a bipartisan poll, was it not?
Yes, Senator Hall. All parties significantly supported. We also oversampled both African American and Hispanic voters, and we found that among Hispanic voters, 84% disapproved of taxpayer-funded lobbying, and among African American voters in Texas, 87% disapproved of the practice.
Good. I just want to point is it's been pointed out this was in the Republican platform, and it is, but I just want people to understand this is a bipartisan issue. Lobbyists are spending all parties money equally.
Yes, sir.
Thank you, sir.
Thank you very much. All right, members, we're going to try to squeeze in one more panel just to accommodate 5 more people, but then we'll have to stop. So I'm going to try to do all 5, but if we go on too long, we won't do all 5. So Amy Hedke, Ed Johnson, Summer Wise, Karen Marshall, and Ed Johnson. And Ed Johnson, for some reason, I have your name, you're twice on that. So that's, I don't know how that happened. So we're just going to do 4. That's all we have time for anyway. must have filled them out ahead of time. All right, Amy Hedke, are you here? Amy Cumming, okay. Summer Wise?
Yes.
Why don't you get ahead and get started while she sits still? Go ahead.
Hello, everyone. My name is Summer Wise. I'm with the State Republican Executive Committee for Senate District 24. I represent myself and the Republican Party of Texas in support of SB 29. So thank you for taking the time this afternoon to hear from constituents like me on this issue. While I am a proud conservative, I live in the Bluebonnet among the Indian paintbrushes, the city of Austin. And in my 25 years here in Austin, I've been blessed with a wonderful community of friends possessing all perspectives, including many far more liberal than my own. I would like to share how SB 29 is really a bipartisan issue. Right, left, red, blue. We all pay taxes. And my liberal neighbors are strong advocates of regular working folks having a voice which is heard with the same consideration as moneyed interests. Ending taxpayer-funded lobbying ends the intrinsic institutionalized corruption that is endemic to our political process right now, and that is at its heart, a populist aspiration. So SB 29 offers us a rare opportunity to work collaboratively and cooperatively to support the grassroots from all parties. And that's all I have to say if anyone has any questions.
Thank you very much. Any questions? Okay. Karen Marshall?
Hello. This is the first time I've ever testified, and I'm doing it twice in 10 minutes.
Good job.
I am a young Republican from San Antonio, and that's where the largest political convention on earth happened last summer in 2018. And ending taxpayer-funded lobbying didn't just rate highly. It was the #1 concern of the delegates there. 97% of the delegates voted that they wanted ended. That's 7,711 of the most active voters in the state voted that this was their top priority. And it's pretty rare to get that many highly opinionated people to agree on anything, and they were all agreed on this. The practice of municipalities and school districts using our tax money to pay lobbyists who have more influence here than any ordinary citizen like us in order to win measures to get more taxes from us is diabolical and crafty and wrong. If school districts and municipalities want legislation to charge us more taxes and fees, they should have people among their own spend their own money to come and speak for themselves, like we're doing, as taxpayers. And the arguments provided against this will no doubt be sophisticated and smooth and persuasive and eloquent and circuitous and not as open as on the floor here today. But they're wrong. Please vote to pass this out of committee. And I yield the rest of my time. Thank you.
Thank you very much. Thanks. Amy Hedke?
Short and sweet, guys. It's not their money. It's our money. We need to keep their hands off of it.
All right.
That's it.
Thank you. Ed Johnson? Did you have a question, Senator Hughes? No? Okay, sorry. Go ahead. Go ahead, Ed. You're recognized.
Ed Johnson, representing myself for the bill. I compliment everything else said. It's not their money. It's our tax money being spent against us sometimes to come in a different outcome. One I'm still frustrated over is the May elections. It was all settled with all the election administrators that the even year May election in between the two primaries should be moved away, and then all of a sudden the big funded lobbyists came in and smushed it, and now we have an election in the middle of an election. So, it doesn't help the taxpayer a lot of times.
All right, thank you. Any questions? All right, thank you for this panel. Members, we're going to have to stop there so that we can get the floor cleared for a session at 3 o'clock. What we'll do is we will reconvene 10 minutes upon adjournment in the Betty King room, so we don't have to wait for them to reassemble here because we still have quite a bit of testimony, and I know people have obligations later in the evening. So we'll stand in recess until 10 minutes upon adjournment.